Patient before the regular bench when you sit in the regular bench. This is not
Your Lordship, this is a matter pertaining to
this bench.
yes.
Oh, please.
I'm facing a difficulty with a certified copy. We on when this bench was sitting,
Certified
this
copy, what can we do? We upload the orders immediately.
this is a CAB matter. It has been reserved for judgment, but we want to file a review against the.
We don't have any CAB judgments in our bench, in this bench. Sorry.
No.
Sorry. You're wrong. We don't have a single CAB judgment pending in our bench. No, you're wrong somewhere.
My lord,
Regular bench, before the regular bench. This is not the regular.
Malad, I am praying for Malad mentioning of review of your Lordship's order sitting with Justice Kumar.
Please help.
Malad, I was praying for leave to file it before the principal bench because the order is passed before the circuit bench.
Leave is granted.
Malad. And offline filing also, leave for offline filing. Malad.
Both leaves.
Do to leave them.
Grateful. Yes, Jalpaiguri.
I appear for the contemners. I appear for the review.
But there's a review application.
Contempt was filed, Lordship. Then Lordship issued notice to serve them. We had served them. In the meantime, the contemners have filed a review.
Achha.
In the meantime, my lord, it was filed before my lord. It was filed, but it was registered in the month of October.
The ground of
list of dates for the dates of.
What's the ground of review, Mr. Chaput?
My lord, first is my lord, some statutory provisions were not considered. But there is a delay, my lord, of if my lord does not oppose it of 30. It is written 50 days, but my calculation is about 35 days.
There's an application. Can
yes, my lord.
Which one? Can?
My lord, can one?
Achha. You are condoning the delay, Mr. On hearing learned counsel for the parties, we find sufficient explanation for the delay having been made out. Accordingly, can 1 of 2025 is allowed, thereby condoning the delay in filing RVW 21 of 2025. Yes, yes, Mr.
Yes, ma'am. But first of all, I'm led by Mr. Abrutush in this matter. But this
time in this
this issue is, my lord, whether my lord has held 60 days to be mandatory. Within 60 days, it has to be decided. My lord, we have my lord has considered 2 Delhi High Court judgment, other judgments. But those judgments, with deepest respect, did not lay down the law. Madam, led by Mr.
Yes, Mr.
may I tell you, Lordship, we have used a supplementary affidavit in this matter. But we would be relying on a judgment rendered by the Honorable Supreme Court. I understand the scope of review. That is what is troubling your Lordship. But the Lordship may kindly take your Lordship's judgment at paragraph 45. If I am not wrong.
45, yes.
Yes, ma'am. Kindly take paragraph 45.
Consistently held by the division benches of Delhi.
Yes. One of the judgment referred to in paragraph 45, MD Securities, your Lordship will find.
Yes.
That was only an interim order. In that matter, subsequently, an order rejecting refund was passed during the pendency of the writ petition before the division bench. Thereafter, my lord, now the matter is still pending, and the petitioners therein had taken out an application under Order 6, Rule 17. So that is not one conclusive. Secondly, my lord, perhaps an impression has been sought to be created upon your lordship that when an application for refund is not disposed of within 60 days, the refund becomes automatic. So, my lord, it is like this, my lord, the petitioners are trying to create trying to impress upon your lordship that the court may create a deeming fiction when the statute does not provide for such deeming fiction. That will be, my lord, one of our arguments with your lordship, because, my lord, in Canon India, Supreme Court, while examining the scope of review, it was arising of no judgment of a case under the Customs Act, held that, my lord, the court may also consider at the stage of review that whether any statutory provision was overlooked or even judgment was overlooked. Well, I beseech your lordship, kindly take the judgment for once. Even in the writ petition, the grounds taken in the writ petition does not even remotely suggest that when an application for refund is not disposed of within 60 days, then, my lord, the application for refund would have been deemed to have been allowed. But ground 3, ground 5 to 15, I could not find any such ground. Well, I will stand corrected by Mr. Kanoria.
Isn't it a legal error?
No, it's not a malad. I tell you, lordship, kindly take Canon India. Can I kindly take Canon India?
Then review scope will reopen the
No, malad, it will not. It will not, malad. If your lordship may allow us,
If it
Well, one
requires
circular
hearing,
has been placed.
extensive hearing, Mr. Mujumdar.
No, it not required extensive hearing. A circular has been placed before Lordship that
Yes.
the circular suggests that the refund application would be allowed if
Has to be completed within 45 days.
otherwise refund has to be allowed.
We have not said that.
Yes, your Lordship has held
We have
that.
said no. No. We have said has to be completed within 45 days in order for disbursal to be made within the mandatory
Right.
timeline. We held the timeline to be mandatory, and we held that in para 45 that the non-adherence to the timeline stipulated in the Act and the rules vitiates the entire process and disentitles the PO from claiming any deficiency in the application.
Well, I'm not claiming any deficiency. Well, the deficiency I'm not questioning. Acknowledgement has been issued. It's not at the stage of deficiency. Your Lordship has.
Where have we held that it automatically
Well, kindly
entails
take the
allowing?
order. Well, that
allowing?
is what is troubling us.
Which-
Well, that
which
is our
paragraph?
reading of the order. Well, I may stand corrected, my lord.
Which
It is-
paragraph, Mr. Mujumdar?
Kindly take, my lord, the order.
We are on our order.
Yes.
Which paragraph we have
I'm
stated that
taking note.
automatically it has to be, it's deemed to be allowed?
Yes. Kindly take, my lord. It ends that this particular issue has been dealt with. Paragraph 23
Hmm.
read with paragraph 57 to kindly take paragraph 48. My lord, we are not here questioning the other grounds. Because what is troubling us is that
Hmm.
if your lordship makes it clear that your lordship has not given any opinion or has not arrived at a conclusion that if any refund application is made and the refund application is not disposed of within 60 days, that is under section 54 5 and 7.
Mr. Mujumdar, whatever order we have passed, it is restricted to that only. We have said we are of the opinion that statutory time limit of 60 days is mandatory and non-compliance of the same vitiates any order
No, my
passed
lord,
in violation
my
there.
lord, that is what I'm on, my lord.
So we have
We-
held nothing.
My lord,
A
kindly
judgment
take,
cannot
my
be a
lord, your
precedent.
lordship, perhaps, my lord,
Judgment cannot be a precedent from what can be derived from it.
my lord, may I just indicate to your lordship, once your lordship holds that it is mandatory, then your lordship would be also holding that.
We have not held anything
No,
else.
then my lord, we have to dispose of the application within 60 days.
Maybe, Mr. Mujumdar,
Yes, my
whatever
lord.
be the consequence, but
Well,
this
the
is our
consequence, my
legal
lord, subject
opinion.
to lordship's
Yes.
kind consideration. May I just indicate to your lordship, subject to lordship's kind consideration, the statutory time limit is there in section 54(7).
We have held it to be mandatory.
My lord, the consequence flowing therefrom is in section 56. Section 56 was amended. The only consequence is that if I fail to pass an order, only interest has to be paid, as it happens in any fiscal statute.
We have not held anything else, Mr. Mujumdar. Whatever may be the legal consequence, you can argue in any subsequent matter. And it's settled, you know that very well, that a judgment can be only a precedent for what it holds,
My lord,
not what can be
so far as the
derived from it.
mandatory, so far as the mandatory issue is concerned, my lord, you will
We have held it is mandatory. That's a legal opinion. You can challenge that in appeal. That's a legal
No,
opinion.
my lord,
form.
I'm not on challenging before the appeal, my lord. Your lordship will be.
No, it's a legal error then. That is
It's
what
a legal error, my lord. That
if
is
you
what
feel
I'm
it's an
on. If your
error,
lordship
it's a
kindly
legal
take
error.
canonta though, canonta.
As in the judgment, or you are asking for a canon?
No, not canon. It's a judgment rendered by the Honorable Supreme Court. Kindly take paragraph 70. I am on paragraph 70 only.
Yes. So,
Yes, my lord. The page is, my lord, is it a GST? It is a
this is the SCC online copy.
SCC online. My lord,
It
I'm
is
so
a-
sorry, my lord. I'm having the reported version in my reported paragraph to Millman. The page 560 of the report.
70, thus the decisions.
Yes.
Yes, got it.
Thus, the decisions referred to above make it abundantly clear that when a court disposes of a case without due regard to a provision of law or its attention, or when its attention was not invited to a provision of law, it may amount to an error analogous to one apparent on the face of record, sufficient to bring the case within the purview of Order 47 Rule 1 of CPC that is there. In other words, if a court is oblivious to the relevant statutory provision, the judgment would in fact be per inquirium. In such circumstance, the judgment rendered in ignorance of the applicable law must be reviewed. But the lordship was pleased to rely on a circular or number
What
1.
provision has been overlooked?
My lord, the provision which has been overlooked, my lord, is section 56, rule 94, and my lord, the 48 GST Council meeting notes that we could not place before your lordship, which clearly indicates that the only consequence that this is basically the 60-day period is not mandatory, but it is directory, but the consequence is there. If you don't make pass the order, then obviously you have to pay interest at the rate of 6%. And that is the only consequence flowing therefrom. The judgment which has been relied on by my learned friend, two judgments, smart ad media.
Mr. Mojindo, whatever provisions were cited before us, we have dealt with.
I understand, my lord, but my lord, the
Now,
48
This is a
council.
judgment on these provisions. only.
Kindly allow me.
Open up a rehearing on this.
Don't open up, my lord. I am saying that review cannot be an appeal in disguise. But it does not require a long drawn process of reasoning. But if I am able to establish that
Certain
the
provisions
circular,
which are not cited, which are not discussed, if you re-enter into that and again
that is
it
there
will
in
be
paragraph
re-examination
60,
on law.
paragraph 60, 70 says so.
No,
Paragraph 70 says
we'll
so. My
interpret paragraph 70 also.
lord, kindly allow us, my lord, if your lordship is not,
It's not a.
my lord, kindly for once, kindly bear with me. Kindly take first paragraph 45 of your lordship's order.
Yes.
If your lordship still feels, my lord, that I am incorrect, my lord. That's a different thing.
45, yes.
Paragraph 45 of the impugned order of the judgment. Kindly take just 1 minute. It has been consistently held by the division benches of Delhi High Court in Smart Media Supra, MD Securities Supra and Gian International Supra that non-adherence to timelines stipulated in the Act and the rules vitiates the entire process and disentitles the proper officer from claiming any deficiency in the application. My case is not about deficiency at all. That's the case I want to make out before lordship. That's a stage anterior to the stage of issuing show cause as to why your refund application should not be rejected. That is stage 1. And my lord, lordship will kindly take Gian International. I have gone through Gian International. It was about, my lord, the delay in issuing deficiency memo. Smart Ad Media says that yes, you can now proceed and pass relevant order for refund. MD Securities, my lord, it was not even a final order. It was an interim order. MD Securities order no? What has happened thereafter in MD Securities? Copy the happened. And thereafter, I have got all the orders. That order 6 rule 17 application has been sought to be filed by the petitioner, which has been allowed.
What has happened?
My lord, the order has been passed.
This was an application seeking early hearing of the matter.
No, my lord, kindly take. Paragraph 4.
Yes.
Learned.
Admits that an order has been passed rejecting the
Yes, rejecting the refund.
This order is not that order.
My lord, this is continuation of that proceeding. This is the same.
There no law has been laid down. In
No,
the
no,
interim order,
subsequent, my lord, there's no, my lord, MD Securities lordship kindly takes. Judgment adao. This is a follow-up order in the same writ petition.
Yes.
Kindly take what was the order passed, NHO? Last paragraph of MD Securities.
This was the one cited before us.
Yes, it was relied on.
Last paragraph.
Last paragraph only. I am not troubling your lordship with the entirety of the order. The matter was made returnable.
Yes.
Your lordship, accordingly, it is directed. What was the direction? Accordingly, it is directed that the refund shall be processed in accordance with law, and the same shall be credited to the petitioner's account by the next date of hearing. Failing which, in terms of the scheme of CGST Act, this court would consider passing appropriate directions on the next date of hearing in respect of the refund and the rate of interest. So, what happened thereafter? List the matter on 28 May 2025. This was not a final order. Thereafter, the authorities passed an order rejecting the refund. That order is now sought to be challenged in the same writ petition. So, it has not been conclusively laid down by the Honorable Division Bench of Delhi High Court that when there is a delay in processing the refund application,
Yes.
my lord, the refund has to be allowed. And these facts, my lord, could not have been placed by my learned friend because these are subsequent event. But one thing could have been, my lord, brought to your lordship's notice that this is an interim order.
No, Mr. Mujumdar, we reject.
My lord, kindly bear with
We're
me. My
giving
lord,
up- we are born with you.
my lord, kindly take Smart Ad Media. What was held in Smart Ad
No, we will
Media?
not reopen.
My lord, kindly bear with me.
No, Mr. Learned senior counsel appearing for the review applicant submits that the order that the judgment dated July 30, 2025.
My lord, the supplementary evidence may be taken on record, my lord.
What is that?
My lord, we have annexed the 48th GST Council meeting, which, my lord, explains the circular.
This was not there before the.
My lord, it was not brought to your lordship's notice. My lord, the Supreme Court says, my lord, it can be brought to your lordship's notice.
This
What
is-
was not
What is
placed?
this? What are these?
Well,
Your meetings.
My lord, not my meeting. Under section, article,
Meetings have statutory binding effect.
my lord, this is a meeting held by GST Council, which is a constitutional authority under.
Maybe, but
article-
their meetings do not have any
My lord,
statutory
my
binding
lord,
effect.
these meetings, the decisions taken by the recommendations made by the council, the rules, the act, everything is amended on the basis of the recommendations made
No,
by the
no,
GST Council. My lord, kindly keep
we
that.
won't permit that.
My lord, kindly allow me to do that.
No. Judgment dated July 30, 2025, passed in MAT 104 of 2024, ought to be reviewed. Full stop, next para. Learned senior counsel seeks to bring on record by way of supplementary affidavit certain minutes of meetings held by the GST Council, which, it is contended, have a vital bearing on the matter. Full stop, next para. However, we are unable to permit the review applicant to bring further materials on record which were not before us at the time when the judgment under review was passed. Full stop, next para. More importantly, since, by way of the supplementary affidavits, merely minutes of the meetings of the GST Council are sought to be brought on record, which do not have any statutory binding
Well,
effect,
it is binding. Well, it is recommendation is binding, and well, that is the
not
effect.
on the court.
Well, not obviously not on the court. Cannot.
Statutory binding effect, we are of the opinion that consideration of the same, particularly within the limited scope of a review, is beyond our purview. Full stop. Accordingly, we refuse the prayer to file supplementary affidavits. Full stop. Next para. Learned senior counsel appearing for the review applicant next argues that in paragraph number 23 of the judgment under review, it was observed that subsection 7 within bracket of section 54 of the West Bengal Goods and Services Tax Act, 2017, stipulates that the proper officer, PO capital, shall issue the order under subsection 5 bracket within 60 days from the date of receipt of the application, complete in all respects. Full stop. It was further held that it is such outer limit of 60 days which was under consideration before this court. Full stop. Next para. Learned senior counsel next takes us to paragraph 45 of the judgment under review, where it was observed that it has been consistently held by the division benches of the Delhi High Court in নামগুলো para 45 টা দেখে দিয়ে Smart India, MD Securities and Gian International, that the non-adherence to the timelines stipulated in the act and the rules vitiates the entire process and disentitles the PO capse from claiming any deficiency in the application. Full stop. Next para. Learned senior counsel places reliance on a subsequent order dated August 4, 2025, passed in MD Securities Private Limited, where it was recorded that learned counsel for the respondent therein had submitted that an order had been passed rejecting the refund. Full stop. Next para. It is contended that the said rejection of refund was contrary to the proposition of MD Securities relied on by this court, passed at an interlocutory stage of the matter, and as such, was not binding in the true sense. Full stop. Next para. Learned senior counsel places reliance on such as such reported at 2025 4 SCC 509, where the Honorable Supreme Court observed that when a court disposes of a case without due regard to a provision of law, or when its attention was not invited to a provision of law, comma, it may amount to an error analogous to one apparent on the face of record, sufficient to bring the case within the purview of Order 47, Rule 1 of the Civil Procedure Code, comma, 1908. Full stop. In other words, comma, it was held, comma, if a court is oblivious to the relevant statutory provisions, comma, the judgment would in fact be per inquirium. Full stop. In such circumstances, comma, it was observed by the Honorable Supreme Court, comma, a judgment rendered in ignorance of the applicable law must be reviewed. Full stop. Next para. Learned senior counsel appearing for the review applicant argues that provisions like Section 56 of the 2017 Act, as well as Rule 94, Rule 94 of the connected rules were not considered in the judgment under review. Full stop. Next para. From a perusal of the ratio
One more submission. One more submission, with lordship kindly record. The only consequence of failure to make an order of remand within 60 days is the payment of interest, nothing more.
Learned senior counsel further argues that the only consequence of not adhering to the timeline of 60 days would be that
94 nahi consider kiya.
that what, Mr. Mojumdar? What would
Matlab,
be,
the only
would
consequence
be that
would be that the authorities would be liable to pay interest,
the authorities would be liable
pay interest on delayed payment of refund in terms of Rule 94.
to pay interest on delayed payment of refund in terms of Rule 94. Full stop. Next para. Thus, comma, the recovery itself cannot be vitiated by the timeline of 60 days having been overstepped. Full stop. Next para. Upon consideration, learned counsel for the respondent in the review applicant opposes such contentions. Full stop. Next para. Upon consideration of the proposition laid down by the Honorable Supreme Court in Commissioner of Customs versus Canon India Private Limited Supra, comma, we find that the Honorable Supreme Court observed that in cases where a provision of law or in cases where attention of the court was not drawn to a provision of law and the court was oblivious to the relevant statutory provisions, comma, the situation may amount to an error analogous to one apparent on the face of record. Full stop. Next para. However, comma, the said proposition does not lay down in mandatory terms that in all cases, comma, wherever a provision was not invited, comma, the court would reopen the entire gamut of arguments and enter into a re-examination of the law and facts of a case in the garb of a review. Full stop. Next para. Such a construction would be contrary to the well-settled line of judgments that in review, comma, the court apostrophe's jurisdiction is limited to error apparent on the face of the record, comma, discovery of new matter and grounds akin thereto. Full stop. Next para. Insofar as the present judgment under review is concerned, comma, it transpires that it was merely held that the time limit of 60 days as stipulated in section 54 within bracket 7 of the 2017 Act is mandatory and non-compliance of the same vitiates any order passed in violation thereof under section 54 within bracket 5 of the Act. Full stop. Next para. Thus, comma, the said judgment lays down a limited proposition to the extent as indicated above. Full stop. Next para. It is quite well settled that a judgment can be a precedent for what has been held in the said judgment, comma, in the facts and in the factual backgrounds of the case, comma, and not whatever propositions or legal fictions can be derived therefrom. Full stop. Next para. Proceeding on such premise, comma, we find that the provisions of section 56 were categorically considered in paragraph 44 of the judgment under review, comma, where it was observed that the said provision, comma, instead of mitigating the mandatory nature of section 54 within bracket 7, comma, highlights the same. Full stop. This court also took into consideration that the issue pertains to the depletion of the public exchequer, PE capital, in the event interest has to be paid to an individual applicant because of the negligence in adhering to the timelines on the part of the PO. Full stop. Next para. Insofar as the argument that the reliance on MD Securities Supra was incorrect, comma, insofar as the said order was passed at an interlocutory stage, comma, although findings arrived at the interlocutory stage may not be binding at the final stage of the self-same proceeding, comma, nevertheless, comma, if a proposition of law or ratio is laid down even in an interlocutory order, comma, the same has binding effect as a precedent. Full stop. Next para. Thus, comma, we cannot accept such argument. Full stop. Moreover, comma, the subsequent order passed in MD Securities Private Limited Supra handed over to us at the very second sentence records that it was passed in connection with an application seeking early hearing of the matter and merely recorded the submission of one of the counsel that an order had been passed rejecting the refund. First up, we do not find the ratio of such rejection order and or the outcome thereof. Full stop. Outcome thereafter. Full stop. Next para. Hence, comma, in view of the above observations, comma, we are of the considered opinion that this court had entered into the merits of the case, comma, both on facts and law, comma, while passing the judgment under review, and had considered all the provisions of law cited by the parties at length, comma, which is explicit from the judgment itself. Full stop. Thus, comma, in the garb of a review, comma, we cannot permit a re-argument on the merits of the case, comma, by taking into consideration other provisions as well as the real within double inverted real connotation of the provisions which were already considered by us. Full stop. Next para. Accordingly, comma, we are of the opinion that no that the present case does not come within the ambit of Order 47, Rule 1 of the Code of Civil Procedure. Full stop. Accordingly, RVW 21 of 2025 is dismissed on contest without comma, however, comma, any order is to cost.
Well, grateful, my lord, my purpose is served.
Achha, what about the contempt? Your purpose, don't
The
escape.
contempt, my lord, I have not been briefed.
Yes,
That
Mr.
Mr. Chakraborty will deal.
Choose your prison.
Well, rule has not been. Well, rule.
Oh, we are mitigating that grievance of yours.
No, may give us some chance.
Can 2 of 2025
Is
is
still-
accordingly disposed of as well.
Well, give us some chance. Well, give us.
Very well. Since
It's a proposition of
next
law, well, we.
since we are giving them some time. Since learned counsel,
August, Lordship, 30th July, 1 month your Lordship had given, and Lordship had recorded with interest. 56 was dealt with your Lordships at para 72.
yes, reserve that for the challenge to this.
Lordship, the refund is of 1920. Long time.
1920.
Lordship,
Learned,
period has been passed.
it is submitted on behalf of the alleged contemner, comma, after passing of the above order, comma, that the alleged contemner seeks to challenge the order rejecting the review, dismissing the review application before a superior forum, full stop. Accordingly, comma, for the sake of propriety, judicial propriety, comma, we grant 4 weeks time to the 4 working weeks time to the alleged contemner to comply with the order of this court and to await the outcome of any challenge, comma, if preferred, against the order dismissing the review application today. Full stop. Next para. The contempt application shall next be listed on, today we are on 8th. So we'll make it on a Friday so that this bench is not broken. So we'll make it 4 weeks after it has to be. So 4 working weeks means January. We'll keep it on January 16th. On January 16, 2026.
Well, may we get back the certified copy because both has to be. only certified copy by replacing it.
No, we have decided on merits.
Oh,
If we gave
No, no,
liberty to take back, then we could.
No.
This is a court of records. We have
no,
to
no,
keep it.
I tender apology.
Yes.
Act দেখুন। Yes. Rule was issued. What was the allegation?
Was issued on the last occasion. Direction was production of the alleged contemner by police. I understand, my lord, he has been taken to court today.
Arrest was not clarified. So therefore, department.
But
was-
I understand, I met the police officer. I understand he has been brought. He has been brought to court pursuant to
Let him be brought. What was the allegation?
allegation. My lord's direction was for payment of areas in 6 installments and 10,000 rupees per month as alimony pendilite, and my lord 20,000 towards litigation cost. I understand after passing of the order, application was made.
Officer, you have brought the contemner?
Yes.
Yes. Yes, please continue, sir.
My lord, only my lord direction was like that. I understand from the date of passing of the order by your lordship, only 30,000 at one point of time and 10,000.
Where is the contemner? Bring him before the court.
আপনাকে সামনে আসছি।
টাকাটা দেননি কেন?
টাকাটা দিয়েছি,
না দেননি পুরোটা।
আমি 10,000 টাকা দিই।
তাহলে আপনাকে কন্টেম্পটা আমরা রুল ইস্যু করেছিলাম, আপনি আসেননি কেন প্রথমবারে? ওয়ারেন্ট অফ অ্যারেস্ট ইস্যু করতে হচ্ছে, পুলিশকে ট্রাভেল দিতে হয়েছে।
ওটা আমার ওই দিয়ে দিয়েছি,
হ্যাঁ,
আমি দিয়েছি 10,000 টাকা।
আপনাকে যখন রুল ইস্যু করা হয়েছিল কন্টেম্পটের, আপনি হাজির হননি কেন কোর্টে?
ও হ্যাঁ, আমি তো হাজির হয়নি। আচ্ছা, আমি খেয়াল।
Is anybody representing him?
Earlier one, my lord friend.
So why are you sitting back? You come up forward. So has he any assets?
Only building. Not I tell you, lordship. Lord, there is a two-storied building. My instruction is, Lord, there are 3 rooms in each story.
In contempt, you cannot attach. You
Yeah,
can only
that's
send him
it.
to prison. We'll send him to prison since he has not complied.
My lord,
If that suits you,
willful violation, my lord's report.
we'll send him
is
to prison. No difficulty.
My lord, that your lordship will consider, my lord, that will not serve the petitioner's purpose.
You have
Did
filed
you-
a contempt application.
Of course.
In contempt, you cannot pass
And
him
my
further order.
specific
This
prayer
not
is that.
execution.
My specific prayer is
He
that.
cannot pay fine since he is not paying alimony. He has to go to jail then. What can be done?
My lord, I had a suggestion. Now, your
You
lordship.
levy execution separately for attachment of his property.
Yes.
Do that. We'll give
That's
you that
it.
liberty.
Yes, yes.
But for contempt, he has to go to
Yes,
jail.
of course. Yes.
What was the order? Let us see the order first.
My lord, the order is of contempt in. My lord, that is in the contempt application, my lord, the order dated. I give your lordship the order. Yes, the order at page 14 of the contempt application. And the relevant
That is
paragraph,
paragraph 9. 9 and 10.
Yes, 9 and 10. Litigation cost not paid. Up till now, my lord, only in aggregate 50,000 has been paid. No area.
The arrears of alimony calculated at the rate of 10,000 has not been paid.
Yes,
By
not been,
6, not a single installment.
not a single installment.
He says he has paid 10,000.
Per month, per month. Next year, lordship has said,
He has paid one installment then.
no, he has 30,000 at one point of time and 10,000. Aggregating
So
to
6
50,
equal monthly installments, what does that come to?
that has not been paid.
And also these litigation costs have not been paid.
Litigation cost not paid.
Yes, sir. We'll direct him to be taken to custody and sent him to prison right now.
Only can see the pasu. He has no money. Only pension malad 22,000 to 20,000.
There's an order of the court. You could have filed a review. You could have challenged before some forum with legal aid. You have several remedies. He has no money, is no defense in a contempt.
Pension malad.
And we issued a rule. He did not appear in court.
Yes.
So he's in double contempt, actually.
That's why I am not.
No, you may appear for him. No difficulty. You are not in contempt.
My last occasion, malad, 6 months switch off. Now I asked him.
No, he's deliberately doing it. Some people should learn.
He's totally.
The greatest humility, my lord. In earlier
Confusion
occasion
will be
also-
cleared right now. He'll get time to ponder on it by himself in prison.
In earlier occasion also, my lord, a coordinate division bench of this honorable court, my lord, for the same reason, because of his non-appearance, directed the police to bring him to court. This is the second occasion.
The contemner has been personally brought to court by the concerned police authorities as per the warrant of arrest issued by this court in terms of a rule previously issued for contempt of court by way of willful and deliberate violation of the order dated April 8, 2025, passed in IA number CAN 2 of 2019, within bracket old number CAN 6346 of 2019, in connection with FAT 299 of 2019, whereby the contemner was directed inter alia to pay current alimony at the rate of 10,000 per month starting from April 2025, full stop. Arrears of alimony, calculated at the rate of rupees 10,000, from July 2019 till March 2025, was also directed to be paid to the appellant wife by the respondent husband, within bracket contemner, bracket close, by 6 equal monthly installments, payable by the end of each month. Full stop. The first of such installments was to be paid by April 30, 2025, and thereafter by the end of each succeeding month. Full stop. Over and above the aforesaid amounts, the respondent husband, bracket a contemner, was also directed to pay to the appellant stroke wife litigation costs of rupees 20,000 within May 31, 2025. Full stop. Next para. However, despite such direction, the contemner himself admits before us that only a paltry sum of rupees 10,000 has been paid by him. Full stop. Next para. Moreover, in
No,
gross defiance,
Not 10,000,
50,000
50,000 in aggregate.
50,000 in aggregate has been paid by him. Full stop. Next para. Moreover, in gross defiance of the rule issued by us in connection with the contempt application, the contemner avoided to appear before this court on the returnable date, due to which we were compelled to issue a warrant of arrest for the contemner to be brought personally to court. Next para, learned counsel for the petitioner submits that for such similar recalcitrant attitude on the part of the contemner on a previous occasion, a coordinate bench had also to direct production of the contemner in court by issuance of warrant of arrest. Next para, thus, the defiance of the order of this court by the contemner is palpable and willful. Next para, we do not see any mitigating circumstance, since in the event the contemner was aggrieved with the order passed by this court, several avenues were open before the contemner, either to file a review application or to go up in challenge before a superior forum, if financially indigent, through legal aid services. Next para, however, the contemner having not done so on the one hand, and on the other, having deliberately and willfully flouted the directions of this court, no option is left to the court but to penalize the contemner for such deliberate defiance of the order of this court. Full stop. Accordingly, the contemner be taken to custody immediately and be put behind the bars full stop, the contemner shall remain in incarceration for a period of 1 month from date. Full stop. The rule is accordingly disposed of in the light of the rule being CRC 21 of 2025 is accordingly disposed of in the light of the above observations. Full stop. Next para, it is made clear that nothing in the above order shall prevent the appellant wife to have the order dated April 8, 2025 implemented through execution by due process of law uh, in accordance with the provisions of law available in that regard. Please take him to custody and put him in prison.
Lord, I'm sorry, my Lord. I personally express my sorrow for this old man to be taken to custody. However, my Lord, only one thing, my Lord, in earlier occasion, my Lord, legal aid was given by a coordinate division bench.
Do you think our nerves are of steel? We also have our moments, but we cannot do that in court. Yes, call on the next one.
My Lord, I'm good.
Yes.
So this is the part matter. Now, Lordship, the
Part
railway-
matter, Mr. Mukherjee will fix on another day because the difficulties, this was suddenly fixed, this bench was fixed because there were several matters.
Now, last occasion, subject to your Lordship's consideration, your Lordships express the view.
It's appearing before her, us as part matter.
Yeah.
Then we'll cancel it, please, before the regular.
Yes, Lordship has expressed the view that let the part be cancelled and
Yes, yes, right.
but Lordship, today, Lordship, we received a copy of the application under Order 40 and Rule 27 filed by the state authorities.
That we said they will be moved before the regular forum. We will release the matter. We'll say it. Otherwise, this bench will. It's not workable. Yes. The matter was heard in part by this bench. Full stop. However, comma, since the composition of the bench has changed in the meantime, comma, it would be unworkable for both parties if the part heard marking of the matter is retained indefinitely, comma, since it is uncertain as to when this bench, comma, in its present composition, comma, can sit next for a lengthy period of time to dispose of the matter. Full stop. Accordingly, the part heard marking of the matter be cancelled. Full stop. Liberty is given. Let the matter go out of the list with liberty to the parties to mention for enlistment before the appropriate bench having regular determination. Thank you.
And Lordship, the liberty to file an objection against this application.
Whatever we asked before the regular bench, we are cancelling the part heard. You prepare that and give them a copy beforehand so that you can take the leave and file on the next day. Yes.
Item number 3.
At my instance,
Yes, sir.
the contempt of your Lordship's order dated 16th of June 2025. Lord, if I may just file a
Contempt application is
supplementary
applied for the first time.
No, Lord, your Lordship has passed an order in this supplementary now. If I may just file a supplementary affidavit, Lord, your Lordship has found it to be prima facie in contempt. If I may just file this.
Have the copy of the main application.
We've served everything. Your Lordship looks at page 9.
No, where is the affidavit of service?
Affidavit of service.
Lordship, my senior is coming within a few minutes.
We are grateful for that.
Affidavit of service. Lord, kindly have a look at page 9 of the supplementary affidavit. This is your Lordship's order of 7th of August 2025 in the contempt. Page 5, if your Lordship looks at, there's a prima facie recording of, a recording of a prima facie satisfaction of contempt. So the supplementary is to just further highlight. If your Lordship looks at page 29.
Given a copy of the supplementary to them?
No,
We'll give a copy
actually
to him
they
and
never
we'll
appeared.
take it up on the next occasion.
Affidavit of service. This is the affidavit of service, not showing that your Lordship's order of. And another affidavit of service showing 7th August has been.
On the prayer of learned counsel appearing for the petitioner, comma, we permit the petitioner to file a supplementary affidavit,
Service order,
comma, which is kept on record. Full stop. A copy thereof be served on the learned advocate appearing today on behalf of the alleged contemner. Full stop. The matter shall next be listed on আগেরটা কবে 16 এক listed on January 16, 2025.
I'm sorry for my interjection, but please have a look at the supplementary. Otherwise, I would not have done this. Please have a look at it once. Please have a look at page 29F. Your Lordship's injunction was restraining him from circulating these defamatory materials. But even as on November 3rd, 2025, he called Exide and my CEO as a thief, and he's circulating it. And if your Lordship looks at page 33, he's done an AI morphed version of my CEO, showing him.
Sir, Banerjee, we can.
But I was praying for issuance of rule today. Milord, I have served on him. He has received it. This is an aggravated contempt now.
Yes, what do you say?
Lordship, let my senior come.
We won't wait for his senior. Sorry, it's a contempt matter. 10:30 fixed.
Lordship, can I request for a passover?
We're refusing that. What is the explanation for this? Who is your senior?
Sir, Arnab Datta, sir.
Who?
Arnab Datta.
Where is he?
He's written to Hindu, E-Putrika, Times Group, Hindustan Times. Everywhere Exide has stolen, despite your Lordship's order. And on the other hand, he's writing letters to my advocate on record saying, please settle the matters.
You understand, but see, your learned friend will be in some embarrassment if you pass a issue a rule like now. We cannot put it before that because we are not being able to sit together. There are other compulsions.
Lord, I understand, my Lord, but I am in great difficulty here. He's issuing suicide letters to me. I've annexed that in the supplementary, saying I'll show that to
From
your
the
Lordship.
police for that.
That is my can. 29G.
No, we are passing it over. Short pass.
Grateful, my Lord.
যেটা অর্ডার লিখলাম তার সঙ্গে অ্যাড হবে যদি কেউ আসে অন্য কেউ তাহলে বলে দিতে শর্ট পাস ওভার ইনফর্ম হিম ইন 5 minutes if he does not come we'll issue rule একজন নামাচ্ছে আর একজন দাও তুমি বসে আছো ওখানে বেঞ্চে বুঝতে পারছি না
Would I appear for the petitioners?
Yes,
This is in this matter, your Lordship had directed. This was taken up on the earlier occasion. My Lord had been pleased to direct service. The affidavit of service is there. One of the respondent contemners has refused to accept service. The others, but I don't know whom they are representing. Now, my Lord, this is a slightly unusual case where the person who has obtained or successfully obtained an order or secured an order of status quo over a premises in question is violating the self-same order. The order of status quo was obtained before the trial court, my Lord, being the city civil court. We came up in appeal. My lords were pleased to confirm the order of status quo, directing parties to status quo, but modifying that order to the extent that I would have, that is the association of the building, would have access to the roof right for specified use. Now, my lord, that order of status quo implied that the plaintiff in the court below would also maintain status quo, because that is the parties would maintain status quo.
What is the order?
Kindly have the order. My lord's order is at page.
So give us the paragraph of the order because the copy is there.
Page paragraph 29 of the order.
56. Parties, yes. Both parties.
Yes. Page 9, para 29.
Both
parties would maintain status quo.
So what are they doing exactly?
Now, my lord, the premises in question, according to their lease deed, now they claim to be lessee, or rather sub-lessee. Premises in question under the sublease is to be used for residential and commercial purposes. Commercial purpose being business of office appliances. That is the case which is made out in the plaint also. Now it is being used for religious congregations of a particular community and for performing religious practices of a particular community.
We said that we gave a rider that
I would have limited
temporary.
Yes, so because I am the association. Now I have a room in the roof, which is the association office room.
So temporary ingress egress was there.
Temporary ingress egress, that is being interfered with also, because that is being interfered, but that can be dealt with because
ingress egress was given to them.
To me. To the association. At my instance, I am the appellant.
Right.
I am the appellant. So temporary, he claims to be the sublessee of the roof. The roof has, my lord, common installations. The roof had, my lord, Airtel towers, etc. Which
otherwise they are in possession of the association by default is in possession of that.
Association by default is in possession.
So what is the contempt, Mr. Thakur?
No, my lord, contempt is that the plaintiff who obtains an order of status quo for
Yes.
that is to permit her to use the demise premises
That
according
is for nature, character, and possession.
nature character.
So holding a religious congregation is not possession being handed over.
No,
or
my lord,
nature and character.
office being established of a religious dispensation, marriage bureau being opened of a religious dispensation, religious practices carrying out on the
Construction has been made there.
no office has been opened. They've been permitted to use the place for holding, my lord, religious congregations.
No, that's not a regular. I mean,
Regular
it's
basis.
a one of each
No,
on each
regular,
case.
regular. Three
Has been
instances.
given over to handed over to them. The
The
position.
nameplates have been fixed.
By third party.
Nameplates have been fixed by the particular dispensation that is there.
Yes. What would?
Kindly see the nameplate once, please. Madam.
900.
Page 900, volume 7. Kindly have volume 7.
ये volume 7.
Page?
Page 900, please, my lord. My lord, the residents of that building. Kindly come to page 900, please. 899. 899 onwards.
This Mr. Razaul Khan director is a different.
Is a different. Kindly see the name of the appellant. It's one Miss
Kanchan Jyoti.
Kanchan Jyoti.
These two were never in the property.
Jyoti Kanchan Rao is there at the site.
Yes. That is there at the site. Now that is below Jyoti Kanchan Rao, director. Now kindly see who is the nomination here. Kindly see the page 900 now, which is the blow up of that.
And where is
Mohammad Rezaul Khan?
Page 909 is the main gate. Or what?
At the rooftop, at the entrance of the premises.
Yes, what do you say?
No, my lord, kindly see two more things, my lord.
Yes.
Now, this official purpose and residential purpose, my lord, cannot possibly be for carrying out religious activities and congregations of a particular denomination.
06, what is this, red?
That is the, my lord, after the sacrifice. Yes, after the sacrifice.
Yeah.
This is after the sacrifice. Well, can't be human sacrifice, for God's sake.
Maybe. We don't. We never know.
No, we are not that bad in India right now.
We never.
So, my lord, this is the position.
So yes, what do you say?
No, madam, so far, Lordship will straight away come to the pictures.
Yes, you've got a complete picture.
Now, so far, page 900 is concerned.
Who is this person? It's handing over possession, Mr.
Lordship,
My lord, and my one thing, this is a subsequent event.
No.
The weekly.
We understood. We
Weekly
understood.
prayer meets.
This
is subsequent, my lord, these were not on record because this is subsequent after
Yes.
the filing.
What do you say? What do you say? What is your answer?
First is,
Somebody else has been given possession.
not at all. There are
His board is there.
10 letters by which are not annexed to the writ contempt application, which have exchanged between the parties.
All letters.
Prior,
Could you explain page 899? This name of this gentleman.
I'll just tell you, page
899.
899.
Yes.
899, it records my name.
That your name was there.
Jyoti Kanchan Rao, and the small one is at page
899, Mr. Razaul Khan.
Yes.
Yes, Mr.
Who is he?
The authorized signatory. It's mentioned over here. But I cannot be.
Not mentioned.
901, my learned friend will perhaps.
899, it says Muhammad Razaul Khan, Director, Qazi Muhammad Faizullah Ansari, General Secretary, some
Kindly see 901, their designation. Kindly see 901, they are running a marriage bureau. Government
Yes,
Muslim.
901 also.
Well, the
And
copy
the
given-
name there is
the
there.
copy given to me, so for page 899 is concerned, the left hand side, Lordship is looking at.
You please show from your copy, Mr.
I will show
Thakkar.
the-
Don't want to waste time on this.
901 ta khule do, better print because I
We'll issue a rule, put in a show cause. It's clear contempt.
this is the blow up. This is the sideboard to Mohammad Rezaul Khan.
Mohammad Rezaul Khan, which is
And then kindly see 901, my lord, he
He's
runs
not
a marriage
anybody of the
bureau.
association. He's a general secretary of some acronym which you don't
Yeah.
understand.
so today
Government Muslim Marriage and Qazi Welfare
when the
Association.
complaint was met, we gave a reply letter. By said for one day, the marriage took place. For one day, and it was under my supervision.
We'll issue a rule. This
But
clear,
it was under me.
clear
It
contempt.
was under my supervision, under me. May I file a opposition annexing all
We'll
documents?
issue a rule. You
He's
show.
admitted
The
contempt.
only difficulty is, my lord, today, these facts which are complained of, we have given a reply. Whether it's handing over possession by a notice board, by a nameplate which is fixed over there, whether it is handing over possession, or for one day, because I have a right, I have a sublessee, I have a right to use. Even today, I am in possession. Today, I is not my residential place, my lord. I have
Learned counsel for the petitioner, learned senior counsel appearing for the petitioner submits that
nature and character है तो क्यों है? Nature, character.
in
now another thing.
Paragraph
The
29.
appellant is not a society. Please kindly listen. The appellant before lordship by the order is only a human being, Mr. Sudeep
But
Chitlangia.
he was the resident
So
of the society.
Mr. Chitlangia was given the right, whatever constructions in the roof belongs to him. The air conditioned plant,
That is part of the appeal.
the other installations. is
one
not
second,
mine.
one second.
Lordship,
He was the named appellant.
No, no.
He is the person who
No, no,
filed
no,
the
no.
petition.
There were the others. He was the only appellant,
no.
Sudeep Chitlangia. The
The
association
alleged
was not the
containers, Kanchanjyoti Rao and others, the association.
That is the other is not the association.
What is the
Kindly
designation
see
of
page 889, please.
what is the designation of Kanchanjyoti?
Kanchanjyoti Rao is a sub-lessee. Kanchanjyoti Rao is
So
a sub-lessee.
according to you, who is violating?
My lord, Kanchan Jyoti Rao and the third parties who are acting in violation. Kanchan Jyoti and third party who have knowledge of this order, they are acting in violation. Because the billboard there brings attention to your lordship's order. Kindly see the two notices.
today
there.
the access
I
to
don't
the
know whom
roof-
my learned friend is appearing. First, let us be clear on that. Whom does he represent?
For all the content. Lordship, the last order.
The matter is, he's appearing for all the
Lordship, the
contemnants.
last order, my lord, the order, my lord's order of 18th of June. My lord's order of 18th of June records Sudeep Chitlangia is the appellant and the respondent
Do you
is,
deny that Sudeep Chitlangia has handed over possession to this person?
they allege that I have handed over the
You means
Contemner number one.
They allege
Kanchanjyoti.
Kanchanjyoti has given up possession, a part of
Your
the-
name is there. His name is there. You don't know about this.
No,
It's-
I know. He's my staff. He's my staff. I know.
Rizal Khan is your staff.
Yes. Rizaul Khan is my
Will
staff.
right now
Under
give the
me.
reason and issue a rule.
He's under me. It's not that I've handed over
Senior counsel
possession.
appearing for the petitioner
There are letters by which I said that he's under me.
submits that in gross violation of the judgment dated
18 June 20.
June 18, 2025, passed in Can 1 of 2025, passed in FMAT 208 of 2025, along with Can 1 of 2025, comma, whereby the parties were directed to maintain status quo with regard to the nature and character and stroke or possession of the suit property, comma, with a rider that the defendant stroke appellant and his men and agents might have limited and temporary ingress and egress, comma. The alleged contemners have inducted third parties to the suit premises, comma, thereby violating the status quo with regard to the same. Full stop. Learned senior counsel places particular reliance on the photographs annexed at page 899 and 901, from which it is evident that one Muhammad Razaul Khan, comma, describing himself as the director of an unidentified body, and one Qazi MD Muhammad Faizullah H. Ansari, comma, describing himself to be the General Secretary of GMMDKW, comma, have put up their signboards on the roof of the entrance to the roof of this, beside the entrance to the roof of the suit property. Full stop. Next para. The acronym indicated above is further elaborated at page 901, which is a photograph of a signboard affixed at the gate of the roof, comma, which describes that the Government Muslim Marriage and Qazi Welfare Association is running from the said property. Full stop. Next para. Learned counsel appearing for the alleged contemners seeks to impress upon the court that the said persons are licensees under the alleged contemner
Number one.
number 1. Full stop. Next para.
Licensee, my lord.
Not licensee.
Not licensee.
Then what are
They're
they?
my authorized person, my lord. This
Your
is-
authorized person.
Yes.
Licensee বদলে the authorized person, double inverted মধ্যে authorized person of the
working under
alleged
me.
container number 1. Full stop. Next para.
I've not given up position.
However, comma, it is palpably evident from the photographs that signboards of the said persons have been affixed permanently, comma, also declaring that the property was being used by the Government Muslim Marriage and Qazi Welfare Association as its office. Full stop. Next para. This is contrary to the submission made on behalf of the alleged containers that those persons are merely double inverted with the authorized agents of the alleged container number 1 within bracket whatever that means. Bracket closed. Full stop. Thus, comma, being satisfied prima facie that there has been a deliberate and willful violation of the order of this court dated such and such যেটা বললাম by way of violating the status quo ওটা যে ডেটটা হচ্ছে জুন 1820 violating the status quo as regards possession by inducting third parties to the property in question comma a rule do issue calling upon the alleged contemners to show cause as to why penal action as prayed for in the contempt application shall not be taken against the alleged contemners. Full stop. The rule is made returnable on January 16, 2025 when the alleged contemners shall file their show cause with an advance copy to the learned advocate on record for the petition.
May I file the affidavits of service?
Yes.
5 has not
Affidavit
accepted
of service
service.
filed to the
5 has not accepted, but he is appearing for all, he said.
I appeal for all. Only one thing, my submission that this notice board which Lordship has recorded has been permanently fixed. It was there for 2 days and
Put it show cause.
Grateful, my lord.
Pass over.
He had appeared in the wrong matter, my lord. He was not for item number 3.
Pass over to
Item number 3.
Yes, Mr. Datta.
But my junior made a mistake.
Oh, sir. Mr. Datta is also not there.
Nobody is there.
What was the contempt you said?
The supplementary affidavit, your lordship will have a look at 16 June order at page 9. 7th August 2025. Prima facie, your lordships have found him to be in contempt. We were directed to serve at page 10, paragraph 6.
Yes.
We've served, my lord. And despite that, he...
Affidavit of service you're filing?
Yes, my lord, we filed.
Affidavits of service filed to be kept on record. So despite service, none appears for the alleged contemner. For sub next para, we had recorded in our order dated August 7, 2025 that in gross violation of the order dated June 16, 2025, passed in Can 1 of 2021, comma, in connection with FMAT 190 of 2025, comma, restraining the alleged contemner from threatening, comma, publishing or circulating any article or issue any statement to the appellant stroke petitioner and stroke or to any third party either through emails, comma, social media, comma, etc. containing words similar to the ones used in the letters annexed at Annexure G to the plaint filed in title suit number 639 of 2025, as well as other similar communication affecting designed to injure the business and goodwill of the appellant, comma, the alleged contemner has persisted in making derogatory, in using derogatory and abusive language, sending offensive emails to the petitioner as well as all and sundry, comma, including various authorities. Full stop. Accordingly, since the alleged contemner chooses to abstain from hearing before the court today, comma, a rule of contempt to issue calling upon the alleged contemner to show cause as to why the alleged contemner should not be penalized in terms of the prayers made in the contempt application. Full stop. The rule is made returnable on January 16, 2025, when the alleged contemner shall be personally present in court, as well as file his show cause, comma, if any, comma, with an advance copy to the learned advocate on record for the petition.
Very grateful.
Great. Thank you. Dipankar Dak.
5, my lord, I appear on behalf of the wife, my lord. It's an application for contempt, my lord, appearing for the first time.
What is the contempt?
My lord, kindly, my lord, comes to your lordship's order at page 19. My lord, page 22 is the operating part, my lord.
Which page is the operating on? Sorry.
Page 22, Milord, para 12 onwards. Accordingly, can 2 of 2023 is partially allowed on contest, thereby directing the appellant husband to.
Not paid anything?
Milord, they are paying Milord 20,000 and 40,000, Milord. Your Lordship's direction was to pay Milord.
A prima facie case of contempt has been made out inasmuch as the alleged contemner stroke husband, comma, in violation of the order dated April 1, 2025, passed in FAT 250 of 2019, comma, has not been paying the entire amount of alimony and litigation costs as directed thereby to the petitioner stroke wife, full stop. Hence, comma, the petitioner shall serve a copy of the contempt application on the alleged contemner, indicating that the application shall next be listed for hearing on January 16, 2025, when an affidavit of service shall be filed by the petitioner.
Milord, only one thing, Milord, arrears has also been not paid.
No, as per directions we have said, so generally. আচ্ছা ও যেখানে বললাম না has not been paying including litigation costs and arrears. Thank you. Next.
Item number 6.
Yes, what is your
contempt application? Your Lordship's order as page 17, paragraph 15, directed 30,000 per month from November 2024.
You're appearing?
Milord, my application also, Milord, seeking the contempt notice was refused, and he's appearing without.
Yes.
Milord, there is an application filed by us seeking modifications of the order.
After getting the review, contempt
From
application?
June, no. Yes, stop
Milord,
paying.
that is the review application.
But there is no, not review, Milord. Modifications of the order.
That is appearing today?
Yes, Milord. Can 3.
Let us hear that first.
Milord, we say, Milord, there
They have given a copy to them, must have.
Can copy to us? It is Can 3? Yes, my copy is also there. Now, Milord, so far as asked, Milord, we
Can
say-
3, can 3.
Can 3.
Can 3 ta konta?
Milord, so far as my
He has
instruction is that-
resigned and so he's wanting
I
the
do not know whether the contempt application was refused or not. Milord, if my learned friend says it's refused, Milord, definitely, Milord, he says correctly.
No, no, the endorsements.
Now, Milord, my instruction is we have not yet received, but so far as we filed an application Can 3, we, Milord, seek, Milord, certain modification on the ground of changed circumstances. And
Can
Milord,
3 ta kothay? And the modification application filed respectively between each other during the course of the day. Full stop. Affidavits in opposition thereto filed respectively by the parties shall be affirmed within January 2, 2026. Full stop. Reply, if any, shall be filed on the return shall be filed within January 9, 2026. Full stop. The applications shall be listed together for hearing on January 16, 2026.
Milord, one in that is-
Yes, what?
So for the modification, he is already received. Content, Milord, maybe.
আচ্ছা যেখানে বললাম sub সেখানে if not already sub.
As super second point is concerned, my Lord, direct us to file by on 2nd. Well, there's a truncated day, maybe on 5th.
File it before that.
Milord, before this winter vacation, Milord, second, kindly.
File it before the winter vacation. You have sufficient time. We are on 8th. You have got more than 2 weeks.
I beg you.
One in my Lord, good, but in the order is in force. My Lord, he has stopped paying. My Lord.
We have already passed an order. We can now only send him to jail. What else can we do? Next.
Item number 7.
Extremely.
This
Yes.
is a review application.
Yes, Mr. Chatterjee.
Lord,
The problem is, my lord, see, I know the limitations of a review thing, my lord.
What, order 41 rule 11 dismissal?
Yes.
Review of that?
Yes.
Dismissed. File another review.
But I feel, my lord, your lordship would be in a position, my lord, to.
Quickly, what is the point?
The point is, my lord, is kind of see the plaint ones.
Let us first see the order. Order.
My lord's order is, my lord, that your lordship did not want to, my lord, get into the entire situation. My lord, if your lordship sees, limitation and then physical possession and things like that. I am not even getting your, this was not even the point. The point was very different. The point was, my lord, he has prayed for a certain share in the property. But in the plaint, my lord, he has said that he owns the entire property. The
suit was for what?
Suit was for declaration of a title to the property. And the schedule was the entire property.
That was decreed.
That was decreed. The appellate court, my lord, reduced it. Whatever we were praying, the appellate court granted that, but not reflected in the degree. This was the point. And this, my lord, in my respectful submission, my lord, was probably overlooked. That's my only point before your lordship. I'll show your lordship, my lord, from the two judgments. If your lordship takes up, just
let us read the order first.
My lord, because that order, my lord, doesn't go into the merits at all. So I don't think. Plaint bar koro, duto copy of the plaint. To do prayer portion, dar kichhu na.
Take it up on 16th.
Very.
It will take some time because
I'll take 10 minutes.
Single judge is waiting. So
very well.
Let the matter.
May I serve on Mr. Tanmay Mukherjee because he had appeared at the time of admission.
Do that. Do that. A copy of the application be served on the learned counsel appearing for the respondent in the appeal at the initial stage, and receipt in that regard be filed on the next on the returnable date. Full stop. The matter shall next be listed under the same heading on January 16, 2026. Please come back. Next. এগুলো বড় ম্যাটার গুলো নেবো না
I am for the petitioner. Review application.
Last direction, my affidavit in opposition to their condonation I'm filing. A reply has also been served upon me.
It's in reply.
What is the delay?
Delay, lordship has 61 days delay.
How many?
61 days delay.
I'm opposing that, Malaj, because the sufficient cause demonstrated. Malaj, I have submissions to make in that regard. Let them place them as application. I'll make my submissions.
Yes. What is the delay? Reason for the delay?
Delay, eventual lordship. Lordship, paragraph number 10, eventual lordship, that after granting the divorce in the said appeal being fact number FAT number.
Paragraph 10 of the can.
Paragraph 10 of the section 5 application, eventual lordship, can number 2 most probably.
Can 2 watch. Can 2 কোনটা?
Para 10, eventual lordship.
ছেড়ে যাচ্ছে ইয়েগুলো সাবধানে রাখতে হবে। Para 10 years.
After granting divorce in the said appeal being FAT number 28 of 2023, the respondent appellant had discontinued to pay the maintenance to the applicant and his daughter. Accordingly, the applicant could.
You are the husband.
I am for the wife, lordship.
You are the wife. You are seeking a review of what order?
Order dated eventual lordship.
What did you do by that order?
Lordship, granting divorce.
Oh, the decree itself. The appeal was allowed. Their appeal was allowed.
Their appeal is allowed.
Very well. Yes. Yes.
Yes.
Delay has discontinued.
Accordingly, the applicant could not immediately contact a learned advocate by the arranging the funds requiring for taking any steps to assail such judgment and eventual order. After the applicant could manage the resources, he contacted his learned advocate in the end of the March 2025, and she was asked to meet him on April 2025. Ultimately, in the month of April 2020, the applicant contacted the learned counsel and instructed him to take eventual steps in her matter. The learned counsel has sought for the certified copies of the criminal case in Thakurpukur PS number section
For what purpose?
For purpose eventual lordship that in the criminal case eventual lordship that certain eventual recordings or findings eventual are there eventual lordship that is contrary to the record in the judgment eventual lordship, because at that time that document.
Yes, Mr. Manta, why do you say we oppose this?
Well, as I oppose this, firstly, your lordships will see the review is filed in the month of May. The condonation is preferred in the month of August. That is my first point.
No, that does not.
My point is that good case on merits is no longer a ground. My point is that due diligence at least should have been exercised. When the review is preferred in the month of May, thereafter it has been preferred in the month of August.
No, the delayed filing of the Section 5 application cannot be a ground unless it's someone hit by 136.
Whereas even if so far as the sufficient cause that is demonstrated that maintenance is not being given, your lordship in the main judgment had found against her that maintenance is being given. Your lordship will kindly just take
might be, but this is financial stringency. We are liberal.
But as well, kindly just take at least in so far as
we'll record that you are disputing that alimony is not being paid.
Well, if alimony is, it's not a question of just the alimony being paid. Your lordships will kindly see your lordship
maintenance you have been paying after the dismissal of the suit.
Yes, Manoj. Now they are denying that the maintenance application your lordship had given her liberty while disposing of the appeal to file a maintenance application.
26.
That has been filed in the month of June, not in the month of May. And the condonation is filed thereafter.
Anyway, she even without casting an aspersion on your client, she might have been in financial stringency. For the same reason.
I have in fact, Manoj, in my opposition, I have annexed checks also that I have issued in her favor. She's been refusing those checks. I have handed over cash of 50,000.
How does it deal with that in her reply?
Manoj, she's denied that. She said that she's not received any funds. I have at least annexed a copy of the checks. Now, cash, naturally, Malaj, there was no receipt.
Annexing copy of checks does not establish beyond doubt that you have...
That I have served, Malaj, I understand. But at least your lordships will see cohesively if your lordship just kindly sees, Malaj, at least takes the judgment for a moment. The judgment that is under review, your lordship just kindly takes...
You just now said that we cannot look into it.
In my opposition, the only reason I want to show the judgment under review...
That alimony was being paid.
Because this particular ground has been taken by her in the main appeal as well. On one occasion, it was taken that she's not that she's not being maintained, neither is the daughter being maintained. Your lordship found an adverse inference against her, saying that no, in her cross-examination itself, she admitted that yes, I was being maintained.
This is post facto, post our judgment.
But at least there would be some sort of persuasive value that my submission would have.
No,
on one occasion, at least if
that is what the time frame during pendency of the appeal, we had disbelieved her that no alimony was being given. But after the appeal was allowed, your appeal was allowed and decree was granted, there was no reason actually for you to pay also because there was no section 26.
Malaj, but there was at this point. So then the sufficient cause goes.
Aspersion against you.
Then the sufficient cause goes, Malaj, because today they have not preferred an appeal against this.
They have hardly sufficient.
Malaj, they have not
section
preferred.
5.
Malaj, kindly just at least takes the judgment to your lordship where your lordship has recorded.
We'll record that we have you submit that we have recorded in our judgment that they failed to establish that you are not paying the alimony. That is what you are saying.
No, it's not just about whether I'm paying.
Why should you look into the judgment otherwise?
Well, it's because of the findings that your lordship has rendered.
Regarding what?
Well, it's one in respect of the maintenance, and the second is the liberty that was granted to her. That liberty
filed to permanent alimony application under section 25.
So that was preferred by her in the month of June, my lords.
We'll record that, but still we feel financial indigence is
sufficient cause is not demonstrated, my lords. That is my only submission. How does this amount? I ask myself, my lords, how this amounts to sufficient cause for the purpose of delay, for the purpose of condonation. Now, your lordship will also appreciate one more point. If, my lords, she was seriously intending to pursue the review application, she knows today that if the condonation application is not allowed, the review will not be admitted. She prefers it 3 months later.
The moment Mr. Basu comes up and moves the matter, we'll dismiss it. That's why he's intelligent enough not to do it.
Well, the reason I'm saying this is that after Patapati Subba Reddy, your lordships have also relied on it and said that even if sufficient cause is shown, Lack of bona fide and due diligence, your lordship will not condone the delay. I am saying that this is a lack of due diligence, because had she preferred, if she wanted to move the review seriously, she would have preferred the application for condonation within time as well.
Yes, what do you say to that? You did not even prefer any application for file any application for permanent alimony despite our being given our giving you the leave. So you are not diligent on your maintenance also. So how do you explain this? He has a point there.
But your lordship,
He could not manage resources, contacted advocate, did not pay maintenance. But you had an advocate when the matter was moved. And therefore, this is no excuse for saying that you could not apply for permanent alimony despite being granted leave. In the judgment itself, in our judgment itself, we gave the leave.
Yes, lordship, after granting
So what prevented you
leave,
from
he
doing it?
filed in the maintenance case, lordship.
Represented by advocates in the appeal. You were represented by learned counsel in the appeal. Was it an ex parte judgment in the appeal by us?
No.
Then you knew the moment the judgment was passed, delivered in open court, that you had the leave to file a permanent alimony application. Why didn't you file it? And in connection with that, you had a right to pray for interim alimony also, because that's also proceeding under the Hindu Marriage Act.
Well, it's preferred in June, Malaj. They've referred in the reply that they filed the application for alimony in June. That is what they've referred in the reply. And this is coming up for the first time.
We can think of two courts where we should assign these matters immediately, so that we don't have to take the burden.
Paragraph number 7, your lordship.
Paragraph 7 what?
Of the reply of the section 5 application, that no formal application for maintenance was filed by the applicant.
Yes.
I respectfully submit that the respondent had paid maintenance to the applicant amounting to rupees 8,500 on 6th February 2024.
There was no application. Why should
no
they
single
pay?
penny in connection of the maintenance had been paid by the respondent to the applicant.
No,
as
there
well
was a
as his daughter.
subsisting order under section 125. Was there any subsisting order under section 125 CRPC?
No.
Then why should they pay? Appeal disposed of, no liability to pay interim alimony. You did not file, despite having the leave, you did not file a permanent alimony application. Why should they pay?
25th June, they have filed the maintenance case.
So therefore, it's your fault. Why shouldn't you dismiss the matter? Why shouldn't you dismiss the section 5? There is an utter lack of bona fides. He has a point there, Mr. Mantha has a point there in saying that this ground that you could not immediately contact your learned advocate by arranging funds. You are represented by advocate in the appeal. In the appellate court judgment under review itself, liberty was given to file permanent alimony application.
February 2025, lordship, the maintenance has been stopped. Lordship, thereafter,
Rightly. There was no liability in law to pay maintenance.
But in the lower court, advocate also there is.
Why should you go to the lower court? Your advocate was here in this court itself. So you could have arranged.
Maintenance application lordship filed before the lower court.
True.
But there is also some financial crisis.
So let us see the what liberty we gave.
Malaj will kindly take paragraph number 42 of your lordship, the last paragraph of your lordship's judgment, 5th of February, 84, Malaj. It's annexed to my affidavit in opposition, Malaj. 84.
At the time of filing the written statement, the respondent, the applicant stated that there is no alimony has been paid. But thereafter, at the time of cross-examination, they said that she said that the alimony has been paid.
No, Mr. Mantha, 61 days.
Malaj will kindly just Malaj.
Yes. We are not hearing you.
Malaj will kindly just considers your lordship's judgment, at least in Debjani Bose versus Baxter, where your lordship has held that even if sufficient cause is demonstrated, I'm taking the case at its best.
No, that is
the lack of due diligence and bona fide, your lordship can
that
still.
Is the Supreme Court judgment, clear judgment. Our judgment? It is a Supreme Court judgment.
Yes, there was a Supreme Court judgment, Malaj, which your lordship.
There are two Supreme Court judgments.
There are two Supreme Court judgments. After Patapati Subba Reddy, your lordships found that there has been a divergent view that good case on merits is no longer a ground. And the second thing that your lordship,
we are not looking into the merits.
Even if sufficient cause is shown, lack of bona fide and due diligence, your lordship can reject condonation.
We'll say this is not lack of bona.
Matlab, kindly, at least lack of due diligence is occurring. Matlab, kindly see, there was a liberty given to her. Matlab, she comes in a month of
Heard,
June.
heard learned counsel for the parties, Full there is a delay of about 61 days in preferring the review application. Full learned counsel for the petitioner places reliance on paragraph 10 of the condonation application and submits that since the respondent stroke appellant had discontinued to pay the maintenance to the applicant and it should be her daughter, comma, she could not immediately the applicant could not immediately contact her learned advocate by arranging the funds required for taking any steps to assail such judgment and order. After managing such resources, comma, the applicant allegedly contacted her counsel and thereafter the review application was filed. Next para. Learned counsel appearing for the respondent submits that there is utter lack of diligence on the part of the review applicant. First, comma, the application for condonation of delay itself was filed much after the filing of the review application. Next para. Secondly, comma, in the judgment sought to be reviewed itself, comma, this court had given the liberty to the applicant to take out an application for permanent alimony. The applicant having not availed of such leave, comma, cannot now claim bona fides or diligence in proceeding with the present review application. Next para, it is pointed out by learned counsel for the respondent that respondent stroke opposite party that, comma, the primary reason cited for the delay in preferring the review application is that the applicant was short of financial resources, comma, since no alimony was being paid to her. It is submitted that it is the applicant wife who herself committed a delay in taking out an application for permanent alimony and, comma, as such, comma, has to blame herself only for the said non-payment, alleged non-payment of alimony. Next para, it is further submitted that the respondent stroke opposite party stroke husband has been tendering checks in lieu of maintenance which have been refused by the applicant. Next para, upon careful consideration of the pleadings in the application for condonation of delay as well as the opposition and reply in connection therewith, comma, we find that the applicant wife has pleaded financial indigence as the primary ground for not being able to engage advocates for the purpose of filing of permanent alimony application in the trial court. Next para, although the applicant was represented by counsel in this court, comma, it is understandable as to why she might not have been able to approach an advocate in the trial court for the purpose of making the permanent alimony application, which, comma, in turn, comma, aggravated her alleged financial indigence. Next para, although the husband claims that the opposite party husband has been sending checks of in lieu of maintenance to the appellant wife, comma, we do not find any conclusive evidence to suggest that such checks were actually served on the applicant wife. Next para, in view of the above circumstances, comma, we are unable to lack any direct malafides to the applicant. Rather, comma, the bona fides implicit in financial indigency can be extended as a by way of benefit of doubt to the applicant, comma, particularly in view of the nature of the application, which is for condonation of delay of about 61 days. Next para, learned counsel appearing for the respondent stroke opposite party cites a division bench judgment of this court in the matter of such and such reported at 2024 SCC Online Cal 11219 for the primarily for the proposition that in the event the applicant fails to show bona fides, comma, condonation applications are not to be allowed.
Para 43, my lords.
Full stop. Next para, learned counsel places particular reliance on paragraph 43 of the said judgment, where it was recorded that the Supreme Court had highlighted in Pattapatti Subba Reddy's case that ওটা পেয়ে যাবে ওখানে ওই 42 তে আর 44 এ এই সাইটেড জাজমেন্টে পাত্তাপাত্তি এটা পেয়ে যাবে case that justice-oriented approach and liberal approach in condonation of delay cannot be used to defeat the substantial law of limitation, whose exercise of the power, comma, it was observed, comma, is discretionary and may not be exercised even if sufficient cause is established for various factors such as inordinate delay, comma, negligence and want of due diligence. Full stop. Next para. In the present case, comma, the delay is not inordinate and the so-called negligence or want of due diligence of the applicant is plausibly explained by her financial indigency, comma, particularly in the absence of clear proof that she was being paid maintenance or had other sources of income in the interregnum, comma, after the passing of the judgment sought to be reviewed and the filing of the review application. Full stop. Accordingly, we are satisfied that sufficient reason for the delay, sufficient cause for the delay in preferring the review has been made out. Full stop. Hence, can 2 of 2025 is allowed, comma, condoning the delay in filing RVW 130 of 2025. Full stop. There will be no rise to cost. Allowed on contest.
Well, it's just one humble submission. My lords, just kindly takes a look at 41 of your lordship's judgment, 5th of February. Well, it's just one moment. Well, it's just for the, well, just paragraph 41. For one moment, your lordship just kindly see. My submission will also be that if she could prefer the review, why couldn't she prefer the condonation also, my lords, or the maintenance? She preferred the review. But it's just kindly.
She was late in both.
No, but let's kindly just take 41.
No, advocate, blame on advocate. 41, para 41.
Matlab, para 41, the next contradiction, matlab, your lordship's judgment. Your lordship's judgment on 5th of February, my lords. Where your lordship's, the appeal judgment. Matlab, kindly just
That was for that.
But if I may just read it out, your lordship just
No,
considers for one
next matter. No, Mr. Mann.
I'm great.
The review application shall be listed for hearing on January 16, 2025.
Liberty may be granted to me to file an opposition to the review and the
Very well. Affidavits, if any, shall be exchanged in the meantime. Do that before the vacation so that they can come up with the reply.
I'm great.
So, 16th review application. 9 who is appearing? Yes.
Number 427 review application.
Yes.
So the kindly comes to my lord, order, my lord. The review under the last page, the paragraph 15. Paragraph 15, my lord. WPLT such as is allowed. We have allowed the said application being such as
Paragraph 50.
1.5. Well, my lord, judgment.
What? 1.5.
Last paragraph. On
Yes. Allowed in part, thereby setting aside portion of information.
No, we allow the said application being MA number such and such direct possession of the disputed property immediately restored to the petition.
Yes.
The tribunal shall pass the.
Read it. What about it? Yes.
Now, the kindly take up the can 1. The coordinate range of this honorable court here in the tribunal tenancy tribunal act there is no provision for direct the police. Kindly, I have annexed that judgment. This was not placed before my lords when the order was passed, and another one in the appellate court. The order of injunction is there, and our right has been protected. In appeal, that 2 documents I have annexed, can 1.
In appeal? Appeal against this order?
No. They filed a title suit for declaration and injunction. In that suit, degree directing us to vacate the property in question. We challenge the appeal. The landed first appellate court, the stay the operation of the judgment of the.
On the date when we passed our order, that stay was there.
Yes, stay was there. That was not that documents could not be produced before my lords. And another.
Why could it not be produced? This is not discovery of new matter.
Now, this kindly comes to the order passed by this coordinate range. This issue has been the page 62 can 1. The order passed in the WPLT 147 or 2013.
62. Yes.
This issue was framed whether the tribunal has any jurisdiction to grant judicial under the provision of West Bengal Land Use
This was never cited before us.
that
You cannot make out new argument now by citing several judgments.
this document could not be placed, my lord.
What document? This is a judgment of court.
These judgments.
Then there will be no finality to litigation, Mr. Ghosh. You cannot just come up and make a legal argument by citing a judgment. Could have done that at that point of time. We won't reopen this in review. Sorry.
That could not be one of the produced, my lord, when the order has been passed, my lord.
Whenever you wish, you file a review application and reopen all judgments by saying that that judgment was not cited. Sorry, we don't do that in review.
Now, my lord, kindly.
File a regular challenge against our order.
Page 39, my lord, kindly comes to the in that can.
Yes, 39.
My lord, the order that was, my lord, the here, my lord, in this title suit, my lord, we defeated, and the director to deliver vacant has full possession.
Yes.
Now, my lord, that was appeal against, my lord, page 44, our appeal.
Why was that not produced before us? That is also a new document. This is not a discovery of new document.
That was one of the.
That was what?
That is one of the recorded. The civil suit has been filed. That is recorded, my lord's order.
Yes, but you are saying an appeal has been filed and that there has.
No. In that appeal, TA 71 of 2024, the stay of operation of the judgment for the in the title suit. That is subsisting.
Was that submitted before us? Or did the tribunal consider that?
Tribunal, the application is pending. Since my lord, the give direction, to police, pursuant to my lord's direction, they have filed one application. This
Yes.
application fixed on 19th of this month.
Right.
Now, the my respectful submission, since the honorable coordinate bench, this says, this is the tribunal has no jurisdiction.
No. You say that order of stay of operation of the decree was there.
Yes.
When we passed our order, it was already there.
Yes.
On the basis of that decree, we directed him to.
No. The issue is that I am the Borgadar.
Nothing.
I was dispossessed. The file 19.
We did not direct in terms of the title suit decree.
No.
We did not implement the title suit decree. If you have a stay of that, you have a stay of that. Whatever may be the effect of that. But independently, we considered regarding Borgadar and we directed this. There was no injunction on them not to proceed against you. There was a stay of operation of that decree.
By virtue of degree, my right has been protected. Now, if in the meantime, the police.
By virtue of decree, your right has not been, your suit has been dismissed.
No, the appeal court.
Rather, their suit was decreed.
Now, the
appeal court has stayed operation, which is merely high. That operation of the decree, we did not implement that decree. Mr. Ghosh, you don't understand. If we had directed the decree to be implemented, then this would be German. Independently on a different consideration, we have directed this to be done. What was our consideration? Let us see that.
Contempt of the tribunal's order, which was in 2012.
Yes.
The decree has got nothing to do with it. That's another proceeding altogether.
One of the director to police help in favor of.
Sorry, Mr. Ghosh. Sorry. On both grounds, we are turning down.
The judge also doesn't consider Rule 8. Rule 8 is clear that
only one. Kindly
Rule
consider
8 too. Where the tribunal is given the power to implement its order and
absolutely yes.
Now, kindly see the
Rule 8.2 is very clear. Police help powers.
This judgment is there. The coordinate bench judgment is also there. Kindly count.
Learned counsel for the petitioner argues in support of the review application that the review applicant failed to bring to the notice of this court at the time when the judgment sought to be reviewed was being passed, that a title appeal had been preferred against an eviction decree obtained by
title suit. Title suit. That is a different title suit. And
we for declaration and injunction.
Yes.
They file a suit for declaration in that suit.
Of that.
That's got nothing to do with
cultivating the land.
Was decree of eviction passed in that suit of which he obtained stay?
Yes.
Yes.
The land trial passed an order.
Did they pass an eviction? Did they get an eviction decree against which appellate court passed stay order?
Kindly come to page 39.
Was it an eviction decree or no?
It is not eviction degree, but I was directed to deliver the khas
Possession within 16 days from the date of the order.
And the violation was the order of the trial.
That was a civil court's degree.
Yes.
Yes. And the order was
Eviction decree কেটে দিন against a decree obtained by the respondents in connection with a suit for declaration and injunction, comma, inter alia further directing the applicant to vacate the suit property, comma, against in connection with which, comma, an order of stay of operation of such decree has been passed by the appellate court. Full stop. Next para. Secondly, comma, it is contended that a coordinate bench judgment of this court was not pointed out to the court, comma, as per which the tribunal does not have the power to direct police help. Full stop. Next para. However, learned counsel appearing for the respondent controverts such submissions and places reliance on Rule 8 within bracket 2 of the West Bengal Land Reforms and Tenancy Tribunal Rules, 1997, which specifically empowered the tribunal to grant police help if necessary to deliver possession in pursuance of an order of the tribunal. Push up next para. Insofar as the coordinate bench judgment is concerned, comma, the same was not placed before us at the relevant point of time by the review applicant. First up, in the event all subsisting judgments at the point of time when an order under review is passed are permitted to be cited at the review stage, comma, there would be no finality of litigation and the entire arguments would be reopened, comma, which would be palpably dehorse the scope of the review jurisdiction. Full stop. Next para. That apart, comma, in the teeth of Rule 8 within bracket 2 of the 1997 rules, comma, there was ample power vested in the tribunal on the date when we passed our order to grant police help in consonance with our direction. Full stop. Next para. Insofar as the stay order purportedly granted in an appeal against a decree which directed the review applicant to vacate the premises is concerned, comma, the order now sought to be reviewed was not premised on the civil court's decree, comma, nor by way of an implementation or execution of the same, and was passed independently in connection with a completely different proceeding. Full stop. Thus, comma, the said decree of the civil court and or any order of stay passed in connection therewith merely implies that the said decree cannot be executed, comma, which has no bearing at all on the present consideration. Full stop. Next para. Thus, comma, the review application fails on both counts. Accordingly, RVW 279 of 2025 is dismissed on contest without an order to cost. এটা ফেরত দিন। Affidavit size will be kept under. We'll sit after 10 minutes for the regular bench.
May I be permit to mention one matter?
Yes.
My lord, your lordship passed an order in respect of Guardians and Wards Act that all the affidavits and everything should be completed, paper book should be submitted, and liberty to mention. Now, I am not seeing and talking with my daughter for the last 9 years. In the meantime, my father died last week. Now, my mother has been hospitalized in the Chandanagar hospital. She is counting her days.
If it's an appeal, Mr. Bhattacharya,
Only I am making a prayer before your lordship,
Yes.
not hearing of appeal.
File an application, file a formal 2-page application, we'll take that application. Just mention, have that application mentioned, we'll take it on list. Yes.
Lordship, I'm
Sorry, you're there, Ms. Ghosh.
Lordship, I'm praying for
She's going to start, so we'll hear and
Lordship, I'm praying for the leave to file a Jalpaiguri matter, Your Lordship. It's an FMAT, Your Lordship. Lordship, on Friday I had sought for the leave, Your Lordship. Your Lordship, that day was sitting in the single.
Oh,
bench.
yes. Let's
Lordship,
start.
Lordship, and there is another, Your Lordship. The stay application I'm also filing today along with the appeal. Your Lordship, it's an extremely urgent
Is the
matter.
next bench in Jalpaiguri?
15th. Lordship, what is the urgency? It's a 3rd December order.
15th of
15th of December.
So next week.
Lordship, there is the Lordship, this is a Lordship, kindly hears me, Your Lordship. I had mentioned it on Friday itself. Your Lordship, what is the difficulty is that
No,
Lordship,
Friday, if we answered you, the answer would be the same.
Lordship, I'm
Not that
praying.
the answer differs.
Lordship, I kindly appreciate. Along with that, I've filed an application for injunction. Lordship, my prayer is that there was a development agreement. Now, this development agreement of 2018 has lost its effect in 48 months. After 48 months was over, there was adequate interaction made between the developer and I'm the owner. Lordship, now what has happened in 2025? Now he has become a trespasser in respect of the suit land, Your Lordship. Now he has started dumping construction material. I'm only praying that in the
1
meantime,
week, no.
Lordship,
Construction material may fall, but revenue will not fall.
Lordship, kindly appreciate. Lordship, kindly appreciate, Your Lordship.
15th is we thought after the vacation, the next bench is after.
Lordship, kindly in that event, Your Lordship, in this
Valid
week,
before the
Lordship, in that event, Your Lordship, in this week, Your Lordship, let there be an interim stay. Lordship, kindly, Your Lordship, today they are creating the third party right, Your Lordship.
No, leave is refused. Sorry. Leave is refused. You file it before the circuit bench.
My lord, I'm mentioning one application.
Application, please. Application, yes. Yes.
This is, my lord, under very compelling circumstances.
Applications and order for terms, please hand over. Please wait for some time. We'll take up the application.
41, my lord, there was an order of the land register Lojima for, my lord, sending back the trial court, lower appellate court decree for correction. It has not been done. My lord,
Appearance to be mentioned, right to be mentioned, and hand over the state.
my lord, it is, my lord, for admission of hearing. I am praying, my lord. Without trial court, lower appellate court decree.
Have you got the certified copy now?
No, it has not been sent back to the court, High Court.
No,
Probably,
unless
my
you
lord,
get that, how can we hear it? It's difficult.
Judgment will be looked into. My lord, it's not that
No,
easy.
but it's defective still. Our rules, the difficulties, order 20, order 41 are there. But our rules have not yet been amended, so decree is now necessary. Otherwise, the jurisdiction and
Appeal
the
is from the
valuation, nothing can be ascertained.
The situation has aggravated for the reason that, my lord, we are the co-owners. My lord, my
Understood, but if
lawsuit-
the judgment certified copy is not there, I mean,
Let it
why didn't you
appear-
obtain a certified
let it-
copy?
my lord,
Why didn't you obtain a certified copy?
No, my lord, decree, lower appellate court decree has been sent back by memo number so and so, but it has not. yet been-
Certified copy should be there.
My lord, we pursued here, there. My lord, the file is not available.
What can we do without this?
File is not available. That is the whole problem.
আচ্ছা ফের let it appear in the list. Let it appear. Order for 20 defective করে দিন আমি দেখছি তখন দেব. Yes.
Appeal hearing matter. After the vacation matter, I'm not praying for.
No. We're not falling into that trap. No.
Your Lordship, inclusion in the list application, but this needs to be heard expeditiously. Application, but this needs to be heard expeditiously.
All applications are hard expeditiously.
My lord, this is my prayer, my lord. This is only not for inclusion, but for also upgradation. Why I tell your lordship, my lord, this is
What?
matter.
Appeal?
Yes, my lord. This is one of those matters where your lordship had the occasion to, my lord, deal with the issue. My lord, if your lordship remembers, I'll just hand over the order. My lord, this is pertaining to, my lord, to the All India Bank scheduled caste employees, my lord, where your lordship had passed an order.
Yes.
By holding that, my lord, the council is defunct. My lord, thereafter, my lord, the joint administrators were appointed.
Now, in the meantime, Lord, what has happened before the trial court? Another suit has been filed by us for freezing of the bank accounts because there were allegations of defalcation of funds. Now, my lord,
Appeal hearing we cannot take
no,
up.
this is not hearing, my lord, this is for admission. I am only seeking for modification because today the president.
It has not yet been admitted under Order 41.
No, this is the earlier order in an earlier suit.
No, your appeal?
No, not admitted. This is for appealing.
Order 41 by default we are taking. Why are you mentioning?
The difficulty is, my lord, it has to come up before 11th because 11th is the next date. Now the president is.
You are handing over the slip today. Whenever the file comes, it will be in the list. Order 41 and applications, whenever the files come, we put it on the list.
If some priority could be
No
given,
priority.
otherwise, my lord,
No.
The difficulty is, my lord, the election is going to come.
Maybe.
And my lord, the
We are
president.
mentioning only today. No. Call on the list. Please call on the list.
My lord, I wish to.
At once. Arrest.
But my lord is mute, lord.
But we did mention the matter.
Lordship, department probably.
Department আছে এটা বলে দেবেন তো যখন
I'm led by Mr. Kamakar, Your Lordship, who's appearing.
Oh, we are directing the records to go down to the trial court for correction, but the records have already come. So we'll
On
ask
that
for
one,
we'll direct the competent person to be brought from that court, and in this the records will get.
Easier,
Yes, easier for all.
Because it was actually all in the past, it went back and then came back and again.
No question of going back again. If the records are here, we didn't know that. The office report dated December 5, 2025 indicates that although this court had previously directed the records to be sent down for effecting necessary correction in terms of an application under section 152 of the Code of Civil Procedure filed by the plaintiff stroke respondent, the records are already before this court and appropriate orders need to be passed. Full stop, next para. Since the records are already before this court, it would only be appropriate, for the sake of expediting the matter, that the appropriate competent person is brought from the trial court in order to effect the necessary corrections in terms of our order. Full stop. Accordingly, the office shall take steps in that regard at the earliest. Full stop. Necessary costs in that regard shall be put in by the respondent within a week. You put in necessary cost for, you're the respondent, for
I appeal for the respondent.
ascertain. Oh, you're there. Ascertain from the office, Mr. Karmakar, if any costs are to be put, then put it.
Yes,
within a
we
week.
shall put that.
Next. Great. Thank
Great.
you. Mr. Karmakar Junior, please give your appearances. Yes.
Lordship, name has to be incorporated.
Oh, whose name? Your name. We'll delete your name and incorporate.
I've already indicated.
In the judgment dated December 1, 2025, passed in MAT 1407 of 2024 with IA number CAN 1 of 2024, in the list of names of the council, the name of Ms. Manju Bhuteria erroneously omitted to mention her designation as a senior advocate. Also, the name of Ms. Arundhati Bormon Roy was omitted from the list of council appearing for the respondent numbers 1 to 20. Let such corrections be deemed to stand effected in the judgment dated December 1, 2025, and this order be deemed to be a part of the said judgment. Eta dekhe kore deben, huh? When you apply for certified copy, apply for today's order certified copy also.
Deep here.
Yes.
Lordship, I beg to appear for item number 3, appellant's lordship.
One second.
Lordship,
One second.
I'm the respondent.
Oh, cost has been deposited, special messenger cost out of time. We'll accept that. You have deposited.
Yes, yes. Lordship,
We'll
kindly
accept.
allow it to be
Definitely, we are condoning the
regularized.
delay and accept. The matter has been put up before us because the special messenger costs have been deposited beyond the time stipulated by us. Full stop.
We have filed the paper books also.
Very well. The records have come.
Records have not come because
Learned counsel for the appellant submits that the appellant has also filed the appellants have also filed the paper books. Full stop. Next para. We on the oral prayer of learned counsel for the appellants, we condone the delay in depositing special messenger costs and accept the same. Full stop. The office shall take steps accordingly for bringing the lower court trial court records at the earliest.
Grateful.
Full stop. Next para. Due steps be taken by the office for service of copies of the paper book on the learned advocates for the respondents.
Yes, grateful.
Item number 4.
Not filed the paper books.
I have also served notice after mentioning my lord.
The receipt in respect of service of notice on the learned advocate for the appellant, filed by learned counsel for the respondent today, be kept on record. Full stop. It appears from the office report dated November 13, 2025, that pursuant to the order passed by the registrar administration within bracket L and OM bracket closed on September 27, 2023, no paper books have as yet been filed in the department by the appellant. Full stop. Next para. Accordingly, the appellant is directed to file the requisite number of paper books within a fortnight from date. Full stop. In default, the matter be placed in the list under the heading Lozima for final orders.
I will.
The receipt filed to the
My lord, order.
please communicate the server copy of this order so that if they don't comply and file that receipt also on the next. Irrespective of that, it will be dismissed under that heading if they don't file.
Item number 5.
Give your name, please. Give your name. Letterhead chiti diyechhe.
Lord, in this matter, I appear for the appellants. Lord.
Yes.
Lord, the plaintiffs are appellants before my lords. Lord. It's a judgment of reversal against the judgment of reversal. Lord, in suit for declaration, injunction, and separate possession. Lord, it was decreed in respect of 42 decimals of property, which my clients were settled by the predecessor in interest of the defendants. Lord, the
settled by registered deed?
No. By a
family arrangement?
No. He was a different person.
Lord, how can the transfer take effect?
That has been accepted by the courts below, my lord.
Then?
But the particular plot was measuring about 56 decimals. They were settled with 42 decimals. But after the settlement was done, my clients were in possession and in respect of 56 decimals. Since the record of right prepared in the revision record of right was erroneously prepared, that 36 decimals was recorded in my client's name.
42 you said?
42 was settled. Were in possession in respect of 56 entire plot.
36, how does that come?
That is the problem. 36 record of right was prepared in the that was challenged by my clients. That this is not correct. But the trial court held all the issues in my favor. Yes, the 42 decimals was settled. Therefore, the decree was granted in respect of 42 decimals. But the appellate court, lower appellate court, held that since my clients were defeated in section 44(2)(a) proceeding and did not file any appeal, so that has become sacrosanct and binding upon me. Therefore, 36 decimals is correct, not 42 decimals.
But if you approached before the appropriate authority And what would be the effect? Because in law, that is the authority which is competent to decide this issue regarding the recording of names. So in the absence of anything else, why shouldn't the court accept that?
Lord, section 42A, which has been decided by the catena of judgments of our High Court, Lord, that has got no binding effect on our
civil court. It does not otherwise have a binding effect.
My lord, that is the law.
Let us see that finding of the appeal court.
My lord. Page 3 and 4.
Page 3.
My lord, I just point out, my lord.
That is limitation. 7. Now, independently, did you prove your position in respect to entire 42?
Yes.
And title was also set aside. Declaration of title was also set aside.
In respect of 6 decimals. Not page 3 at the top.
Page 3 of appeal court.
Appeal court judgment.
Yes.
Further fact is that Sheikh Yaqub Ali, Sheikh Ilyas and Ayya filed an application under section 44(2)(a).
Page 3 of appeal court or only. Oh, sorry. I was looking into the. Sorry, my mistake.
Right.
Yes. Further fact. Please continue.
For recording their names against plot number 511, claiming that they had their right, title and interest in respect of 42 decimals. But that was after contested hearing rejected by the revenue officer by order number.
You are these people, Sheikh Yaqub and all?
My lord.
You?
Yes. That issue was finally decided by the trial court also.
How? That is not binding?
That is not binding. And record of right does not create any.
Oh, your title was the entire suit was the judgment was set aside.
Yes.
We thought regarding the position it was disputed.
Allowed in part on contest.
What portion was set aside? Same is decreed in part. Yes. Yes, exactly. Declared your right title and interest was index was 36.
36. That is the.
The present second appeal will be heard on the following substantial question of law: whether the learned first appellate court substantially erred in law in relying on extracts from the records of right to disbelieve the title of the plaintiff stroke appellants, established by appropriate deeds, by overlooking the principle that the recordings in records of rights do not confer or take away any title. Full stop. Any interim application?
No application is there.
The appellant shall, the trial court record shall be brought by special messenger at the cost of the appellant, to be deposited within a week from date. Full stop. The appellant shall also deposit postal costs and other requisites for service of notice of the appeal on the respondents within a week. Full stop. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention the appeal for enlistment before the appropriate learned single judge, having determination as and when the appeal is ready for hearing.
Great.
Next. Yes, please.
Like the defendant appeal.
Respond. Defendant appellant, yes.
Judgment of affirmation. The fact remains, my lord, the plaintiff filed a suit for declaration permanent injunction and subsequently, my lord, amendment application for recovery of possession. the suit was decreed against my client, prefer an appeal, and appeal court affirmed the judgment and degree of the trial court. The fact, my lord, the petitioner, the plaintiff, settled a patta in the year 1993. But my lord, and he claimed that I am the outsider, I am in possession by
Plaintiff
way
is
of
the plaintiff is the patta holder.
patta holder. I am the stranger person. I am coming from, my case is that I am coming from Amlagoda to Lalgor in the Jharkhand district, my lord.
Yes.
And I have, my lord, occupied the vested land, and I have constructed the room since 1975. My father was constructed the room 1975. While the patta was granted by the government to the patta holder without taking the possession from me, only my lord, symbolic possession to the patta holder. Now the patta holder in the year 2005 filed a suit for declaration on the ground that he was in possession. I forcibly evicted them. That is why he has filed the compelled to file suit. But my contention is that no, my father 1975 occupied this year and they constructed building. And I have taken the point that the suit is not maintainable and suit is barred by limitation. Because 1993 the patta was granted. So after a lapse of several years, 2006, he filed the suit. And my case is also in the year 1993, while he was granted patta, the plaintiff threatened me 1995 that I have got the patta, you surrender the property to me. So my question before the court below, that suit is not maintainable. And the trial court framed, my lord, 10 issues. 1 to 7, my lord, the trial court comes to a conclusion that neither the plaintiff and the defendant has not pressed those issues. Kindly see this. I am placing this. Inner page 5 in the trial court judgment.
Yes.
Issue number 1 to 7.
Inner page 5 of trial court.
For the sake of brevity and
convenience. 1 second, we are not getting that. 9, na? Inner page 9.
9. The trial court judgment, my lord.
No, trial court 30. 9 is not. Okay, 9.
Has your lordship got it, my lord?
Issue. Oh, there are.
Appeal court judgment letter, my lord. First, the trial court
obviously,
judgment.
the appeal court judgment letter. Page 7, yes.
Page 9.
No, it starts at page 7. Issues 5.
Yes, madam. I am placing 9.
The trial court. Okay, appeal court. You obtained separate certified copies. Subsequently, another second judge's copy.
The trial court.
What is the name of your client?
Yes, my lord. My client is Osit Chalok and Viren
Yes,
Chalok.
this matter.
And my lord, the judgment certified copy.
Anyway, let us come to that. Let us come to the issues, yes.
Yes, my lord. Page 9. Has your lordship got it, my lord?
No, in my copy, it's page 7.
No, cannot 7.
Page 9 issue, the decision on the issues.
Page 9.
You are placing the decision on the issues or the issues themselves?
No, yes. Decision with reasons.
That is at page 8.
Page 8. I am placing page 9.
Page 9 is the decision on those issues.
Yes, ma'am.
I was looking at the issues.
No.
Very well, yes, please.
Issue number 1 to 7. For the sake of brevity and convenience, all the above issues you are taken together for discussion and disposal of one bunch. Neither the plaintiff nor the defendant put forth the contention that the instant suit was not maintainable or was legally barred or was defective in any way. At the time of putting forth their respective argument, neither the learned counsel for the plaintiff nor the learned counsel for the defendant argued for or against any of the above issues. So, my lord, that was the main point taken by the defendant, that suit is not maintainable barred by limitation. because my father occupied the land 1975. The patta was granted 1993. So, as and when, according to under section 49 of the West Bengal Land Reforms Act, as and when the patta granted to the landless person, it is the duty of the BLRO.
Got your point, yes.
Yes,
So,
my lord.
what about that?
My lord, take possession of the property to the third my lord. But while the patta was granted, I was in possession. So,
Your case has been disbelieved on facts by both the courts below, and
Yes.
their cause of action is 2005 when you threatened them. That is their cause of action.
But
Your
I have-
case has been disbelieved that you have built a property there on 1975. Disbelieved on facts by both the courts below. Why should you interfere with that?
my lord,
Mr. Giri, why should we?
I have taken the point.
Evidence was
that-
considered,
Yes.
not a perversity.
No.
Evidence was considered.
But-
You had constructed 2 mud houses, considered everything, but defendant failed to prove that
Hello,
his father was in
one of
failed
the-
to prove that father was in possession since 1970.
Yes, I have. Yes. But
You have
well,
tried?
must have document with me, but that was not placed before the court below.
Keep it bound and in plaster of Paris so that it,
But one thing subject to correction, my lord. Page 11, your lordship. Kindly one thing, my lord.
page 11 of
Page
trial-
11 of the trial court judgment.
yes, page 11 of trial.
On evidence of PW2, Tarpanarayan Sahas Rai, in my humble opinion, was not very effective on reviewing either the plaintiff or for the defendant. Hence, the evidence was not relied upon this court. PW3 during her cross-examination, elicited the fact there was a tin set, a mud building on the shoot plot of land. She further revealed the fact that the predecessor interest of the defendant, namely Bhanu Chalok, has constructed 2 mud houses, one with in tin set and another with straw set on the shoot property. But it is established that there is a mud house and there is a tin set.
Does not mean that was built in 1976, 75.
Yes, that was not. But I have not.
No, you
I have not placed. I have not placed the
admitted,
document.
revealed the fact. PW3 during her cross-examination revealed that 2 mud houses, one with tin shed and another with straw shed, was constructed on the suit property after the year 2006. That is your admission. That is the recording.
Then, but my contention
No.
was that in the document written
Wrong
statement, but this was not considered.
The
by
defendant in a suit for declaration and permanent injunction has, along with recovery of possession, has preferred the
Well,
present
subject
second
to
appeal
correction one article.
against ES1.
Well, subject to correction, my lord. Your lordship can take decision, but give me chance to at least 1 year, because some mud house is there. I am the landless person.
They've got sufficient time. Suit of 2005, they're waiting for sufficient.
One thing, your lordship can. Your lordship knows, my lord. 1 year.
Let us pass the judgment, please.
Yes, yes.
কি বললাম? Recovery of possession has preferred the present second appeal against a judgment of affirmance. Full stop. Next para, learned counsel for the defendant stroke appellant argues that both the courts below overlooked the principal objection taken by the defendant stroke appellant to the maintainability of the suit, that is on the ground of limitation. Full stop. It is argued that although the plaintiff stroke respondent pleaded that the plaintiff was granted patta in the year 1993 in respect of the suit property, on the strength of which title is claimed by the plaintiff, the defendant, it is submitted, was in occupation from the year 1975 by making constructions on the suit property. Full stop. Next para. However, both the courts below overlooked the bar of limitation in granting decree in favor of the plaintiff stroke respondent. Full stop. Next para. Secondly, it is contended that there was clear evidence of the defendant appellant being in possession of the premises by virtue of construction of mud houses, which was overlooked in decreeing the suit against the defendant stroke appellant. Yes. Full stop. Next para. Upon a thorough perusal of the judgments of both the courts below, we find that the appellate court affirmed the decree of the trial court, where it was recorded categorically that PW3, during her evidence, revealed that the mud houses were constructed after the year 2006. Next para. That apart, other evidence was also considered by the courts below. Next para. In fact, both the courts below proceeded on the premise that the plaintiff stroke respondent has title and occupation of the has title in respect of the suit property by virtue of the patta granted in favor of the plaintiff. Next para. Thus, the concurrent finding of both the courts below were in favor of the plaintiff, both as regards believing the plaintiff case of title on the strength of patta, as well as disbelieving the defense case of the defendant being in occupation of the premises since the year 1975, which was not proved by cogent evidence. It is well settled that in a second appeal, the court does not reappreciate the evidence. Next para. Insofar as the question of limitation is concerned, the courts below proceeded on the premise that upon the position of the appellant of the plaintiff stroke respondent being disturbed in the year 2005 by the defendant stroke respondent, the suit had to be filed in the year 2006. Thus, no bar of limitation is borne out by the materials on record. As such, we also cannot find any fault with the findings of both the courts below on the ground of limitation. Next para. Accordingly, no substantial question of law is involved in the appeal. Hence, SAT 121 of 2024 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure. IA number CAN 1 of 2022 stands disposed of consequentially. There will be no orders to cost. At this juncture, learned counsel for the appellant seeks some time to vacate the suit premises. Next para. It will be open to the defendant stroke appellant to make such prayer before the executing court. If so made, the executing court shall decide on the same upon giving an opportunity of hearing to the plaintiff stroke decree holder stroke respondent.
My lords can, 1 year time will do it, then
Sufficient time. We did not give any adverse finding. We find that it's pending. They're pending. It's pending from 2005. Now we're in 22. For 2 decades, they have been waiting for this property. We won't give any further relief to you,
Because
but we have opened this little scope. So,
Yes,
yes.
I am for the plaintiff respondent, my lord.
Yes.
Lord, I am for the appellant, my lord. This is judgment upon my lord.
Is it section 5, Mr.
Yes, section 5.
What is the delay?
My lord, 400 something days delay.
400 something. Explanation?
Explanation is given. My lord, kindly see my
usual. States usual explanations.
No, not usual. My lord, this is
We have filed our
unusual.
opposition, my lord. We have already filed our opposition.
Yes. What is the explanation, Mr. Shinmugam?
I am confused. This is the reply, my lord, of the opposition. My lord, kindly come to my
So we have not
Opposition,
received the
file your opposition.
We have already filed, but we have not got the reply, my lord.
No copy of the reply.
reply to me.
Give a copy and come back tomorrow.
My lord, reply, my lord, already, my lord, the same whatever I have written.
Affidavit in reply filed to be kept on record. Since no copy thereof has been served till date, the learned advocate appearing for the appellant is directed to serve a copy thereof on the learned advocate for the respondents, which is complied here and now. In order to enable the respondents to go through the reply, let them attest and adjourn for the day.
But day after tomorrow, my husband.
Tomorrow. Adjourn for the day is tomorrow. Come back tomorrow.
Obliged.
Mr. Shengupta, please come back tomorrow.
Yes.
Yes. 8. The application is production. Neither the trial court judgment and decree nor the first appellate court decree has been filed certified copy.
The judgment, my lord, has been filed, but the decree.
No, that saves the limitation, but it will be defective. It is defective because otherwise the jurisdiction, valuation, nothing can be, or the names of parties cannot be ascertained. File those, then come back. Should have corrected those and then come back. File a certified copy. And the other classification of appeal that you can correct, we can give you leave. Memorandum of appeal from judgment and order. What is this? Second appeal.
Yes, second.
So memorandum of appeal should be from appellate decree.
From appellate decree.
So we'll give that liberty to you, Learned Junior. Let her correct it during the course of the day. And how long do you require to file certified copies of the judgment and decree of the appellate court?
Well, 2 weeks, my lord.
2 weeks. Very well. On the prayer of learned counsel for the appellant, the matter be adjourned for a fortnight and shall be listed next on December 22, 2025 under the same heading to enable the appellant to file the certified copies of the judgment and decree of the trial court and the certified copy of the decree of the first appellate court on the returnable date. For sub next para, leave is granted to the learned advocate on record for the appellant to rectify the classification of the appeal in the memorandum of appeal during the course of the day. Please ensure that it is done under your memorandum of appeal from appellate decree. In both the judges' copies, please carry it. And in your own copy also, later on you won't have. Yes.
Great.
Thank you.
Item number 9.
9.
My lord, I pay for the respondent plaintiff.
Yes. Yes, Mr. Chatterjee.
Lord,
What is the defect?
Defect?
Yes, apart this section 5. Let's check up the ticket.
কেন দিতে পারবো না?
Obviously, we cannot ask any of you to check up the defect. So
No, my lord, it's our fault. It's completely our fault.
preamble is bereft of the name of the presiding judge. Please put in the name.
এই স্ট্যাম্প তো দেওয়া রয়েছে
প্রিয়াম্বলটা করে দিচ্ছি লিভ করে দিচ্ছি
Name of the judge can you ascertain during the course of the day?
আমি বলে দিচ্ছি
Then do it. We'll give that leave, and right now we are hearing. Yeah. Yes. একটা লাইন লিখে দিন প্রথমে the learned advocate on record for the appellant shall rectify the preamble of the memorandum of appeal by incorporating the name of the learned presiding judge of the trial court, during the course of the day. Yes, Mr. Chatterjee.
Anti-suit injunctions. And it's a little weird. My lord,
Oh, it's a foreign decree.
No, not a decree.
Foreign suit.
Yes.
Oh. Then
Now, my lord, what happens is husband and wife both live in England.
Both
Live in England, and but they are Indian citizens.
So Hindu carries the law.
Yes. Now, my lord, since they live in England, under the English law, if you are domiciled there, you have a right to file your matrimonial proceedings there. I file my matrimonial proceedings there. I obtain orders. He appears. He challenges orders.
Orders means interlocutory.
Interlocutory. Matrimonial orders. There, my lord, it's something called a support orders.
Like maintenance.
Like maintenance. He challenges them in high courts. Judicial services. He challenges them judicial services payments order. That's the terminology, my lord, in England.
What does that mean?
Means maintenance.
Very good. Yes.
Then, my lord, what happens is he comes back here. He's given evidence. He's done everything, taken part in the proceedings. He's challenged those orders in high court. He's given evidence, everything done. There, comes back here, files a suit saying that I should not be allowed to proceed with the suit, my lord, in England.
What is the relief sought here?
The relief is that declaration I can't proceed, my lord, with the kindly comes to the, my lord, the plaint right away.
No,
at
here
page
he does
12.
not seek any. That's a divorce suit you have filed there.
Yes.
He does not
Here
seek
also,
any.
my lord, he has husband files another suit pending.
Oh, that's a different suit.
That's a different suit. In another suit, my lord, he only files for this.
Yes.
Starts off from 12. Lordship turns to 22.
So his divorce suit is also pending.
Pending here.
That was a prior suit.
That was a prior suit. First proceeding I have filed. my lord, in
Your suit was a prior suit.
My suit,
There.
their divorce suit is not.
So
filed.
Mukherjee is doing a job for the time being. Till he does not, will yes.
Then, beloved, your lordship sees the prayer here.
Yes.
Page 22.
Yes. Declaration.
Declaration that the proceedings instituted by the defendant before the Central Family Court, United Kingdom, instituted respectively on such and such, together with all applications, petitions, and orders passed, vexatious, oppressive, and without jurisdiction.
Now, second.
Then injunction, permanent injunction, was prosecuting, continuing, or taking any step or further step in or in connection with the UK proceedings being such and such. And then this is the suit, Willard, ad interim granted, saying that I can't proceed in England.
Mr. Chatterjee, under sections 13 and 14 of the CPC, Civil Procedure Code, now, if a decree would be passed there, it would be presumed that it's by a competent court unless you rebut. And unless those factors are not satisfied, section 13, it will be a valid decree, have res judicata effect. If that be so, why shouldn't the principle of section 10 also apply?
Yes, section 10, my lord, applies in my respectful submission. Section 10 is a different aspect altogether. Here, my lord, he is saying that I can't proceed with my suit there. Declaration that it's oppressive.
It's a subsequent suit.
Yes, but that's a section 10, my lord, we filed here.
Section 10,
Lord, there was
principle.
no-
Section 10 is both the suits within the Indian courts.
I bow down.
But even then the
But
principles.
he says it's oppressive. Declaration that a proceeding there, my lord, is oppressive.
Yeah, multiple litigations on same.
Lord, my respectful submission is that the prayer for
What is
anybody
that
has been
language?
granted, and he has appeared there and has taken this point as well, which the courts have denied him.
What point was taken? That is,
That it is, and below the courts have relied upon opinion, my lord, of a senior advocate of this country
to hold what? Turn
to hold
down
that only Indian courts have, my lord, and the trial court has relied upon it.
No, his suit was prior in point of time. Here, his divorce suit here.
Divorce suit here.
So thereafter, you file a suit there for same relief, divorce.
Yes.
He contests there. And there, what was refused to him there?
No, nothing refused to him. It was granted to me.
What?
What he said was that the English courts don't have jurisdiction. Just the
So they may have jurisdiction otherwise.
Yes, that's it. He said that English courts don't have jurisdiction.
That was turned down by the
Turned down. Gone to the High Court.
there.
Yes, Royal Court of Justice.
Refused.
Yes. Milord, here what happens is they have also gone there with this order. Milord, I'm wrong in saying that they've gone to the High Court there. The High Court went after this order was passed. This was taken, Milord, to the High Court there by us, saying that this is the order passed by the Indian court. The High Court there has said that the order of the Indian trial court should not govern the English courts.
Obviously.
So now the situation is that, but it's diverse.
So let us see the impugn order once.
Yes, kindly have a look at it and kindly see why this injunction has been granted. Anti-suit. It's on the basis of an opinion of a senior advocate.
No, that may be.
No, they can't use it, Pilot, in proceedings. Supreme Court says that, Pilot, even with judges is.
No, it has to be the independent formation of opinion.
Yes, and that is not there. In my respectful submission.
Let us see, yes.
Kindly have a look at it. Upon perusal of the pleadings, which is the 6th paragraph.
No, let us read from the beginning.
That's a factual situation. Very good.
Despite the defendant filed two separate petitions for divorce means?
I'll tell you, Lordship, why. There, my lord, what happens is, my lord, till your lordship reaches 6 months, my lord, inside the jurisdiction of England, you don't have, the English courts don't have jurisdiction. What happened is, we had come back, my lord, to India, and my lord, because we were asked to sit for a settlement. So I came back to India, so that 6 months didn't happen. So that court itself said that after the period of 6 months is basically, my lord, over, you can always file another one. That is why the second one. To, my lord, take out this question of jurisdiction. Because you get domiciled there if you stay continuously for a period of time. When we filed the first application,
first one was dismissed.
The first one is not dismissed, still on.
How can two
the courts directed us to file that to obviate that jurisdiction. And my lord, I presume they will withdraw the first.
The allegations are
Yes.
Yes, let us continue.
Yes. The plaintiff submits that the defendant was not a permanent resident of UK, and during her stay there, in student visa, she brought such divorce proceedings. The UK Family Court, despite the jurisdictional bar, entertained such divorce application and even passed maintenance order dated such and such, imposing substantial financial obligations. This is the reason why, my lord, this is fine filed. Upon the plaintiff, though there is law on this point that the applicant must be habitually resident in England and Wales for at least 1 year, immediately prior to filing of the petition of divorce. The petitioner has relied upon the order dated such and such passed by the learned such and such, rejecting the defendant's prayer under 151, seeking stay of matrimonial proceedings, and in this order, learned Additional District Judge, First Court, Alipur, has affirmed that Alipur Court has alone the jurisdiction over the matrimonial dispute between the parties. This is challenged in High Court now, and Justice Sarkar wants the parties to settle. So that is.
We also want the same.
Still
Go and
pending.
settle.
I don't have a problem with that as long as he pays off everything. This is like a
If there's an already order regarding settlement, why should we now?
No, that is a different
the last location before Justice Sarkar, that is exactly what fell from IFU. That is exactly what fell from Justice Sarkar, my lord, and they agreed on that.
Let them pay the alimony, then thereafter do whatever they want to.
If there's already an order, why you frustrate that by passing an order?
No, we are not.
They are circumventing the proceeding by of this
That is with respect.
Have a sitting, and if it can be resolved,
I have no problems on that. But here, what is happening is that they are continuing, Milord, with this order of stay, and this is creating a problem, Milord,
there's
everywhere.
a positive direction, a mandatory direction, then we could understand something would be frustrated. It's a restraint order, so it would facilitate only your mutual talks of settlement.
Milord, it's a restraint order on me not to proceed, Milord, with my suit in England.
Simultaneously, we are having a talk of settlement. We'll keep it after 2 weeks if you can settle the matter in the meeting.
Motion was this. Your Lordship will see why this is happening. That the prayer of ad interim temporary injunction is allowed. The defendant, her men, agents, servants, and assigns are hereby restrained by an ad interim order of injunction from prosecuting, continuing, or taking any step or further step, or in connection with the proceedings instituted by her before the Central Family Court, or any other proceeding or like nature between the same parties before any foreign court. No order is passed. Issue notice. Plaintiff is further directed to comply with the provision of the is directed to put requisites. Injunction shall not be passed against them. Be supplied to the plaintiff for information. So if they don't pay, I will not.
First of all, Mr. Chatterjee, their proceeding was an earlier proceeding.
Milord, the earlier proceeding for divorce.
Principle. Yes, you also asked for divorce.
Yes, I am also asking for
the divorce proceeding was earlier.
But the payment of alimony, Milord, is the only proceeding which is pending, Milord, in England.
No, there you have sought for a substantive divorce.
Yes, and alimony.
In connection with that.
Yes, Milord, definitely. So alimony orders have been passed there.
That he wants to avoid.
That he wants to avoid, my lord, by this order. This can't be done. My lord makes that clear. I have got no problems to. I have no problems to sit for my lord any sort of settlement. I am fine with it. But what happens is, my lord, that he creates this problem here, and he participates, my lord, in England, and then he says that no, I will not allow you to proceed there. May I ask this question to myself?
You could ask for alimony in this proceeding also because it is a prior suit. And you participated here also.
No, I have applied for section 10.
Here?
Yes.
This is the earliest suit. How can you get section 10?
Milord, 151 I have applied, Milord, in certain occasions there can be, Milord, a little departure from section 10.
151, yes.
Yes, we have applied under 151. Section 10, the principles can happen. That was turned out.
No, that was, an order was passed on that.
Yes. The revision application is from that. So I have no problems with anything. I want to settle, my lord. Obviously, the marriage doesn't work. There's no point in going ahead with, my lord, with anything of that sort. I have no problems in sitting for a settlement. But this can't be used as a tool to stop.
One is that your suit was his suit was earlier.
But he has two suits. This is one suit, and the one suit, my lord, the matrimonial suit that he has filed.
That is yours. No, he has also filed.
He has also filed a matrimonial suit.
Earlier.
There.
Here. I have filed there.
Here, his matrimonial suit filed here. He has only one suit.
No,
this suit. This is a separate suit.
He has only one suit, this suit.
I filed two.
Divorce suit only one.
Divorce suit one.
This is different. Divorce suit, his divorce suit was earlier than your divorce suit in UK.
Yes.
One.
One.
Secondly, he has taken a point of jurisdiction also that
Yes.
their law, have you asked for divorce on the ground of cruelty there? Because some counties, they include irretrievable breakdown as cruelty also.
Yes, Milord. That is one of the grounds.
That is one of your
One
grounds.
of
So
my
that is contrary to Indian law. That section
No,
13
I bow
comes-
down. Divorce won't be granted.
So prima facie there is a bar in jurisdiction.
Milord, there is no bar in a jurisdiction.
Section 13, the
Kindly
riders come.
have a-
Please come to section 13 once,
Yes.
Mr. Chatterjee.
Yes. When foreign
P.
judgment not conclusive,
Yes.
a foreign judgment shall be conclusive as to any matter thereby directly adjudicated upon between the same parties or between parties under whom they or any of them claim litigating under the same title, except where it has not been pronounced by a court of competent jurisdiction, where it has not been given on the merits of the case, where it appears on the face of the proceedings to be founded on an incorrect view of international law, or a refusal to recognize the law of India in cases in which such law is applicable.
So Indian law recognizes certain specific grounds and it has been held by Supreme Court 141, Article 141.
Milord,
that
here
irretrievable
I will
breakdown
show
is
you a
not
lot.
a ground till now, only apart from Justice Dhulia's judgment.
Exactly. Now,
That.
Justice Dhulia's judgment opens up the avenue. And that is exactly what my point is before your lordship on that. So it's not that the civil courts can't grant jurisdiction.
Not that prima facie it would be inconclusive.
Bow down.
So therefore, if that be
It
so,
can
then
go
second-
on, but it cannot be conclusive here.
No, that is the test because
That is the test in subsequent proceeding, Milord, if it is
No, res
instituted.
judicata tests
I'm
are
out.
applicable to section 10 also.
Completely bow down.
Because if res judicata would apply,
My lord.
if there was an earlier degree, then section 10
My
also
lord.
comes.
My lord.
The language is same.
Absolutely.
So you dispel this.
It doesn't say that it can't go on. If it is good or bad or indifferent, Milord, that is for the
What
courts to
about
decide
earlier
here.
proceeding?
Even if it's an earlier proceeding, my alimony is already granted and he has gone and appeared there.
You would be happy if we open up the alimony proceeding, the interlocutory
Absolutely.
proceedings.
Yes, my lord. I have got nothing else. He has filed this only to stall that, nothing more than that. He has appeared, my lord.
We'll
he
continue
lives
after
in
recess.
England.
Mr. Mitra will hear you after recess. We'll continue.
He lives in England. He comes here, my lord, for holidays.
Let him see.
The number of Teslas he owns there, it's not funny.
None. Zero.
Top Baba.
বাবারও নেই
Well, I'll just show your lordship 2 or 3 very small things and then Milord, my learned senior friend can. Well, kindly looks to the impugned order once.
Yes.
Why, Milord, this order was passed is important. Looks to Milord, your lordship has seen the first part. I'm not troubling your lordship with that. Aman Noito. I'm not troubling your lordship with Milord with the entire statements, Milord. Kindly comes to Milord after the judgment's been cited upon perusal of the pleadings.
Yes.
I'll just place that part, Milord, and show your lordship why, Milord, this interim order was granted. And upon hearing learned advocate for the plaintiff, this court is satisfied that the materials disclose a prima facie case in favor of the petitioner. The matrimonial proceeding before the competent Indian court was instituted earlier in point of time under the law governing the parties' marriage and has been presently pending adjudication. On the other hand, the case initiated in UK is beyond the scope of law, having no jurisdiction to try it. The maintenance amount as awarded is also not according to law and oppressive in nature, as is shown by the income tax return, and plaintiff is supposed to pay maintenance exceeding his actual income. So for that 2025 year, Milord, they have produced, Milord, an income tax challan, Milord, and showing that he doesn't have any income. And the court goes on to that and says that the UK's whatever evidence was produced in UK, that the learned court did not have the occasion to see. Then, at this ad interim stage, the balance of convenience appears to favor grant of temporary protection to the petitioner. Continuation of the foreign proceedings may give rise to multiplicity of actions and possible conflict of jurisdiction, whereas no apparent prejudice would be caused to the defendant if the same are kept in abeyance till the next date of hearing. From the materials placed, this court is further of the view that continuation of a foreign proceeding would cause serious and irreparable prejudice to the petitioner. The maintenance orders passed by the UK Family Court, despite its lack of jurisdiction, appear to impose onerous financial obligations which the petitioner is not in a position to sustain. Compliance with such directions has already affected his financial stability and exposed him to coercive measures abroad. There is also pressing urgency as the next tranche of payment under the UK order falls due in November 25, and further coercive directions may be issued if not restrained.
Was any challenge filed against the UK maintenance order?
No, my lord. Subject to correction, no. Then kindly looks to Milord what the learned judge has seen this, sees what he has said, Milord, in UK. Milord, if your lordship turns, rather, Milord, I will first show your lordship his plaint which he files. Have a look at page 83. I'm sorry. No. Kindly have a look at page 83. This is his plaint here. Just to dispel, my lord's doubts with respect to irretrievable breakdown of marriage and whether, I'm using that there. Volume 1, page 83.
Yes.
Starts off from page 83. Kindly turns down. Team.
Yes.
At the end of page 86, yes. In fact, the matrimonial relation has irretrievably broken down and there is no further scope of reconciliation. He has taken this ground here. And that's at paragraph 17, 18,
So it's not a question of
19.
his stating that it had irretrievably broken down.
Milord,
It's
the
a question
Supreme Court
whether it's a ground of
available or not. Milord, I'm reminding your lordship about Justice Dhulia's judgment, Milord, 2023 17 SCC 433.
You formally cite that also, but just let us complete this. Yes.
Yes. Now here, Milord, I'll show your lordship that Akun Devanna. Now, Milord, the ground is available to us here in India as well. So this is not something, Milord, where I'm playing fraud on court and doing something, Milord, which I could not have. The court prima facie finds, Milord, that the courts in England don't have jurisdiction. That itself, Milord, on the face of it is wrong. Milord, it is an admitted position by them that they are, Milord, going on with the proceedings in UK?
In the UK court, they have appeared, you say.
They have appeared,
Have they
filed
taken
a
a
written statement.
Have they taken a jurisdiction?
Yes, they have.
Question.
They have
On what
refused,
ground?
saying, my lord, that this court doesn't have jurisdiction. This court doesn't have jurisdiction. I'm saying refusal. Why? Because the court has ordered them payments. Has ordered them payments, and there will be a hearing on, my lord, this part on a later date.
On the jurisdiction.
Yes, my lord. So what happens here, whether you have jurisdiction, it's on, my lord, at this point. So they have taken a point there. Now, my lord, my respectful
It not be on now in UK.
5 hours. কত দাদা 4.5 ঘন্টা না 5.5 ঘন্টা 5.5
Anyway, but
they would know better.
তোমার চেয়ে বেশি কেউ ট্রাভেল করে। Your tidbits in UK, Mr. Chare. Absolutely.
গল্পের গরু গাছ।
But
so, my lord, I will just show your lordship, my lord, their opposition. Kindly turns to page 507, first statement. 507, that's at, my lord, yes, it's in volume 4. Have a cursory glance, my lord. I'm not going to place your lordship the entire thing. Have a cursory glance. See paragraph 6 at 508.
508.
See paragraph 6. Their point with respect to, my lord, UK courts not having jurisdiction is taken here as well. That's at paragraph 2. Then, my lord, on merits, they've gone on to say, my lord, paragraph 6 is with respect to whatever has happened, how the settlements were going on. On merits, they've said, with respect to his income, my lord, that also has been, my lord, stated. If your lordship comes down, way down, kindly have a look at 515, financial resources. My lord, the first the property, my lord, he's invested somewhere in Portugal. That's what he says. And this flat, my lord, he has said that because he wants a golden visa, my lord, from Portugal. So that's I would say, my lord, a luxury thing that he wants, that anybody with some sort of money will have a property somewhere and apply for golden visa. That itself will show, my lord, the amount of money he has. Then he goes on to show, my lord, the shares that he possesses. He is the chairman, my lord, of Monocon. He has admitted that. Entirely, my lord, if your lordship sees from his list of dates given, they were there, my lord, in England forever. After marriage, they all stayed, my lord, in England. They used to come to India for the festivals. If your lordship sees, it's all on there. So my respectful submission, my lord, and it goes on forever, my lord, I can take your lordship to everything what your lordship wants. My respectful submission is, once you have appeared there, once you have taken a point and a hearing is on the ground of jurisdiction, the Indian courts didn't have a jurisdiction to say that you don't have to comply with the UK court's directions. Whether that will operate as a res judicata here is something different. That is not for something for the court to see, my lord, at this stage. Irretrievable breakdown of marriage, but now if your lordship can see that. This satisfies your lordship 2023-17 SCC. 2023-17 SCC, page 433. Kindly have a look at below paragraph 22 onwards. And how irretrievable breakdown of marriage becomes a ground. And your lordship, relying upon this, has also delivered a judgment. I have that with me as well. I need not multiple. But this is what it is. Since your lordship knows about it, I'm not wasting my lord's time. 22, 23, 24, 25. And he himself is saying, my lord, that it is irretrievably broke down because they are living separately from each other for a very long time. Marriage, my lord, happened in December 18. From, my lord, around 2021, my lord, the problem has started. The problem is somewhere else. We have a different take on that. But now at this stage, your lordship is not, my lord, interested to get into that. So I say, my lord, the findings are perverse. The findings are completely perverse because it doesn't even look into the UK law, which says that if you are a domicile for 1 year, you have the jurisdiction to file for divorce there. They have taken a point there. It is for the courts in UK to decide whether they have jurisdiction initially. And whether that decision will be binding or not will may not happen under when a situation arises in terms of section 13. Premature. Whether, my lord, the courts in UK passed a wrong order, the civil court in here, my lord, rather the matrimonial court in Calcutta or in Alipur would not have the jurisdiction to say, my lord, that the UK's court on merits was bad. He can say a lot with respect to the points under section 13. He can say under section 13, but not say that court was, my lord, incompetent or did not have, or on merits it is wrong. It can say it's incompetent. It can say it's incompetent when the second, my lord, the proceedings happen under section 13. So this I say, my lord, the judgment itself is completely perverse.
Yes, three grounds are available to me on for anti-suit injunction. First is that forum non-convenience, where that's not a forum, that's a forum non-convenience. Number two, not recognized under section 13. And number three, oppressive. Forum non-convenience, not the natural forum having jurisdiction. Lordship kindly takes a look at the page 28 first, Lordship. Page 28. Smallest of points I'm starting with, page 28. That is, page number is not very clear. That is after page 26. After, kindly see page 26 and then 227 is page marked. After
of the
that,
stay application.
Of the stay application. 27, the page after that is not typed here. So 20.
In our copy, there's a printed page number.
Oh, very well. Page 28 is the marriage registration certificate.
Yes.
And the Hindu Marriage Act.
Yes.
In Calcutta. In Calcutta. Then Lordship kindly sees that he is.
They are domiciles of where?
Calcutta. Page 32.
England. In England, they are domiciles.
That's something I will show just now. Page 32. Page 32. Her passport, permanent resident of Calcutta. Sorry, it is my passport. Her passport is page 37.
Place of issue is London.
32 is my passport.
That's of London.
No.
Place of issue.
Port of issue, yes. Place of issue was in London, but resident of Calcutta because he was working there. Now kindly come to, at that time, kindly come to page 37. The lady's passport, that is the defendant's. 37.
Almost illegible.
Place of issue also is Calcutta and address next page. Fairly illegible.
Place of issue, yes, Calcutta.
Place of issue, Kolkata, West Bengal, and place of permanent residence is Kolkata, next page, page 38. Then Lordship kindly comes to the lady's Aadhaar card, page 30. Aadhaar card is Calcutta, Mihir Prakash Bajoria. So Mihir Prakash, that is mine, and what about hers? Hers is ladies, respondents. Respondent page 29, page 36. Aadhaar card respondent, page 36, Salt Lake City. Now, Lordship kindly sees she's the statement was that she's a permanent, that permanently residing. Kindly see her own statement in the UK court page, kindly come to volume 3. Her statement filed, page 281. This is her statement filed on 9th May in the UK court. Page 281.
Yes.
Kindly come to page 286. Paragraph 9. Notwithstanding the above, my life is and continues to be London. I have a new student visa, commenced from 6th December. And as I'm undertaking an MSc Psychology in the University of East London. Student visa.
I have lived in England since 2015.
Yes, because she was a student in Bath. That's what she has said. Because she was a student in Bath, and thereafter
2024 is a new student visa.
So on a student visa.
But she has been living in England since 2015.
As a student visa. As a student, I'm showing the student visa.
When did your marriage take place, Mr.
Marriage in Calcutta.
When?
That is 2018.
Achha.
Now,
before that, both of you were residents of England.
I was working in London on a work. There's no more there because I had to come back because I couldn't afford to live there. She was studying in Bath, and as she has said, there was they fell in love.
They've said that I was there as on a work permit. They've said 514.
I was just coming to that.
That's very well, Mr. Mitra. Let us.
What about that? But if she came, she was student in Bath, and that's how they met. And Lordship kindly comes to page 282.
282? Yes.
22.
Page 282. 282.
Yes.
Paragraph 4. I have lived in England since 2015 when I first moved to Bath to pursue a master's. At the conclusion of my studies in 16, I remained in England because Mihir and his family begged me to stay and assured my family that they would take care of me. Since then, I've lived at so-and-so, which was our first matrimonial home before moving to flat number so-and-so. Court will be aware from reading my first statement that I was responsible for the entire renovation so-and-so. So she went as a student. She's presently as a student. In between, Lordship kindly comes to her work permit. Lordship 514. Lordship kindly comes to because I helped her get a job. She was working in London in my company. So she got a work permit. That job she did not have and doesn't have anymore. Now she kindly comes. So last 1 year, where was she before filing the case? The same document kindly comes to page 284. 283, the sequence of dates are given, page 283, paragraph 8. Paragraph 8, a more accurate chronology of the breakdown of the relationship. Kindly come to the next page. May I show page 283 once more. 28th September 23. I messaged the Bajoria travel agent about flights to Kolkata, flying out on 10th October and returning to London on 20th November. Kindly turns the page to page 284. December 23. No, sorry, 9 January 24. I returned to flat number 58, Academy Gardens, London. So 30th, and then Lordship sees 31st October. 31st January 2024. I fly back to Kolkata. And then Lordship kindly turns the page. 7th May. 7th to 10th May 2024. I returned to flat 58. 7th to 10th May only. 24. I returned to flat 58 Academy, London. I'm forced out of the flat number 50 and moved to hotel. I meet with me at the hotel and agree to return to Calcutta with him to work out our marriage. Then we spent time together over this. And then the giveaway is the last date here, 19th August 24. I returned to London and stay in flat 14. So between January and August 2024, she was in London for 3 days, 7th May to 10th of May. And then Lordship kindly comes to the state copy summons. Yes. Lordship kindly comes to page 340. A volume, yes, same volume 340. Paragraph 36.
Yes.
Unfortunately, a marriage has experienced difficulties. She goes back in August, para 36, last 3 lines. Last 3 lines of para 36. He was aware from 19th September. However, on 19th September 25, became aware that Mihir issued divorce proceedings in India on 4th September 24. So 19th September, she became aware of the divorce proceeding. And this is not suddenly out of the blue because before that, while in Calcutta, kindly comes to page.
Before that, Mr. Mitra, there is usually a jurisdiction clause in these applications in UK. Now, regarding the forum, how has she claimed
Yes,
jurisdiction?
I'm coming to that. And the
Has
UK
it
court
stated that she is a domicile or something?
Show me that order.
Must be some clause in that.
The divorce petition in UK
Yes.
is that which is also very interesting, Lordship. As he said 6 months, it is actually 12 years. 12 months. One has to be in UK to file a permanent residing. Now, Lordship kindly comes to it is 12 months.
One has to be
12
there.
months or 6 months.
12 months.
She has to be permanently residing in UK.
And that's why the second
Apparently, she was there from 2015, came back and fro.
She was. It has to be continuous, and I will show from the judgment itself. Show me the. Show me the.
Page 406.
16 May. Kindly comes to page. এটা পড়তে পারা আছে বলে বেটার কপি আছে বলে কোথায় বেটার কপিটা কোথায় আছে বললে kindly comes to the order page আর্টিকেল লাগানো আছে বেটার কপি লাগানো আছে কোথায় বললে page 495 to B 659 na 661
Or domiciled in England and Wales. She was not domiciled.
I will just now show. I will just now show something. Kindly comes to page 661. 661. That is the order. On that day, there are 2 orders passed. Firstly, kindly comes to 659. That is the not alimony, but interim maintenance order. 659. Mutual divorce journey. Anyway, page 659. Yes, a mutual divorce application.
Yes.
That is the maintenance. The appellant will repay to the respondent such part of the amount. Kindly come to the next page, 660. Order. The respondent shall pay to the applicant maintenance pending suit until the date of final divorce. It is an interim order in the divorce proceeding. And the divorce proceeding order is next page, same day, 661. First paragraph 3. The divorce application under case number so-and-so was issued on 10th October 2024. If jurisdiction remains disputed by the respondent, the applicant intends to have issued a new divorce application on 20th August 2025 on the basis that it will reduce the issues of the court. So she admits that, and Lordship kindly comes, the issues framed. No.
This was the first suit. After that, she filed another suit.
Which first is also pending. Second.
You have sought for a stay of the second suit.
First and second, both. Now, Lordship kindly comes to 662. What is the agreed order? Paragraph 5.
Yes.
The parties shall jointly instruct Geeta Luthra as a single joint expert in respect of Indian law with the following directions to apply. The letter of instruction shall be drafted by so and so. Now, what will be the issues which will be on which Geeta Luthra's opinion, page 664. Appended questions to the expert. How does the Indian court treat parallel proceedings in another country?
This is an expert's opinion at best.
That's what they asked for, expert's opinion. Expert has given an opinion that I will show that the Indian courts will not accept it well, that under the irretrievable, and I will just show them my petition that divorce petition, first divorce petition.
The expert's opinion is not binding on either.
Not binding,
us.
not binding, but then here
we interpret the law in our own way.
So what I'm saying that the UK court wanted an expert's opinion.
Yes.
And now, and also it found that the court jurisdiction.
Also taking expert opinions every day from you. But
And
that's on what we premise our judgments, in fact. Actually. So therefore, I mean, all of you, not only you.
Now, Lordship, so what I am showing is really paragraph 3, that the court's jurisdiction, and she has in fact filed on 20th of August.
Which page?
Page 661. I showed that the court itself noted that the court question is there, and she has accepted that, and she's filed a second divorce petition in 20th August 20. Now, Lordship, kindly sees page 387. The divorce petition, Lordship wanted to take a look at the first divorce petition, 387. Uh, 386. 386. Residence. I know, my Lordship, that's the law, that irretrievable breakdown of marriage can be an evidence of mental cruelty. Irretrievable breakdown of marriage
in UK also is the same. There's no ground for irretrievable breakdown.
Only,
but it comes under cruelty. No. The definition of cruelty includes irretrievable.
So kindly takes a look. Reasons for divorce, page 387 in the middle. No cruelty at all. Reasons for divorce in the middle, applicant has confirmed their marriage has broken down irretrievably. That's only, not mental cruelty, which amounts to irretrievable injury. I mean, which is evidenced by irretrievable breakdown.
This is the component of cruelty in England. In most of the counties, at least, I don't know about.
I really would not know. I have not explored that.
I did matters when I was there, and this side also have played. Apparently, anyway, let us not proceed.
So basically, not mental cruelty evidenced by irretrievable breakdown of marriage. It is by virtue of only irretrievable breakdown of marriage. And I will show the recent judgment considering Rakesh Shilpa Shet. Also, Supreme Court has continued to maintain that irretrievable breakdown is not a ground in Indian law. Supreme Court can, under Article 142, for bringing to an end. I will show the latest judgment of the Supreme Court.
It has considered the other judgments.
Rakesh, Justice Dhulia's judgment, the Shilpa judgment, all of them.
Samar Ghosh. Rakesh Raman is Justice Dhulia's judgment.
Yes. After considering Rakesh.
Samar Ghosh was way back.
But Samar Ghosh is relied on by.
Now, Lordship kindly comes to. So, irretrievable breakdown is the only ground. Now, Lordship kindly comes to the second marriage, second divorce application, that is at page 431. Volume 5, volume 4, 431. 410 it starts. 410 it starts. Lordship kindly comes to 430. Statement of truth, etc., etc. 430.
Admission of.
কোথায় বলেছি it will break down to কোথায় বলেছি it will break down to কোথায় বলেছি এখানে সেম জিনিসটা বলা আছে same thing is recorded here. The ground for is irretrievable breakdown of marriage that I will just show.
Domicile has not been ticked. Page 429. Yes, 428 read with 429. Habitual residence as domicile are two different jurisdictional considerations. Page 428. That's
Yes, habitually resident in England and has resided there for last at least 6 months immediately before that. So habitually resident plus.
But the next page 429, she ticks both parties to the civil marriage are habitually resident, but leaves domicile blank. Is domiciled is not ticked. If you see the third tick, the applicant
is habitually resident in England and Wales.
The box
and
after that,
applicant is domiciled and habitually resident in England.
not ticked.
That's not ticked. And the lordship sees
She says that she's a habitual resident.
habitual resident and has
resided
resided there
Next
for
one, yeah.
at least 6 months. So the first one, she did not say that. She could decide because her passport shows she was not a habitually resident. That she has resided there for at least 1 year immediately before. That part was not met in that one. Because from January till
So therefore
August,
she files a second suit also, which
so,
you have also
so
asked for
that the
stay.
first case, she gets a maintenance order.
In the second one, no.
Second one, no. Second one, that first case only, in spite of the second case being filed, the first case order is still
In the
going on.
first question, jurisdictional issue has been postponed. I mean, it's still there.
It is still there, but after filing the second petition, and after now with the expert's opinion, which the court itself called for, that will be decided. Now, Lordship kindly comes. So why haven't
The expert has said what? That Indian law is not what?
May I just show, my lord, that she couldn't have that Indian law will not recognize this ground of divorce.
That's her opinion.
That's her opinion.
Might not
That
be
that the Indian courts normally will not stay an earlier proceeding.
These are vague, sir.
Earlier proceeding.
We have to go by the law.
To go by the law. I will go by.
We are just asking you. I mean, what?
Yes, and also that Indian courts will not recognize the judgment because of the Section 30. It will break down of marriage, and I will show a Supreme Court judgment also on that. That if a divorce is granted on irretrievable breakdown of marriage, that won't be recognized under Section 30, because it is not mental cruelty evidenced by irretrievable breakdown of marriage, and that was what I placed before the learned judge.
But Justice Dhulia's judgment takes it as a notch higher, that it's cruelty to each other.
Yes, so it's an evidence of cruelty. So it's an evidence
without
of
even not without any motive of, I mean, hurting. That is where it has been taken, because Justice Dhulia's judgment, para 23, 25 says cruelty can be even unintentional, and 22 says irretrievable breakdown of marriage may not be a ground. It says that, but cruelty is marriage can be.
Marriage
But
can
then
be
para
dissolved.
23, it is the Supreme Court
A
says
marital relationship which has only become more bitter and acrimonious over the years does nothing but inflict cruelty on both sides. To keep the facade of this broken marriage alive would be doing injustice. Now, whether this is
it carries forward.
Marriage has been broken irretrievably, in our opinion, spells cruelty to both parties, as in such a relationship, each party is treating the other with cruelty.
Next sentence.
It is therefore a ground for dissolution under 13(1)(a), that is mental cruelty. 13(1)(a), mental cruelty.
13(1)(a) is cruelty.
Yes, I mean, in this case, nobody is beating up.
Obviously mental.
Cruelty has not been defined under the Act. All the same,
Yeah.
all the same. Now logically sees the well. I actually would have liked.
So the Supreme Court says in this judgment, marital relationship which has only become more bitter and acrimonious does nothing but inflict cruelty, keep the facade open. A marriage which has broken down irretrievably, in our opinion, spells cruelty to both the parties. As in such a relationship, each party is treating the other with cruelty. That's read into it. It is therefore a ground for dissolution.
So it is.
So just by living apart and it's being broken down irretrievably.
So it may be a ground of in support of mental.
It's brought under 13(1)(a) by
13(1)(a).
This part is not 142. This is 141, Mr. Mitra. Article.
Well, what you kindly see is cruelty has not been defined under this Act. All the same. So, para 24. All the same, the context where it has been used, which is the ground for dissolution of marriage, would show that it has to be seen as a human conduct. So, cruelty has to be seen as human conduct and behavior in a matrimonial relationship.
Breakdown has been brought within the ambit of 13(1)(a), which is cruelty.
But I would put it this way, this judgment, yes, that is an act of cruelty if it's it's impossible to stay together. It's become so acrimonious that it's broken down.
Both of them are admitting that.
But
both have filed divorce suits also.
So in that
Different
case,
grounds, but
if your lordship, and here of course mental cruelty is also is the ground. Cruelty evidenced by irretrievable
in
breakdown.
your petition also you have stated divorce petition that
That is there, but then there are evidence of cruelty, and I will show that. So mine is filed on 10th of September.
Just interrupting my learned senior friend, if I just can, Milord, the Supreme Court has gone into this similar facts completely about irretrievable breakdown of marriage and filing suits, Milord, abroad. This is what it says.
No, what is this?
2018, 17 SCC, page 12.
You should have cited this at the outset.
Both are US citizens in that case.
No.
You should have cited this, Mr.
I'm
in
sorry,
the
Milord,
midst of his arguments.
I wanted to shorten it as much as I could.
Cut him short and just
No,
cite
it's
judgment.
better, Milord, if he looks at it. Kindly have look at the.
If I'm not mistaken, if this is the same judgment, the both were UK word.
Which para?
Dinesh Thakur.
Milord, Lordship will see paragraph 12, 13. 12, 13, and then 22. This is on anti-suit injunction.
Paragraph 26 bolli.
22, Dada.
22.
12, 13, 22.
Kindly come to paragraph 21, the previous page. Last two lines. There is no dispute to the fact that both are parties are permanent citizens of US. Undisputedly, the Circuit Court Florida is also having concurrent jurisdiction in the given case. Here, the English court itself says that its jurisdiction is doubtful.
21.
That's in the first suit.
First suit. Second suit has been filed now, but then I'm still going on paying maintenance as per the first suit order. I shall separate my argument that is on the oppressive point. And Lordship kindly sees paragraph 3. My junior rightly points out paragraph 3 of this judgment. Just 2 lines above placetum G. Both the parties got the citizenship of US in May 2003.
Paragraph
3. Placetum G.
Of Dinesh Singh Thakur.
Yes. Page 15.
Yes. Placetum C.
G.
Yes. G.
Just above 1 line above G.
Both the parties. Yes.
So US citizen from 2003.
Para 21 also is stated.
Yes. But this is from 2003 it says. That is not mentioned in 21. And the divorce is filed much later.
Here also facts were similar. I mean, in Indian court granted anti-suit injunction.
That I will just. The London District Judge, while granted the ex parte injunction.
Yes.
Set aside. Was granted, then set aside.
Would an appeal be maintainable, Mr. Chatterjee?
No, but here, but I have a. Well, I have a maintainability point before that.
It's not an order 39 rule 126.
Okay, before that,
not
please
property.
see page 609. Before my lord put 151. Can you see page 609 once?
He has applied for an order of
No,
injunction
Lordship, kindly-
training.
Well, I have on
The 39 is not just property.
page
Have a
609
look at-
though.
Look at
No, double.
this is important. Your Lordship, kindly see.
Double
that.
double anti-suit. Lordship kindly comes to 699 one. But on this issue of maintainability, I would have come to that because normally I don't want to.
Mr. Pitru,
Because immediately after getting this order,
yes.
anti-suit, they have elected for a remedy. That is page
The
699.
matrimonial suit, whether an injunction is passed under order 39 rule 1 of this sort.
Not under 39, but under section 41, yes. 39 rather.
Does it satisfy any of the criteria of 1 or 2? 151. I was filed under 151.
He has filed under order 39 rule 1 and 2, though
Yeah,
that
can be
doesn't
material.
matter.
Yes.
In any suit for restraining the defendant from committing a breach of contract or other injury of any kind, whether compensation is claimed in the suit or not, injury of any kind. It should fall under that. The plaintiff may at any time after the commencement of the suit and either before or after judgment apply to the court for a temporary injunction to restrain the defendant from committing the breach of contract or injury complained of, or any breach of contract or injury of a like kind arising out of the same contract or relating to the same property or right.
It arises from a contract.
Or right, or breach.
Breach of contract or other
Or
injury of
other injury of any kind. Injury of any kind, that is broadly speaking. That is broadly speaking.
court shall grant temporary injunction to restrain defendant from committing the breach of contract or injury.
Or injury. Or injury. So his injury, my lord, is my suit there and continuance of that suit there. That's his injury. So it comes under two. One, no. One is only on property.
Or any breach of contract or injury of a like kind.
Yes, my lord.
Arising out of the same contract.
Absolutely. Or right.
Please come to the second part of that.
My lord.
Apply to the court for a temporary injunction to restrain the defendant from committing the breach of contract or injury complained of, or any breach of contract or injury of a like kind arising out of the same contract.
Or relating to the same property or right. Or right.
Very good.
Now,
continue.
Now, kindly, apropos mental bit, I would have come.
Yes.
699, last page.
699.
They had an election of challenging the order of the learned single judge, but they elected some other course of action.
Single judge of UK court?
No, of the Indian court, which has granted the anti-suit injunction in UK. They had the option of filing the appeal, which they have done. But
Yes.
before that, they have elected a different course of action. They have gone to the UK court, page 699, and got one of the only UK courts can do it, totally unreasoned order.
Yes.
Staying my order of the Indian court, asking me to withdraw the case. Logically, C69. This is something to be seen, to be believed. At least, had this been an Indian court, then there would have been a lot of hue and cry over this kind of an ex parte order. Kindly see the first page.
Yes.
Paragraph 4. The Indian divorce proceedings are the divorce proceedings taking place so and so. Paragraph 5. The Indian interim anti-suit injunction is the 1st November 25 injunction made against the appellant on the application of the respondent in the Court of Civil Judge, Alipo. The Indian maintenance pending suit and LSPO summons is the summons issued. Is the summons filed by the respondent in India under case number so seeking an order the applicant repays to respondent maintenance pending suit so and so.
This High Court is the equivalent of a district court there.
High Court.
No, this is the family division. I would not really. This High Court. Page 700.
What is the appellate forum?
Study next to.
What is the appellate forum against this?
The Royal Court of Justice. Royal Court of Justice.
No, against the High Court.
I don't know whether from an allegory what the appeal lies in.
Against this order.
Yes, Lord. It's in the High Court of Justice, Family Division.
The appeal against this lies where? In there?
Against this will lie to the Privy Council.
Not the Privy Council. How can we?
Supreme
If at all, Court of Appeals. If it's an appealable order.
Well,
before Court of Appeals.
Before it's just by the.
What is the hierarchy there, Mr. Mitra? I'm not sure.
The High Court, Court of Appeals, Supreme Court, which is House of Lords, Supreme Court. Privy Council doesn't come into
this. High Court has jurisdiction over a particular county or.
But the English High Court will I would not know the territorial jurisdiction because I did the bar. I did my LLB and
the entire country.
Masters. So maybe the Bombay High Court type of jurisdiction.
This is not Royal Court. This is High Court.
That's inside the Royal Court of Justice.
All right.
Now the order is
where the hearing takes place inside the Royal Court of Justice.
It is called Royal Court of Justice.
So this is a superior forum than the court which passed the first order.
Yes.
Then that is
there.
Superior forum.
So they obtained an order from a higher court there.
Higher court there. After
it is roughly equivalent to our high courts.
Roughly equivalent to our high court. Now, Lordship, so they challenged basically our Indian order to go to UK court. Paragraph 15. Until the return of others is prevented from relying within the English divorce proceeding on the Indian. That's in respect of the Indian anti-suit injunction must not prosecute, continue, or take any further step in or connection with the Indian interim anti-suit injunction, save that he must forthwith apply in India for the discharge of the Indian interim anti-suit injunction, and for the Indian interim anti-suit injunction application thereafter will be adjourned to a date after the final decision of the English proceeding. So they have taken, and then C must not take any steps to enforce the Indian interim injunction suit. So they have taken recourse to this course of action and got this order. So, and also Lordship will CE in respect of the Indian maintenance pending suit, and maintenance pending suit is there's only a divorce suit, and LSP or summons must not prosecute, continue, or take any further. And B, save that he must forthwith apply in India for the dismissal of the Indian maintenance pending suit.
Yes.
So this recourse he took on the 10th of this is on 10th of
undertakings given to the court.
That is that's a standard undertaking which is which I find even in the earlier court. That is the given to the court by the applicant.
Oh, that is the applicant.
Upon the applicant.
That's different. Relief is different. Yes.
So having taken recourse to that, whether it is why should they be allowed to do? But that's well that apart. Lordship kindly comes to they went to UK alive after having explored. Lordship kindly comes to page 60. 60. My specific case on averment today is that from October 2013,
60 is a
yes.
WhatsApp message.
Sorry, 62. This is from Anand Prakash Agarwal, that's my advocate, to Vidushi Jain. That is the defendant. At instructions of my client, Meet Prakash Bajoria, I am sending herewith draft of memorandum of settlement between my client and Vidushi, consent petition under section 13B of the Hindu Marriage Act, and petition for dispensation of waiting period of 6 months. And the petition is annexed to it. Next, page 63 is the settlement, and 73 is the mutual divorce petition, to which can you see her response. Her response is at page 81. At the time she was sitting in Calcutta. Please find a document attached below. Kindly come to page 82. We had receipt of your mail under section 13B, noted the contents. 1. Vidushi Jain Bajoria has never asked for divorce, and only your client, Meet Prakash Bajoria, desires this divorce. Meet Prakash Bajoria alone does not have the sole absolute authority to decide the terms and conditions of the settlement under 13B. All the terms and conditions will be discussed threadbare and decided whatever is justified. All settlements should come prior to the date of execution. So divorce was being discussed in Calcutta. Thereafter, we filed at page 83 the divorce petition in Calcutta, the matrimonial suit.
Was the UK court this page 699 passed earlier than the present tribune order? Which was the earlier one?
699, yes, after because their ground is how could the Indian court stay the proceeding in UK? So you stay the Indian court's order and you stay the Indian court suit and you ask him to withdraw everything. So that's why I'm saying they elected the English court, rightly or wrongly, because of course I am not saying rightly, that to stay our civil court's order. When they say that you are so rich and I can't afford, well, that's something prejudicial fact, please ignore it. Somebody who can afford to go to UK, be on a student visa, get enrolled masters from 15 onwards. Now Lordship kindly comes
and work in your company.
I had temporarily provided, yes, I have said so. I had helped her get a job. Page 83. Not my company, where I was a judge, where I was the director. So this is the suit filed on 10th of September. Served on her on 19th September. And after the divorce discussions begin, she goes off to UK on page she returns to UK on, I think, August 2024, Lordship. That was the page 286. I will just tell you, Lordship, one second. She goes to UK. Yes, on 19th August 24. And now I'll come. Income return টা কোথায় আছে? এখানে না, সেখানে page 481. UK. More than what I was earning, even in UK when I had the job.
Why is this relevant?
Oppressive orders. Because payment order is oppressive. I have not submitted to that court jurisdiction. So I don't want to go and challenge this in that court, because I have initially I did not come rushing because Lordship, tell you Lordship why? Because they filed a section 10(151) whatever for stay of the Indian suit, which they kept on deferring, adjourning, but ultimately we got it to be heard. And where is the order? That order was passed in page 164. This order is passed, page 164, volume 2.
দুটোই মাটি ছিল, এই ভলিউমটাই মাটি ছিল, মাটিগুলো রাখেন।
Not to invoke the judicial lordship comes
164,
volume 2. Volume
yes,
2. Go to 479. You put 479.
Page 164. Extremely well written order.
From this, they filed revision. I could understood they got that stayed, and then they filed the appeal. First, they went up in English court and got the order stayed. Then they come to the other court where they only offered settlement, because I said very clearly, I'm willing to settle so long as you get it out of your mind that you are married to my father. You are married to me. Like I tell when I appear for a male client Indian, that forget that you're married to your mother. You must, like, similarly, like, you are married to only me. So go by my standards, I will settle. And this is the love marriage. Love marriage. That is their case also. This is an admitted position.
And what turns on that?
No, I mean, not that you are lured by my father's so-called wealth. Your father is no less wealthy, but still.
There's a question of who lured whom.
Anyway, now Lordship.
I get lured.
Yes.
Now page 481 is his UK return. কোথায় অ্যানালাইজ করা আছে ইনকামটা? আমাদের পিটিশনে বলা অ্যানালাইজ করা আছে ইনকাম। Page 481. My UK return is for 2000. Theirs is calendar year. Calendar year £227,199. Tax deducted 89,000.
Why should you go into the merits of this, Mr.
Well,
Why should you go into the merits of this?
oppressive point. From the oppressive point.
You can't adjudicate on this, on the incomes and
This has to be adjudicated upon, certainly. But the prima facie oppressive nature.
Why do you say it's oppressive?
Because what I've been asked to pay as maintenance is more than what is my income UK return.
No, but can that be judged by a particular order passed in a proceeding?
One of the factors,
oppressive, the proceeding has to be oppressive against you. That the matter is proceeding, this very fact has to be oppressive against you. That I cannot go there and contest or some other reason. One particular order passed in that is oppressive, probably, Mr. Mitra, would not be the test, subject to you correcting us. Because oppressive, the suit, because as you rightly said, Mr. Mitra, forum non-convenience, section 13C, and oppressive. The proceeding there, my contesting the suit there is oppressive to me. Not a particular order, probably. We won't go to that extent. Order may be oppressive, we may challenge that, that's different. But my going there and contesting is oppressive. We don't find that here because you have been living there for a considerably long time.
Then I gave up my job. It's my specific case because my salary was being entirely paid. So up to August 24 I had a job in UK.
But at the time when the suit was filed, you were there.
No, August 24. I was not there. That is also, Lordship, kindly sees page. So
as of today, you have left that job and come back.
August 24.
You have left that job and come back.
In October 23, I left. Lordship sees my averment in page 15. Page 15, my plaint case, and I will show that's borne out by his dates also. From October 13, I have come back to India.
That is before filing of this.
Huh?
Before filing of their suit.
Before filing of our suit,
both
1 year before that, because ours in September, theirs in October. Or 15 paragraph I. October 23, both parties returned to India and began residing at plaintiff's family home at 14/1A, Burdwan Road.
But she says she has gone back.
Now, Lordship kindly sees she went back. If one goes and spends 3 days, 4 days. Now, Lordship kindly comes to their averment. This I will show that what I have said, apart from at this stage, this is not yet disputed. Kindly see. Yes. From their statement filed in UK, one can possibly make out that is what I have said is possibly correct. Prima facie correct, at least. Page 281 is the statement. So that's why I stress on the student visa and filing the case there. 281 goes back, enrolls in a college.
Yes.
281 is the statement. 282. Paragraph 6 at page 282. Mihir says that our marriage ended October 23. That's a year before the divorce case of her. I disagree. From October 23, I began to spend more time in India because I was requested to do so by Mihir and his family to reconcile our differences, and save our marriage. However, I never left home. My home, 58 belongings as my everyday possession, remained there. Even though I traveled to India, I returned home flat 20 whenever I could. That I will show 2, 3, 4 days.
But still she's there only and her flat is there still.
Not her flat. Whatever. She claims that is my father's or mine invisibly held flat. That is her case. The specific case is that it is not her flat.
It's your flat.
That's her case. That's the ground. See their apartment where I used to stay.
Your case is that it is not your flat.
I used to stay there. Yes, I used to stay there. This is neither owned by me nor my father.
Not owned by you.
No, nor any entity where my father and me directly or indirectly control shares. Rest of it,
Your father may reside there. You have no.
Father is permanent resident of
maybe
Calcutta. So it is nobody's case that is my flat or her flat. Now, Lordship, from October 23, she has been more or less residing in India. So whenever she can, she goes and stays there. Now, Lordship kindly sees that that is her matrimonial home, she has called it. I'll just show it. London fact.
After your marriage in India, you went back there only.
Yes, yes, because I was working there. I was working there at the
That
job.
was your matrimonial home, in a sense. I mean, in all senses.
Her matrimonial, yes, so my matrimonial home also.
Her matrimonial is also your
Yes,
matrimonial.
matrimonial home, but they're two different flats. She only says, firstly,
14 and 58.
now Lordship kindly comes.
You got two numbers, flats.
Ownership
No, two different. Now, Lordship, who owns the flat? That your Lordship kindly sees that is their own averment in the second
Even if you
statement.
own the flat, Mr. Mitra, that does not go against you in a sense. You might have owned the flat there, you might have stayed there, you might have come back, but you can always sell it out.
That is, of
You
course,
are
not
still
even
the
a case.
owner of that, does not cut ice with us on this issue.
Page
by itself.
Page 340. This is not that this can't be.
You're not prejudiced by the even if you are the owner also, then you might have
But
only.
she has herself said that both the flats are owned by two different companies.
Maybe.
And she has not been able to show any connection.
So first, it's oppressive against you because you have come back in October 2023, and also you say that due to the nature of orders being passed there, it's oppressive to contest there. This is one aspect of the matter. Forum non-convenience. Also,
Hindu Marriage Act, it has to be now. Here I will show a couple of judgments, brother. Hindu Marriage Act divorce.
But the two jurisdictions may have determined authority to decide your cases. Here, English courts also, because if you had resided there continuously for one.
On that case, well, on that I had shown that order passed on their first court, where she only files and says, I will withdraw and file again in August.
Yes, but the second suit, then that had jurisdiction otherwise.
Second suit will be, it is first suit not yet withdrawn. Second suit, she is staying there. I'm not disputing, but second suit has already been filed, where the jurisdiction issue, as Mr. Honorable Chatterjee has said, will be decided, or the process of being heard. That's what he said.
That was in the first suit, the jurisdiction issue, not in the second suit.
Second suit because
first suit because you raised a jurisdiction question on.
But in the meantime, they've already filed in August 2024. Or their second suit.
That second suit, there is no jurisdiction issue.
The only thing will be that that
your jurisdiction challenge was on the ground that she was not resident there.
Not resident there, because I didn't file anything there apart from making a government. And secondly, by the time the second suit is filed, the expert's opinion, I didn't file an application challenge. Opposition. And so by the time the opinion which they sought for has already come.
In the second suit, there is no objection as yet. I mean,
it has not yet been. There is. I will show
you filed your response to their.
No. Because Lordship Kelly sees the order in the second suit, that is 28th of October.
And what was the genesis of this English High Court's judgment? The
genesis is no, not second suit. My Indian suit filed.
What did they challenge in that?
Only for stay of the Indian suit, only that. For stay of the order which I had obtained.
In their law to permit them. And is there anything like
R151, inherent part? And
no, Superior Court cannot have 151. Maybe 226 sort of.
Yes, inherent part, because
I have not found any jurisdiction in forum dispute.
You have got the order.
Yes, but I'm saying so, my lord, that I have not found any law which permits me to file that. I have not found.
But the anti-suit injunction concept is the English concept.
Yeah,
that is when forum convenience, oppressive.
Now Indians write better English than
nowhere near. The number of English courts injunctions are there. It's galore.
We write better English than them. That is not we. I mean Indians generally.
That's because there are hardly any British there. The Britishers have all gone to Dubai. And everybody from Dubai has gone to England. It's just that.
Now, Lordship kindly comes to the 683.
But this is very, vindictive sort of an injunction.
Weird.
What if this injunction remains, then oppressive?
I'm not even going to look at it.
We'll quote if necessary.
I will not even rely upon it before you.
Till now we were with you, but this is oppressive.
Now, Lordship kindly comes to
I'll tell you why.
Then we cannot surrender our sovereignty like this.
No, certainly not. I am not going to even look at it below.
It's not some sentimental nationalism sort of thing.
I understand.
No, it's legal. I mean, constitutionally we are saying that.
That's why I say, Milord, Kali treats it as something, Milord, which is beyond jurisdiction and nullity. Absolute nullity. Because I have not found any
Probably you would also treat it treated it in the same manner because you have filed in.
kindly treat that as a nullity for at least for India.
You obtained.
I can't say, my lord.
You obtained this.
I, as a lawyer, I have the duty to tell your lordship what is correct or wrong, what is right or wrong. Treat it as a nullity and
If
treat
this be the attitude of the English court, then we are not confident.
My lord,
that
it's
either of you will get justice there.
No, my lord, what happened is, if your lordship
What
looks
sort of order is this?
if your lordship looks into what's happened, my lord, before, with respect to people who were fugitives.
No, this is very. I mean, we don't know whether this is racist or.
What happened is, my
I mean,
lord,
it borders on being racist.
What happened is, what they were trying to do is that since they've got an injunction,
Thank God she's Mrs. Justice Harris and not Karen. Very
Mrs.
entitled.
Justice,
Very entitled.
Mrs.
Whatever, it's Harris, not Karen.
I understand. Beloved, the problem is they were trying to say that
Very
they will not
entitled, I mean,
pay. They will not pay because, beloved, they've got an
One
injunction.
order can strain the relationship between two countries. If it was on a larger footing.
That's why I say treat it as a
We
nullity.
will pass this sort of order. I've never seen an Indian.
Treat it as a nullity, my lord. I don't even want to look at it. Treat it as a nullity.
But then how can we
Like,
be
if I
confident that
had
there'll be
not-
justice there?
Beloved, they have got justice there. They have gone and they have gone and filed oppositions showing their income. Mr. Mitra today is coming and telling your lordship, I have come back to India. Sees what he said.
Let him
finish. I'll tell
Can you
your
see
lordship.
another order on
Yes,
the
just be back in 2 minutes.
684, 683, the 28th October order. After the opinion comes, after the second divorce petition is filed. This is an order passed in both the petitions.
Both the petitions in the sense, both the divorce petitions.
Both the divorce petitions.
So they are not taken up together.
No, my lord, yes, that's what it seems. And there's a third one is that anti-suit injunction which they have got. Worship, that's the third one.
Case number 1727. There are several numbers.
Volume 5.
Docket numbers.
Volume 5.
683. These two cases referred to, because I mean, we don't know. The two different cases. What are the numbers of these cases? One starts with 1727 and the other with 1728, or they are part of the same case?
Can you give me one reference?
Because you say both the divorce petitions are being heard jointly.
Yes, that's what yes. Your lordship, yes. 680. What do you know? No. Wait a second. 28th of October. 28th October. 683, yes. Should may I just come to? I got my brief first.
Within double inverted Indian courts. Yes.
Now, Kunti Rako, but Kunti second petition Rako to? Second.
I just clarify, these numbers, ending 233. This is the matrimonial proceeding, divorce. And this is 043. This is in connection with the alimony proceeding, maintenance. No, the number is same.
Both the suits.
Yes.
If parties are same, the number.
Court allowed that since now by 1 year have lapsed, you are staying over here, so you file it. So it's going on by the same number. Only to obviate the issue with regard to jurisdiction, nothing else. So these two are the
Kindly.
727 is the first one, 10th October.
684.
Yeah.
That's the order part. The final hearing on 8th December shall be in open court, but counsel have permission not to attend rope. Neither party shall have permission to rely. Kindly come to any application for relief from sanctions, including paragraph 8. The applicant is granted permission to issue the second divorce application. Will continue. And paragraph 7, the applicant's application for a personal freezing injunction against the respondent is adjourned and will be considered for directions at the conclusion of the final hearing on 8th of December.
Mr. Mitra, please see para 8, para 9.
The second divorce application shall be stayed alongside the first petition pending the outcome of the forum dispute.
So you are taking the forum jurisdiction also here, forum argument here, but the English court itself says that the second, both the divorce petitions shall remain stayed there till the forum dispute is resolved. This is a much better attitude.
But kindly come to para 90, para 80, para 90. While this is stayed, while jurisdiction is there, the respondent shall pay the costs of the applicant of and incurred by her unless summarily assessed is the sum of 60,480 by fourth. So while this is stayed,
what is this? The meaning of this incurred by her unless order application?
I couldn't follow their language. If you read it, it's a little, as the Lordship says rightly, English is not very clear.
We know better English than them.
I do not.
Read this sentence, Mr. Mitra.
The applicant,
in my school, I would be rusticated for this, writing this sentence. In my school, I would be rusticated. I wrote this sentence. The respondent shall pay the costs of the applicant of
and incurred
by her
unless
order application summarily assessed in the sum by 4 p.m.
By 4 p.m. on 11 November.
Have some technical meaning there.
Then can you see the paragraph?
Yes.
14. Respondent shall comply in full with deficiencies arising from provision of information set out in 6 AD of the order of the Honorable Judge, 4 p.m. As set out in the applicant's witness statement. The applicant shall simultaneously.
That was on disclosure. Something was not disclosed by you.
Why
that those were categories. This can be understood. I mean.
But while this is being stayed, I have to pay the costs.
But this is like, I mean, litigation costs sort of.
But while the proceeding is not yet started, jurisdiction will be decided.
But there are judgments in our country also, Mr. Mitra, that even if in a suit for nullity, alimony can be granted.
That's true. In a suit on
declaration that divorce marriage is a nullity, alimony.
Yes, that's what I'm coming to. Section 24 of our Hindu Marriage Act. So, as I showed that there's
36(7) parallel.
It's
pendency of the proceeding.
Pendency now
can be for nullity also.
And again for nullity, any proceeding.
They may have a similar process.
But
all that we know.
So the interim maintenance is also allied. It's also connected with the divorce case. So his very fair.
You are virtually trying, Mr. Mitra, to challenge their alimony order here, committing the same mistake as their court.
No, but that order has not been stayed. Order has not been stayed. Logic sees that order has not been stayed.
You can challenge that order before that forum.
That order has not been stayed.
In the garb of this, you are trying.
But that order has not. At least I can say I may have wanted that, but that order has not been passed. But the English court has passed that order.
Yes.
That is the whole difference.
Already passed have not been touched.
Litigants can ask for the moon, but the courts are to judge what to pass, not to pass. So now.
But the execution of that cannot happen because of your stay, this injunction. They cannot have that order executed because of this injunction order.
Well, my proceeding.
We can open that up. That interlocutory proceedings will continue.
Now, my proceeding here, logically, do not do
but if
that.
It's oppressive, then you have a point.
It is because kindly see, while this is done, jurisdiction, kindly come back to page 791 once more. That is that very strong order. Page 791. That is that.
One of your juniors here will give him a chair.
She's very. I must say he's very enthusiastic. Very good junior.
That's why we are asking for them. We are not very good in handling papers.
Eventually, he will go at some point.
That no one knows.
Then he'll have. By that time, maybe he'll be
sitting there. That's for sure.
Not only that, will be sitting here.
He's a great help. Whenever I had.
They probably wouldn't be having. They would be having better assistance than us. Beside us, somebody would be sitting and supplying paper.
790. That
it has started. Somebody sits there and we'll start that then.
They sit here. They sit below.
No, my interns sit there.
Interns are there.
Yes.
So they have a computer with a earpiece here.
That is the difficulty.
So they'll come back with anything and give it to the judge as the arguments proceed.
You can start there.
You can very well start. Absolutely.
The English court has ensured, page 790 is the order which I showed just now. Volume 5.
790. 790 is not there.
699, 790 not there. Yeah, sorry.
790 is not there.
It looked like 791, but then it is 701. Sorry. 699, the order starts.
Yes.
Yes. While they have stayed the Indian court's order, declaratory relief, it is declared that the applicant is required to comply with orders made by the English court in the English divorce proceeding.
Where is that? Which paragraph?
17.
Applicant means them.
Possibly them.
We are. Mr. Mitra will not go out of this order again.
What applicant?
Applicant is equal to comply with her obligation.
Her obligation.
That is different.
Huh? No. That while the second suit was being admitted,
The damaging part is injunctive relief from 15 to 16, 15 and 16.
Now, a few judgments.
Yes.
To kindly takes a look at 1991, 3 Supreme Court cases. Page 451. I don't have the copy. Under section 13. Paragraph 5 of this judgment is 435.
Yes.
It is necessary to note certain facts relating to the decree of dissolution of marriage passed by the Circuit Court of St. Louis. In the first instance, the court assumed jurisdiction over the matter on the ground that the appellant number one had been a resident of the state of Missouri for 90 days. Next, preceding the commencement of the action and that petition in that court. Secondly, the decree has been passed on the only ground that there remains no reasonable likelihood that the marriage between the parties can be preserved and that the marriage is therefore irretrievably broken down. That's the only. Thirdly, the respondent number one had not submitted to the jurisdiction of the court. From the record, it appears that to the petition she had filed 2 replies of the same date, both identical in nature, except so. Now, she kindly comes to paragraph 9 now. So both were resident in the US. So this paragraph 9, as pointed out above, the present decree dissolving the marriage passed by the foreign court is without jurisdiction. According to the act, as neither the marriage was celebrated nor the parties last resided together, nor the respondent resided within the jurisdiction of that court. That's my case also. Last residence is also in Calcutta. The decree is also passed on a ground which is not available under the act which is applicable to that marriage. What is further, the decree has been obtained by appellant by stating that he was the resident of Missouri state, when the record shows that he was only a bird of passage there and was ordinarily a resident of the state of Louisiana. He had, if at all, only technically satisfied the requirement of residence of 90 days, with the only purpose of obtaining the divorce. He was neither domiciled in the state, nor had he an intention to make it his home. He had also no substantial connection with the forum. Appellant 1 has further brought no rules on record under the St. Louis could assume jurisdiction over the matter. On the contrary, as pointed out earlier, he has in his petition made a false averment. Respondent 1 had refused to continue to stay with him in the state of Missouri, where she had never been. In the absence of the rules of jurisdiction of the court, we are not aware whether residence. Now, Lordship kindly comes to paragraph 15, 16, 17. Section 13A states that a foreign judgment shall not be recognized if it has not been pronounced by a court of competent jurisdiction. We are of the view that this clause should be interpreted to mean that only that court will be a court of competent jurisdiction which the act or the law under which the parties are married recognizes as a court of competent jurisdiction to entertain the matrimonial dispute. Any other court could be held to be a court without jurisdiction unless both parties voluntarily and unconditionally subject themselves to the jurisdiction of that court. The expression competent court is 41 Indian Evidence Act are also to be construed likewise. Section 13B states that if a foreign judgment has not been given on the merits of the case, the courts in this country will not recognize. This clause should be interpreted to mean A, that the decision of the foreign court should be on a ground available under the law, which the parties are married, India, and that the decision should be a result of the contest between the parties. The latter requirement is fulfilled only when the respondent is duly served, and requirement is, well, I'm not on the contest, I'm on the recognized Indian law. Now, 17. Second part of clause 3 of section 13 states that where the judgment is founded on a refusal to recognize the law of this country, in cases in which such law is applicable, the judgment will not be recognized by the courts in this country. Marriages which take place in this country can only be under either the customary or the statutory law force in this country. Hence, the only law that can be applied to the matrimonial disputes is the one under which the parties are married, and no other law. When, therefore, foreign judgment is found on a jurisdiction or on a ground that not recognized by such law, it is a judgment which is in defiance of the law. Hence, it is not conclusive of the matters adjudicated therein, and therefore unenforceable in this country. For the same reason, such a judgment will not be unenforceable under clause F of section 13, since such a judgment would obviously be in breach of the matrimonial law in this country. D, we are not concerned with D.
17 mostly.
Then paragraph 20. From the aforesaid discussion, the rule can be reduced for recognizing a foreign matrimonial judgment in this country. The jurisdiction assumed by foreign court, as well as the grounds on which the relief is granted, must be in accordance with the matrimonial law, under which the parties are married. The exception to this may be
exception 1 may come in here,
where the matrimonial action is filed in the forum where the respondent is domiciled, or habitually and permanently resides, and the relief is granted on ground available in the matrimonial law under which the parties are married.
But you say that you are not habitually residing there.
That's specific. That's also under the law. Where
but that is there.
Marriage.
Substantive part is there.
Where the respondent voluntarily and effectively submits. So I have not submitted to the jurisdiction.
No.
And or to Roman 3 consents to the grant. Now, apropos this, kindly see 21.
But there is some, I mean, we should not, this is binding on us, but Mr. Mitra, if it's said by the court that procedural law and jurisdictional law is also incorporated in substantive law, to bring within the fold of 13C, then Mr. Mitra, can you voluntarily confer jurisdiction on a court which does not have it? Absolutely. In the same breath, it has been held, because either you say that no, substantive law, yes, cannot be against the substantive law of India, but if you borrow the jurisdictional law also, territorial jurisdiction also of that law, which is Hindu law here, Hindu Marriage Act, then you cannot say that, I mean, it's a bit contradictory in that sense. You cannot voluntarily confer jurisdiction.
Or then you
and then also this last exception would not come in. If the matrimonial action is filed in the forum permanently decides, that also would not come in.
Permanently. On a ground
of this is an exception.
And the permanent side and the relief is granted on a ground available.
Suppose this is granted on the ground of, say, cruelty, as our cruelty, or some other ground recognized by our law, but it has been filed in a place where both of you or the respondent permanently resides.
Then it's okay.
But which is not any of the places which yes, under Hindu law also that respondent resides comes in.
That is why. That is why Roman. Now, apropos this, kindly takes us a look at 21. এটা good আছে, তো পরে দেখাচ্ছি। 21 Supreme Court cases, page.
Yes.
আবার এয়ারড্রপ করে দাও, চট করে এয়ারড্রপ করো, একটা 21
yes.
গরম হচ্ছে।
Yeah. Grant of
I'm just getting another copy for myself.
You can take one of our copies.
No,
we'll have to mark.
It's a very short judgment. আমার কাছেও নেই। তার আমি বলছি কি নামটা বলো তো।
The judgment and give it to me.
Citation টা বললি?
2021 2 SCC 775. 75.
The wife suit in abroad, husband files anti-suit here.
Yes. What is the proposition here?
On anti-suit injunction.
What is the proposition of law? This is on anti-suit injunction. Yes, we can understand. The fact situation so warrants.
Basic. Not of full justice.
This is not a precedent on anything.
এই তো খুলে গেছে তো হ্যাঁ ঠিক আছে বলছে কাইন্ডলি কামস প্যারাগ্রাফ if I'm not mistaken paragraph. Paragraph 4. It was urged before the trial court that the respondent had resorted, the wife, resorted to proceedings for divorce before the Superior Court of Arizona, where according to the appellant, the parties had never resided. Both the parties are Hindu and were married under the Hindu law. The child was also born in California. The parties had never resided in the state of Arizona. Moreover, in the proceedings was that the Superior Court of Arizona, objection regarding jurisdiction of the court had been taken by the appellant. While dealing with the preliminary objection, that court made it amply clear that it intends to apply the laws of the state of Arizona, would not take into account the laws applicable to Hindu marriage, namely the Hindu Marriage Act. In view of this observation, the appellant apprehends that some drastic order is likely to be passed by the Superior Court of Arizona, the instance of the respondent wife. Notably, the respondent is bent upon precipitating the matter before the court of Arizona, despite the appellant having resorted to proceedings for divorce, as well as custody in the minor child in India before the court in Bhopal, in the state of Madhya Pradesh. Those proceedings are still pending, where the respondent has had entered appearance after the subject application was filed by the appellant. Be that as it may, during the pendency of that stated suit for declaration and for direction to hand over custody of the minor child, an application had been moved by the appellant before the trial court, which came to be rejected on the ground that the Superior Court of Arizona was outside India and not subordinate to that court. This view, noted by the trial court, is completely erroneous and ill-advised. For the relief claimed by the appellant was for grant of interim anti-suit injunction against the respondent and not against the Superior Court of Arizona. When the matter traveled to the High Court at the instance of the appellant, even the High Court proceeded on an incorrect basis that the courts in India could adjudicate the controversy between the parties only after the Superior Court would pass an order in the pending proceedings. The Superior Court of Arizona. This was not the purpose for which ex parte ad interim relief was sought by the appellant. In any case, no judgment of this court has been sought, has been brought to our notice, which says that if the other party had already resorted to proceeding before another court outside, including outside India, an anti-suit injunction cannot be issued, even if the fact situation.
In fact, this is in support of that anti-suit injunctions can be
in a matrimonial case.
In fact, Mr. Mitro, Section 41 specifically, fact, bar does not apply because that applies to
foreign proceeding will not apply.
Foreign proceeding it will not apply. So therefore, there is no bar.
So now, Balut,
this is just this said anti-suit injunction can be granted.
Online Delhi
now it's already well settled that anti-suit injunctions can be granted.
2003 SCC online Delhi. এটাও কপি এটার কপি নেই নামটা বলো তো Dev Agarwal versus and others versus name. May I?
Yes, hey, yeah.
Read up to you.
আমি আমারটা দিয়ে দিচ্ছি জজ সাহেব এখান থেকে দেখে
তোমারটা দিয়ে দাও, তোমারটা দিয়ে দাও।
No, no, now it's all. Yes.
But this unfortunately is marked.
Yes.
ERJ.
number নেই আমারটাতে। Kindly come to at page 62. Lordship, page 62. Last paragraph.
SCC Online Delhi, which year?
This is this is 2003 SCC Online Delhi, page 60.
60?
Page 60. At pages 62 to 64. Harmita Singh. Last para.
Yes.
In the present case, the plaintiff wife, namely Harmita Singh, and the defendant Rajat Tareja were married in New Delhi. Their marriage was performed and celebrated in style on 24th March, according to Sikh rites and ceremonies. Therefore, it is the Hindu Marriage Act which would govern all disputes between them pertaining to their marriage, division of properties, and maintenance. Where a divorce is not prayed for, maintenance can be granted by the court in terms of Hindu Adoption and Maintenance Act. Spouses departed for the US on 27 March 2002. Plaintiff wife has alleged that she was compelled to leave matrimonial home on 27th August, and that this is on facts. Next paragraph. The law on the vexed question of conflict of law and on the appropriate court for deciding the disputes pertaining to divorce of this genre has undergone substantial changes. The old law in Britain was that the wife would be deemed to have the same domicile as her husband and would therefore have to seek relief in the court where the husband was domiciled. This almost inflexible rule, not taking into account the difficulties faced by the deserted wife, has given way to preference for the court which is most convenient to both parties. Conventions in the European community have since been negotiated. This conundrum of competing jurisdiction and laws had been carefully considered in a number of decisions of the Honorable Supreme Court of India. The foreign decree is recognized by in India as most legal system, but would have to be judicially investigated before it is given legal efficacy. Narasimha was at place. The Apex Court declined to give its imprimatur to a foreign decree which did not take into consideration the provisions of the Hindu Marriage Act under which the parties were married. In Satya Taneja, where the husband set up domicile only to perfunctorily fulfill the domicile requirement in 90 days, the foreign decree was not accepted. Then Vidan is not relevant. Kindly come to the next page. On the contrary, however, courts in India would undoubtedly have jurisdiction over the dispute between the present spouses, since the marriage was performed in New Delhi. Having financial as well as family support in this country, it would be comparatively easy for the defendant husband to initiate divorce proceedings in this country. The plaintiff wife would not be in a position to challenge the jurisdiction of the matrimonial courts in Delhi. The forum of convenience, which is a concept well recognized and implemented in the US, would thus be New Delhi. The plaintiff wife has not submitted to the jurisdiction of the courts of the US. In the context of their residing together as husband and wife, the plaintiff's stay in the US could well be viewed as transient, temporary, and casual. I am quite clear that some of these factors can apply to the husband also in regard to New Delhi. But the fact remains that he could quite conveniently prosecute litigation in New Delhi, whereas it is financially impossible for the plaintiff to do so. Having not received the spouse visa, she may not even be in a position to enter the US.
That does not apply to you.
But here also, Balat, wife could have certainly come to Calcutta.
Yes, but forum of convenience, you have been there for so many years. You have come back, yes.
I have come back. Now,
Not so inconvenient to go to you that to say that the court does not have jurisdiction.
no, doesn't have jurisdiction for other reasons.
Because here, what has been done is that suit has been stayed, not the Indian suit has been stayed, which could be said against the English court's judgment.
Yes, English court.
But here, by the impugner, present impugner, this our court has stayed their court, the English court's suit. So it's not a forum.
But here also the
non-convenience as such.
Here also the US court proceeding was stayed. Last paragraph.
Yes.
The
But
US
there
court,
the wife was, I mean, not in a position to financially go there and regularly contest.
but she might.
But you have been there and to and fro.
We have been to and fro, but
you have a flat there still.
No, that's well. On that, I will show that.
Not a forum non-convenience for you as such.
Forum non-convenience, in the sense that this is a more convenient forum.
That cannot be probably a.
Well, forum non-convenience coupled with no jurisdiction for
You cannot just choose if both the courts have jurisdiction. You cannot just choose a court of your convenience, just like that.
Well, October 2024, in my humble submission, UK court didn't have jurisdiction because I was deciding, I couldn't have filed in UK.
No, but the second suit, their second suit is.
Well, it's.
And the first suit has been clubbed with the second suit, apparently.
Now, so with the orders all continuing in the first suit. Second suit, there's no order passed, except for that 14,000 pounds. Now, second or first order not very clear. So, first suit order I am suffering, in spite of the fact that the first suit could have well bet that was not the appropriate court, UK court. Not the appropriate court, that she also admits. And her residence, at least in second round, when she goes back on a student visa.
That does the
temporary residence. So I'm saying that was a temporary transient residence. Temporary transient residence on a student visa. She is there.
All right. She has all along been on a student visa.
No, she had a work permit as he rightly pointed out, because at one point of time when she was working in London in this company called Monocot, where I was a director, she had a work permit. But when she goes and files it there second time, or when she files the case there, both first and second court, both first and second suit, it is a transient nature. She hasn't got a job, and she's got enrolled in a university of something she has mentioned. And she's got a student visa from 6th of December. So it's a transient residence which she has now, not a work permit. I'm saying work permit is relevant for the purpose of the date of filing of the suit.
Very.
Now, Lordship, kindly comes the last judgment. And that the second divorce petition, her prayer is first one should be dismissed. That's an admission that the first one is without jurisdiction. Now, Lordship, kindly comes to the latest judgment after considering. Is Dhulia's. So, in my humble submission, I personally don't feel that Dhulia's judgment has added a ground to the section 13. Not added a ground, but it says that irretrievable breakdown of marriage would be okay. Now copy now. Would be evidence of cruelty. So, if I filed a suit today in Calcutta or anywhere in India on the ground of irretrievable breakdown of marriage only, without pleading any cruelty, it can be dismissed on the Order 7 Rule 11. That now Lordship kindly comes to paragraph 8.1, page 25. Exercise of power by this court under Article 142(1) to grant a divorce, decree of divorce, and the factors to be considered while doing so varied with facts and circumstances of each case. It's 142. In the case of Rakesh Raman versus Kavita, that is the one, the multiple court battles between them and the repeated failures and mediations is at least testimony of this fact that no bond now survives between the couple. It is indeed a marriage which has broken down irretrievably. Irretrievable breakdown of a marriage may not be a ground for dissolution of marriage under the Hindu Marriage Act, but cruelty is. A marriage can be dissolved by a decree of divorce inter alia on the ground when the other party has, after the solemnization of marriage, treated the petitioner with cruelty. In our considered opinion, a marital relationship which has only become more bitter and acrimonious over the years does nothing but inflict cruelty on both sides. To keep the facade of this broken marriage alive would be doing injustice to both the parties. A marriage which has broken down irretrievably, in our opinion, spells cruelty to both the parties, and that's a 13-1. In light of the above observation, this court had granted a decree for divorce and dissolved the marriage between the parties. The aforementioned position has since then been followed by this court in several cases while exercising power under Article 142 of the Constitution. For instance, in a recent judgment in Vikas Kanojia, this court granted the decree of divorce on account of irretrievable breakdown of marriage in light of the overall facts and circumstances of the case, even though the wife had submitted that she was willing to live with the husband. Then similarly in Prakash Chandra, it goes on, and Lordship then kindly comes. Paragraph 8.5 is Shilpa Shailesh. May I just please para 8.5? The aforesaid decisions have followed the proposition of law confirmed by the Constitution bench in the case of Shilpa Shailesh. However, even before the said judgment, this court had not hesitated from dissolving the marriage on the ground of irretrievable breakdown, where the relationship between the parties had deteriorated to a level that no reconciliation appeared possible, and where such a dissolution was necessary to do complete justice between the parties in exercise of power under Article 142 of the Constitution. Even though, then para 8.6, the not again same thing, then
8.12 where 142 is the only exception. 8.11.
8.11, 8.12 kindly comes. Therefore, there now remains no doubt that this court has the power to grant a decree of divorce on the grounds of irretrievable breakdown. Page 31. By invoking its powers under Article 142.1. But that constitutes an irretrievable breakdown has to be determined in each case by undertaking a factual analysis of the case and using judicial discretion in light of several exhaustives. So this court has to reach the conclusion that the marriage has completely failed, and there is no possibility of the parties cohabiting together as wife and husband. Para 8.12 is very important. Unlike a divorce proceeding before the family court, where the court is bound by the false divorce provisions contained in the HMA, Hindu Marriage Act, and other allied legislation, and thus has to necessarily appreciate the evidence to give a finding about whether a party had indeed committed the alleged matrimonial offense or not. This court, while dealing with an application seeking divorce under Article 142, can depart from the said procedure as well as the substantive laws by acting as a problem solver and balancing out the equities between the conflicting claims. This court is therefore not required to look deep into the veracity of the detailed allegations made by the parties against each other to find as to who is at fault, but is required to take a holistic view of the relationship between the parties and conclude if there's any. Thus, the thrust of considering an appeal under 142.1 is in order to ascertain whether there is an irretrievable breakdown of marriage between the parties, and the result is so. Not under Hindu marriage. And paragraph 8.13 is the same thing. Divorce being sought by one of the spouses on the basis of fault committed.
Dependent on proof of marriage.
Well, first of all, I shall just summarize and conclude. My lord. Now, well, just one sentence. Page 421 on this. 431.
Of?
Should be dismissed and for the
431, that is volume 4. Why are we hearing the trial on jurisdiction even then? Page 431. Why is this charade of jurisdiction hearing? 431, this is the second divorce petition filed by her. This large box. the applicant issued a divorce application under case number so and so. First divorce applicant, respondent dispute jurisdiction, a 3-day trial determined jurisdiction and forum. The appellant can establish she was habitually resident on 10th October and that she has been resident in England for 12 months before that date. However, as the jurisdiction trial is in December, and the applicant has been in England and not left the country since August 24, she has sought permission to issue a new divorce application, the second divorce application, and for the first divorce application to be dismissed. The purpose of this is to remove the sterile argument of jurisdiction from the proceeding and save court time as well as costs. Even if one goes by habitual resident from 10th October 24, 12 months is not there on 20th August 24 when she files the second petition. Be that as it may, that she herself says she does not. And in spite of that, trial on jurisdiction, the interim order is still continuing. I have to pay not only £6,000 a month, but also £14,000 her legal costs. So, well, I shall conclude by just summarizing my points. It is not a forum convenience because of the fact that the first proceeding could not have been filed in October 24. Second proceeding in August 24 also appears 12 months from October, can't be August. Not a forum convenience. Forum convenience is admittedly in Calcutta, where the marriage took place, the defendant resides.
So, did not have jurisdiction does not mean forum non-convenience.
No, the jurisdiction.
It's a different argument.
So that's forum that doesn't have jurisdiction, coupled with 13B, 13F, C and F, that the court doesn't have that court doesn't have jurisdiction. Number one. In spite of that, I'm proceeding. So it's oppressive.
That is 13C, not competent.
No,
as
so
by
that's oppressive. No, that's an oppressive, even though the court doesn't have jurisdiction. It has proceeded to pass, and the defendant has obtained an interim order, knowing full well that she doesn't have jurisdiction, and that order is still continuing, even though on August 20, she has herself said that the court doesn't have jurisdiction. Forum non-convenience, because now, as per the admitted case of the defendant, she's living there from 10th of October habitually. So when she filed the case, she was a habitual resident, not of UK. And her passport, Aadhaar card, everything shows she is in Calcutta and she was staying here. So she could have very well filed that case and applied for under Section 24 for maintenance. Or in other words, she could have filed a 24 in my application instead of multiplying two cases. That will also lead to oppressive nature, because many people in India can't afford to go to UK, take a student visa and file a case. So our Indian law, whatever maybe less maintenance our Indian law gives, than
many people would not be a consideration in your case. I mean, we have to go by the parties before us.
But yes,
people may not have luxury to do many things. Engage you, Mr. Chatterjee.
Mr. Chatterjee.
That's exactly why I'm here.
Yes. He's the
exactly
he never appears.
Oppressor.
Exactly why he's there and I'm here.
He's the advocate of the oppressor and the oppressor of the oppressor.
So, well,
anyway, so
that's not the forum.
Wife could very well come and contest here, and
when she's aware of the second our divorce case, couldn't have filed the case there. It was a harassive petition only to harass me. Then, my lord, on the question of jurisdiction of...
So you are equating harassive with oppressive. I mean, harassment is oppression. I mean, this is not a trick question. I mean, just ask.
It is a trick question to me. You may not say that. But it is... Let me avoid that answer. So, my lord...
very well. So it's oppressive.
Oppressive.
Let us stop. I mean, put it there. Yes.
Oppressive is coupled with the fact that she has
Yes.
Knowingly, because Indian law she seemed to be aware, deemed to be aware of, that it will not be a ground for divorce. It will be non-recognizable in India. So knowingly, that's why I'm saying oppressive harassment, Lordship, whichever language, just to, and when admittedly, or not, I wouldn't say admittedly, because my passport, I have to prove it that I have not been residing in UK since October 23. But that's my plain case now. October 23, I have not been residing in UK. And both of us, none of us are UK citizens. Oppressive because of the second English court order. I will not be getting justice in UK for several reasons. One is that second court order, the third order, really, third suit order. Number one. Number two, in spite of jurisdiction being admitted that she doesn't want to proceed, trial on jurisdiction. In spite of her admitting that the first proceeding she was not habitually resident, I'm still going on maintenance even after 20th of August. That, and of course, section 13 is glaring at the face. And Malal said at the ad interim stage, equity they cannot, because when they have chosen to go to UK and get a stay of that, in reference to my order, Lordship will not exercise the equitable jurisdiction to help him get a second stay of this order in the Indian courts. So this is not a case where ad interim order should be interfered with, in my most humble submission. That is all.
Good.
Lakshmi, I must kindly.
Mr. Mithra will dispose of the
Yes, of course.
Maybe not today. We may not pass orders today, but we'll dispose of the case. Because nothing remains for the appeal. Yes. Short reply, Mr. Chatterjee.
Very short. Lord, my first respectful submission before your Lordship is, kindly do not equate section 13 and anti-suit injunctions. Section 13 is very different. The entire submission of Mr. Mitra Milord is really based on 13. Section 13 will come in at a much later stage if there is any conflict of decision, Milord, between the Indian courts and the British courts. Milord, there's one very important thing I need to show your Lordship, even on facts, is what Mr. Mitra says, that I have come back. That is something, Milord, which I feel, Milord, is a very wrong statement, because of his statement, which he's made, Milord, in England. Kindly have a look at page 516. Have a look at it once. What? Have a look at 516 once. This is his Milord submission to the jurisdiction without prejudice, and he files Milord an affidavit. Volume 4 na 5? 4, Milord.
Yes.
He is continuously saying that I have come back. Have a look at this statement once. And this is made, Milord, before the British court. And I'm reading for your Lordship.
Yes.
I am employed as chairman of Monocon International Refractories.
Can we look into a memorandum settlement?
This is not a memorandum of settlement at all.
Title that 529.
Written without 516.
516, not 531.
No. 516.
Sorry.
Not even memo settlement, Milord. It wasn't even.
We cannot rely on this.
516 is a submission that is made before the UK court. And he's pleading there.
Right.
The very important one, Milord, is the first line. I am employed as a chairman of Monocon International Refractories. This is a company, Milord, which is owned by him and is listed in UK. This is listed in England.
This is at the juncture when the first suit was filed, and
second suit.
Second also.
Absolutely.
This is his statement in
Yes, Milord, this is the statement before the British court.
No, when?
5? Milord, 507 if your lordship comes back,
This was after the second suit.
Malad, this statement was possibly filed on 17th of April 2025. Malad. That date is appearing Malad, at page 522.
It has to be after
507 also.
so this is after the second suit.
Has to.
After second suit.
After
Number
second
is
suit.
also.
Number is given below at 507.
So it's
Yes,
2025. By that time, Thomas
This is
second
17th of
It is also
April.
given in at
Yes, 17th of April 2025. Kindly looks to now comes back to 516.
Yes, 506.
Contrary to contrary to bizarre accusations by Vidushi that I do not have an active role in this company, I am part of the key leadership team. This is his statement. I am saying you are not, but he's saying I am. I am involved with all high-level decisions and strategy. I have an active role at all board meetings and in winning and maintaining contracts at a high level. As has now become public knowledge from around September 25, I will be assuming the role of Group Managing Director. I have been able to continue this role remotely from India since our relocation in October 2020.
Yes, sufficient. Yes.
Malad, only one thing, Malad, I'm not interrupting. Malad, this is possibly before the second UK proceeding. Malad, the second UK proceeding was filed on 20th of August 2025. And this statement, Malad, was filed on 17th of April 2025.
Right. So this is what it is, Milord. September 2025 is probably after, Milord, the second court. So, Milord, now your lordship will see that these, whatever he said, Milord, he's, again, if your lordship goes back one step earlier, sees I have invested in an off-plan apartment in Portugal because I want a golden visa, 200,000 euros. I have. So now comes this is why I'm showing, is on oppression. Mr. Mitro says that I am being oppressed. Why? Because I have to pay 6,000 pounds. Because 6,000 pounds translates to, I think, 6 lakhs or an odd, the CC wouldn't know. So now, the problem here is, he says that this is oppression. Your lordship was annoyed with the British courts passing that order. The same thing has been done by our courts.
Right.
That's the impute order. That's
The
the impute
language
order. I am, for a second.
And the premise of that.
Absolutely. I'm for a second. No, that court passed it later. British courts passed it later.
The British court passes later.
Later.
Yes.
The Indian
court, where is the offensiveness in the Indian court's order?
He says so. Kindly look
Show us, show us. No, we are open to that.
Yes, yes. Kindly have a look
Just
at
show
it.
us.
From the material.
Just because it's an Indian court does not mean that it's sacrosanct. Show us where is the offensive.
From the materials place, this court is further off the second page.
This is impute order?
Yes.
Yes. Second page?
Yes.
From the materials place.
From the materials place, this court is further of the view that continuation of the foreign proceedings would cause serious and irreparable prejudice to the petitioner. The maintenance orders passed by the UK Family Court, despite its lack of jurisdiction, appear to impose onerous financial obligations which the petitioner is not in a position to sustain.
Valid, which is one of the valid findings. I mean, valid subject to.
Valid subject to, Milord, whatever has been said in the UK as well. The court had to see what has been said in the UK
courts once.
Then, compliance with such directions has already affected his financial stability and may expose him to coercive measures abroad.
Which is one of the perfectly plausible views. Why not?
Might have.
I mean, maybe wrong. We may hold it ultimately to be wrong.
I bow down. I completely bow down. And then says coercive directions may be issued if not restrained.
Come to
but
the judgment.
I'll come to that
once.
once.
Where is the reasoning?
Lord, there is. I will tell your lordship what the British courts, if your lordship sees, there is no reasoning in any of the orders.
So this order is ample British courts.
British courts. Any order, there is no reasoning whatsoever. My lord, your lordship sees sole even the alimony orders, there's
but if you say that
nothing.
Mr. Chatterjee, very well, you say 13 cannot be brought in.
I am on that. I am saying, my lord, today you are asking me not to proceed in a jurisdiction which I believe has jurisdiction. My lord, anti-suit is on 3 occasions.
If the prima facie satisfy Mr. Chatterjee, us, or
Yes.
this any court, that yes, this court does not have jurisdiction, or the 13 criteria would apply, then it would be a futile exercise. Then it may be an oppressive and
That is for them to decide, not for us to decide. Forum convenience, forum non-convenience, or forum convenience. Let's get to that, Milord. That should be one of the grounds for anti-suit.
Unnecessarily being compelled to.
I bow down.
If
So
you
what
privation
happens
can
is,
show, if the privation
so what
show
hap-
that it does not have
then
jurisdiction.
appreciates one part, not just don't see only Milord the husband's part. The husband sees the daughter's part, the wife's part as well. The wife is living in England, there is no dispute. The wife has been living in England from 2015, there is no dispute.
No, the dispute is regarding her
Now-
being able to regularly, she comes here, stays
Milord,
here
if
for
I
long
stay
months,
here, that is where the mistake is.
goes
That is
back.
where that
Her
is
list of
why
dates show that.
that is why the courts have fixed a date in England for hearing on that. I'll show your lordship immediately. Kindly have a look at 709. Turns to 709. Kindly looks to 709 and sees paragraph 18.
9.
I'm sorry, 685.
Yes.
685. Sees paragraph 18.
18.
On the basis of the second petition, the final hearing shall proceed as a forum hearing only. So the courts there, my lord, would decide whether the jurisdiction in England is there or not. Now, the court, for that reason, has called for, my lord, an opinion from the Indian expert, who is an advocate of the Supreme Court.
Of our Supreme Court.
Yes. Mrs. Gita Luthra, I've got no problems in naming her because it's there in the order itself.
Yes.
There in the order itself. Now, her report doesn't look into, my lord, the judgment of Justice Dhulia. So, the courts can look into it. But it wouldn't look into, my lord, it from that. That's the sacrosanct thing.
So
no.
what you mean to say, it's not oppressive. The British proceeding is going above board.
Exactly.
Taking
So the court there, my lord, is seeing whether it has jurisdiction or not. My lord, it's a very peculiar law there.
This is appearing to have been done.
Appearing to have been done. And it's not that, my lord, why is it not oppressive? It would have been oppressive if he was unable to pay. My lord, he has been paying the entire amount. He has paid the entire money.
That is under compulsion.
Because the judgment which was cited before your lordship, my lord, it's
no that the wife that's
wife was in a
actually
destitute situation.
Yes, yes.
Here, my lord, I am saying
there is no comparison.
He has not even applied for, my lord, the variation there. He has given evidence.
Want to submit to that jurisdiction at all.
My lord, he has given evidence. 581. Have a look at it.
Evidence.
He has led evidence there. What volume ta bol? 581. And this is the second witness statement of the respondent. And he is giving evidence. I am Mihir Bajori. And every time he writes, without prejudice to a submission to the jurisdiction of the England and Wales Court, and gives evidence on merits. 584, Lordship, entire evidence from 581 to 583 is on merits. And 584 documents.
What was the previous page where he stated that he's going to become the whatever of the company?
That is
page number only page.
480 koto? 485. 560. 51.
Yes, you have taken that.
And sees 584 onwards, all the documents have been given. So non-convenience is where he could not have participated. My lord, the fact that he has a house in London. That he has a house in London belongs to his company. He says, it doesn't belong to me. Mr. Mitra was very, obviously it doesn't, it belongs to the company. And he's saying somebody had allowed him to stay there and things like that. Beloved, for the past 20 years, I don't think anybody would allow somebody, my lord, to live there. Even in India, my lord, if somebody lived as a licensee, the suit would have been over by now. So and there, my lord, the litigation happens if you are not paying or if you're not, my lord, it takes 1 minute to throw you out. It's not our courts, my lord, where we have to go on forever trying to get a watchman or, my lord, a relative out. My lord knows that. So here, my lord, the
My lord knows that.
Yes, because my lord just passed a judgment, right? Very recently. In my mind.
Had to throw a watchman.
No, didn't throw her. So now the situation is, my lord, that here the entire thing is very different. Non-convenience, Absolutely, my lord, in my respectful submission, wrong. My lord, they
We are
used to
being
come
candid,
back.
Chatterjee, also we are somewhat shaky about that British High Court's order.
I am on that, my lord. I'll come back to that. That is
be the
why
attitude.
that
We
High
don't know
Court's
what will
order
happen there.
has that.
So that High Court will have jurisdiction. Sorry, will have jurisdiction over
that High Court.
That district
Look,
court also, even if
my
the
lord, if
district
you're
court is fair.
may I ask this question to myself, my lord? Is your lordship so sure, my lord, that I will win? No.
Either
That's
way.
what the 2018 judgment says.
The district court appears to be fairer than the High Court.
That's right. But I am
on a first blush.
We can't.
These are loose comments.
I bow down, my lord. So the High Court has said that that's the order which I showed your lordship. The High Court says that the only hearing that will happen is on forum. That's paragraph 18. So here, whatever Mr. Mitra has said, they've got to go and say that to that.
It has to be taken from that perspective. So
yes.
It brings it down to the forum hearing.
Absolutely. So before passing any other order, the court will satisfy itself that I have jurisdiction. If they say that I haven't been there for 1 year, I'm out. I'm out. And kindly sees non-convenience can never be even opened in their mouth, my lord, because they have gone and given evidence. Forgets about my lord defending. He's gone and given evidence there.
That was in the first suit.
Second suit, if I'm not mistaken. I'm subject to correction by my learned friend.
24th October, yes.
Yes. Second suit. My lord, he says that he is the managing director of a company.
Gone there and given evidence. This is a
Monocon.
Sent it.
Monocon is a company listed in UK, in England.
He admits that.
Admits that. And he's saying that I'm doing it remotely. Why? May I ask this question to myself? Is it believable? May I ask this question to myself? All throughout, admittedly, he's read in England. That's where. That's a good time. I still have 10 minutes. I'll finish it off. Milord,
number.
I understood that.
Yes. Anyway. Yes.
No, it doesn't. It's for him. Now, my lord, non-convenience, suit whether maintainable or not for the Indian courts to decide. Once the suit is decided there, then my lord, section 13 applies, and then the Indian courts will decide whether that is binding or not. Not an anti-suit. It can't say that you can't proceed. Lord, the other part which Mr. Mitra very nicely said, my lord, my company helped her get a job. I've written that down. Monocon is my company and it's not my father's. He didn't say it was my father's.
He said my company, not as in my company, not that I own it.
He said my company, I got a job. Got her a job.
Immediately there, the next sentence was my company, not as in I am the owner.
The shareholding will tell you, Lord. So that is something very different, my lord. But I am only for the prima facie case, I'm telling you, Lord.
Mr. Mitra has cited this Supreme Court judgment, the first one.
Coming to that.
First one, which says
that the first one I'll take your lordship.
Even on jurisdictional issue.
I'll get your lordship is to that 2018 judgment which he did not.
So why should they be compelled to go and litigate there? Would
Correct.
that be oppressive?
Exactly.
Because in a roundabout way, section 13. In a roundabout way, section 13 consultations may come in also.
It can.
But if it's a futile suit, then
I understand. That is where, my lord, first we need to wait what happens in England with respect to forum.
All right.
With respect to forum, it is, my lord, prejudging something, my lord, that has not happened yet. So I am today, basically, if I come to India, I can be hauled up for, my lord, the contempt. For proceeding something, my lord, which I have a right to proceed with, if this order stays. Is it the fact?
The British court forum hearing is only on prior residence of 12 months, not on 13.
Because my entire jurisdiction there is on that.
Not on 13.
Not on 13 at all. They have taken that plea. That is why, my lord, the Gita Lutra's that
will only decide, that may at best decide that last 12 months
I'm on that.
Therefore quoted.
So the
13 considerations are not
13 consideration doesn't come into it at all now.
No, as we said, if you find that it's palpably, 13
palpably, that's what I'm saying. Palpably. So your lordship needs to come to a finding first that I was not residing.
Not only that, the other aspects also, irretrievable breakdown is there.
That's an easy answer. Irretrievable, my lord gave the answer. I don't have to get into that. I don't even want to, my lord.
Nagaratna has given a different answer.
Justice Nagaratna was deciding.
And that is binding on us.
Was deciding.
Categorically said that those grounds have to be proved. Those are all 142.
Definitely. No, that's what Justice Nagaratna, my lord, did not see. She was deciding an application under 25. She's the first page.
Yes.
She was deciding an application under 25.
Is also
No, this is not obiter. I'm telling your lordship. This is 25. There, my lord, an application under 142 was filed by the my lord husband. Then there, what the court has said inside the judgment is not looked into. What the court has said inside the judgment, how irretrievable breakdown of marriage is to be treated. She says, I have jurisdiction to grant a divorce. She's relied upon that, on that. My lord, she's relied upon Justice Dhulia's judgment to take jurisdiction, to grant divorce. She has applied it on that way. It's not that she said that Justice Dhulia's judgment is distinguishable.
Not the other way around.
Exactly. So grateful, dear lordship. So this judgment is basically saying that the Supreme Court has jurisdiction under 142, and we bow down to that. But what happens is, what has the Justice Dhulia says, irretrievable breakdown of marriage can be used as cruelty. She doesn't say that that's bad law. She hasn't said that it's bad law anywhere in this fact judgment. So
interprets that and says that that's under 142.
Absolutely.
142.
But doesn't say that was also under 142. But the law which was laid down was 141. The law which was laid down by Justice Dhulia, my lord, was under 141. It brought in, my lord, within the ambit of cruelty.
All right.
So if it was 142, my lord, he's absolutely right, Mr. Mukherjee, saying that if it was 142, then it would not have been even required for the Supreme Court to bring it under cruelty. They brought it under cruelty.
That is our perception, your perception and mine maybe, and Justice Bhattacharya's. But since Supreme Court has dealt with that, you have to be very careful.
Supreme Court decision as well.
Very careful on that.
And your lordship needs to interpret what the Supreme Court has said in the two different judgments.
That discussed here and explained here. Not that it was not.
Beloved, it's taken only for the reason saying that I have jurisdiction under 142 because she was deciding, my lord, of a 25 petition. That's it. That's the only, my lord, sum and substance. Kindly have a look at.
So the moot question was not that whether it's under 141 or 142. That is your interpretation.
Kindly have a look at this judgment, which was in a way relied by me, but distinguished by my learned senior friend. Kindly have a look at 2018-17 SCC.
Yes.
Kindly turns to paragraph 21.
21.
Yes. And sees the first part of 21. Mr. Mitra read below the last part.
Yes.
Sees the first part of 21. Further, my lord's Caligari.
Yes.
Should just wait for justice.
Yes.
Further, during the I'm sorry.
18-17.
Is paragraph 21. Further, during the course of hearing, various documents such as PAN card, Aadhaar card of the respondent wife, lease deed, which was executed by her in 2015, etc., which are also placed on record, are sufficient to show that respondent wife is ordinarily living in India. Further, as it appears from the proceedings recorded from the US court, that the respondent herself has admitted that the family court Gurugram has jurisdiction in the given case. The evidence placed on record is sufficient enough to show that the respondent is amenable to the personal jurisdiction of Gurugram family court. Though the respondent wife is amenable to the jurisdiction of the family court Gurugram, there is nothing on record to hold that the other party will suffer grave injustice if the injunction is not granted. What's the injunction? Anti-suit. There is no dispute to the fact that both the parties are permanent citizens of the US. Without a permanent citizen of US, that is why probably SIR has come in. It should be permanent resident. Undisputedly, the Circuit Court Florida US is also having the concurrent jurisdiction in the given case. I am on this. The contention, I mean, it's permanent citizen.
There's a concept called permanent citizen there.
Yes, there is. The contention that the appellant husband will suffer grave injustice if the proceedings are allowed to be continued in Circuit Court, Florida, does not stand to the ground, as the appellant himself has been residing there after 2007, and the proceedings for grant of anti-suit injunction were initiated by him in India, though through another person, by empowering him through a power of attorney to file and pursue a disputed litigation on this behalf. Further, there is nothing brought on record to show how the appellant husband would suffer grave injustice if the injunction restraining the respondent wife from pursuing the divorce petition in Florida is not granted, and then sets aside the grant of will or injunction. So here, they need to first show what is the injustice that you're talking about. Lord, I'll just sum up with two things. Anti-suit is only when there's oppression. When there is oppression, when there is lack of inherent jurisdiction, and below there is another part. Not maintainable. His basic submission involves on oppression. On oppression. Why oppressive? Because I have to travel to England. He is saying that he is whatever he is, and those are all he has a place to stay in England. He travels to England regularly. He has given the dates of his travel, through and forth India.
So close arguments, Mr.
Your Lordship, kindly gives me 45 seconds. Only 45 seconds.
No, reply to reply, on and on.
My Lord, only one thing, my Lord, false submissions have been made, my Lord. I must only indicate one thing, my Lord.
Don't say that.
My Lord, the two flats, my Lord.
Rephrase your language.
My Lord, I apologize, my Lord.
Yes.
Possibly, my Lord, incorrect, my Lord, because the two flats, my Lord, that has been referred to, my Lord, are held by independent entities, my Lord, that are not related
We're
to
not
either
going
the
into
company.
that question at all.
My
We're
Lord,
going
that's
by
one
the
thing.
averments of the parties.
And my Lord, insofar as the judgment of the Supreme Court is concerned, my Lord, well, cruelty was gone into. Kindly, my Lord, takes a note of para 2. Why the Supreme Court went into the issue of cruelty, my Lord?
In Justice Nagarathan's judgment.
No, my Lord, in Justice Dhulia's judgment.
Living separately.
Order a copy.
May be granted, my Lord.
Name of the judge.
We granted.
There.
At the inception, so that we don't forget and we don't.
My Lord, before your Lordship rises, may I address my Lord Justice Bhattacharya?
Yes.
My Lord, today morning, my Lord sitting with Justice Uday Kumar
Yes.
for civil imprisonment subject to deposit of the subsistence allowance.
Yes.
My Lord, Section 58.
That is by default it comes. Yes.
That is by default it comes. My Lord, if it is not deposited, my Lord, he can be released. My Lord, that is what is my understanding of Section 57 and 58 of the civil.
No, he is in contempt of the court.
Yes.
So therefore, it's between the court and him. But it's
now, my Lord, the sheriff's office is saying, my Lord, unless the sum of is 10,200 and all these, and plus some.
There is a calculation. There is some calculation.
There is some calculation under the
payment for his subsistence. The person who will
may I only pray, my Lord, the petitioner is not in a position to maintain herself even today. My Lord, that part can be exempted by your Lordship.
Let it come up as to be mentioned. Apne ekta report kore to be mentioned.
Let it come.
We'll consider whether that can by the legal services authority.
My Lord, that is the only thing.
The legal service authority. As to be mentioned, please be there. As soon as possible, that that bench will sit again on 16th.
That is the whole problem, my Lord. And he is being detained, I understand, in the sheriff's office.
Yes, but you have passed a specific direction.
My Lord has to, my Lord.
You cannot solely.
It's a very difficult situation. We are in a very. My Lord, he has been kept in the sheriff's office, I am told.
Yes, but our order has to be complied with by them. Subject to subsistence allowance. Subsequently, if you don't put in the subsistence allowance, then.
My Lord, in that case, your Lordship can even, my Lord, extend the period, my Lord, that it can be paid.
You cannot do anything without Justice Kumar.
That is the thing.
And that bench is not sitting before 16th.
So may I give notice?
Hearing is concluded. The matter. Now, In view of questions of both fact and law having been raised, comma, the appeal is admitted to be heard on the grounds taken in the memorandum, full stop. Since the appeal is on a short ambit, comma, the hearing of the appeal itself is taken up. Full stop. Heard learned counsel for both sides. Full stop. Hearing is concluded and the matter is reserved for judge. The appeal is reserved for judge. If the application is connected, along with the connected application.
Lord, if that means it's on 16th, Lord, may I give the notice?
Because you cannot flout the order of a court.
My lord.
Imprisonment যেটা এক বছর দিচ্ছে ওটা থাকবে।